All rise. The court is for County, Washington, the Michigan Sound session. All those having business before the court draws in. The Honorable Judge Simpsons.
You may be seated. Court does call the case of the people versus Lori Anderson.
National for the people. Good morning.
Good morning.
I'm Hugo J. McIntyre on behalf of Ms. Anderson, who is in the courtroom this morning.
All right, very good. Thank you.
And the defendant ready to proceed, Your Honor.
All right.
Proceed.
We're ready as well.
All right, very good.
Your Honor, I only have one witness. I understand defense may have more than one witness, and I would like sequestration.
All right.
No objection, Your Honor.
All right. Witnesses are hereby ordered sequestered. They must remain in the hallway. They are not to discuss their testimony until this matter has concluded.
Nor watch on YouTube, Your Honor.
Or watch on you.
Thank you, Your Honor.
Yes, Your Honor, there is one of the matter I want to bring to the court's attention. One of the witnesses that we had subpoenaed today was Officer Olivia Boatwright from the Pittsfield Township Police Department.
Yes.
Subpoena was sent to her on June the 7th.
Okay.
And I've been in contact with her command officer, and she is on vacation. So I'm not quite, we emailed it in, we sent it to the police department. So I'm not quite sure what happened, but I don't know Officer Boatwright, but I hear she's very reliable and trustworthy. So something has happened.
But she's on vacation at this time?
Yes,
You're informed she is.
yes. But she is not an officer that was directly involved in reporting this situation. She's an officer that my client spoke to later on relative to the situation. I would develop that once the trial starts. So she is not, I don't want to say not relevant, but not relevant.
Okay. So you don't know whether, I mean, obviously you subpoenaed her. Is her
Yes.
testimony then crucial to your defense of this case? Or
It is tangential, Your Honor. It is tangential.
okay. So I guess when we get to that, we'll deal with it.
All right,
I guess it's probably the best way I can. All right, let you make an assessment as to whether or not you would need her testimony or want it. Ms. Lundy.
And that is what Mr. Mack and I discussed as well. I let him know that I didn't anticipate that I'd have much for Officer Boatwright, if anything. So it would really be his witness. And if he felt he needed her to do the trial, that I was flexible with that. I understood that he may need her.
Okay. All right. Thank you. Have the witnesses been adequately sequestered?
Yes, sir. My sole witness is still in the courtroom
Okay.
with his support person.
Got it. Okay. Then you may proceed.
Thank you, Your Honor. With defense's consent, I will waive opening.
Any objection, Mr. Mack?
No objection, Your Honor.
All right. Would you like to give an opening now, or would you like to reserve or waive your opening?
Your Honor, I would like to reserve our opening.
All right. Very good. Thank you. You may call your first witness.
Marcos Lascanos.
Please come forward and be sworn.
Please sit down. Raise your right hand. Swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Go ahead, have a seat, and then state and spell your name.
It's Marcos Lascano, Marcos, last name Lascano, Lascano.
All right. You may inquire.
Sir, are you familiar with the address of 4259 Shandy Court?
There.
Sorry?
Yes, sorry. I just didn't live there long, so it's hard to remember.
That's a place you lived? Is that a yes?
Yes. Sir.
So we're making an audio recording of all of our proceedings today. And when we have the mms and the things, they don't show up great on the recording. So if I ask you for clarification, please don't be offended. It's just for the record. That 4259 Shandy Court, what township is that in?
Ypsilanti?
That's in Ypsilanti. Do you know if it's in Pittsfield Township, Ann Arbor Township? Do you recall?
No.
Do you know that it's in Washtenaw County?
Yeah.
Okay. And do you know it's in the state of Michigan?
Yes.
Your Honor, I ask the court to take judicial notice that 4529 Shandy Court, Ypsilanti 48197 is in Pittsfield Township.
Without objection.
No objection.
Take judicial notice that that is located in Pittsfield Township.
Thank you, Your Honor. You said you lived at that address, sir?
Yes.
When did you live there?
For about 2 months, November and December, I believe.
What year?
2024.
Did you live there with anyone else?
I lived there with a few other people. I remember. I lived there with Lori Anderson. I lived there with another roommate named Paul. And then I lived there with another roommate. Forgetting his name as well. And then I lived there with another roommate. That was only a week. It was just a lot of people checking in and out of his house.
You mentioned the name Lori Anderson. Who was that?
That is was my
Your tenant?
Yes, the person who owned the house that I stayed at, and I rented a room at the house.
So the person that owned the property where you were living, you called that person a tenant. Have you ever heard that person called a landlord before?
Yeah, sorry. Then,
Do you see the person you know to be Lori Anderson in the courtroom today?
yes.
Can you please identify her by an article of clothing that she's wearing and where she's sitting?
Looks like
And where is she sitting?
she's sitting next to where wearing the blue suit coat.
Your Honor, may the record reflect the witness identify the defendant?
Without objection, record shall so reflect.
Do you recall having contact with Miss Anderson on November the 16th, 2024 at that address on Shandy in Pittsfield Township?
Yeah.
How did you first have contact with her on that day at that address?
We didn't really talk much. It was mostly just brief and curt, like saying hi, hello, not much. So I don't remember much from that day. If we did communicate first throughout the day, it must have been that. But the first solid interaction I remember throughout the day must have been through that text that I sent. The text to everyone who lived in the house, which included her, which was just me saying that I needed to get my laundry done.
And did she live there?
No.
Would she stay there?
She spent multiple days there, spending the nights there.
How do you know she would spend the nights there?
Because she keep her car there, and she would sleep there in the spare room with her dog, and her dog would bark a lot, so that was also part of it.
This property, can you describe kind of how it is set up, what it is? Is it like an apartment building or something else?
Regular type home. You have probably 1, 2, 3, 4 bedrooms upstairs. One of them was the office, but she's mostly not really much of what it looked like on the inside. Maybe it was a couch. Sleep on better. The son's room, my room, maybe it was my roommate's room, hall. Then it also had the laundry room and a bathroom. And downstairs was the kitchen and a basement, which Lori had eventually converted into another bedroom. Well, another room.
You have permission to approach the witness with what's been marked as People's Proposed Exhibit 1?
No objection.
All right, yes.
I've shown it to defense counsel. Sir, I placed in front of you what's been marked People's Proposed Exhibit 1. What do you recognize that to be?
Looks like the second lease that we signed.
And is this the one that was applicable at the time of this incident, November the 16th, 2024?
Yeah.
Have you had a chance to review that earlier this morning? Said a yes?
Yes, sorry.
Is this a fair and accurate copy of your lease?
Yes.
Move for the admission of one.
Any objection or voir dire?
No objection, Your Honor.
All right, exhibit 1 is admitted.
Permission to publish to the court.
Yes.
Can you go ahead and pass that up to Judge Simpson? He's going to take a look at that.
Thank you, sir.
So on November 16, 2024, after you had texted the group chat about needing to get your laundry done, did you ever see Miss Anderson?
No, all I kept hearing was the laundry machine going off.
Okay, so what laundry machines were there in this house that you recall?
There was 2 laundry machines. It was the washer and the dryer in the laundry room.
What time do you remember doing your laundry?
I must have tried starting around 9 o'clock, 10 o'clock.
9 or 10 o'clock at night? All right.
Yeah, I wasn't able to do my laundry throughout the whole day because the son had kept his laundry in the laundry machine all day.
When you say the son, whose son is that?
Lori's son.
Now, as you heard your laundry machines going off, what did you do?
I was hanging out in my bed waiting because I needed to do my laundry for work tomorrow. I kept hearing them go off. It wasn't like immediate, like, oh, stop. It was like, oh, they're not going on anymore. So I get up, go back, turn them back on, and then I'd go text and I'd say, can I probably go back to my text, look at them boys. It was, hey, I need to do my laundry for work tomorrow. There's laundry stuck in here all day. It needs to get done.
Were the laundry facilities shared from everybody in the house?
Yeah.
When you went back in to check on your laundry, did you ever see anyone else in that room?
No, it seems like whoever was turning out, whether it was their son or Lori, it seems they kept doing it as soon as I left. I was out of turning it back on.
At some time later that evening, did you ever see anyone else in that room?
It was only after maybe the third or second time that I had turned it back on. I eventually just stayed in that room because I felt like I had to guard my laundry.
What happened next?
What happened after that was eventually Lori had come in and saying that it was too loud and we don't do laundry after the time. And that it was time, we're not doing this anymore. She turned it off and things just started escalating from there. I tried explaining that laundry stuck in the machine all day and that I had to do my laundry for work tomorrow.
At any time, did she ever start handling your clothes?
Yes.
What happened?
That's when I brought out my phone and started recording. That's when I started telling her, this is my property, these are my clothes, you're not allowed to be touching my stuff.
What happened after you started recording?
She just kept going, didn't matter. She just started just doing what she was doing. She didn't care about anything. she said I started to get out of her house, that I'm done, that it doesn't matter. And then just things started escalating. She started grabbing stuff. And then she wanted to get everything, started turning off the light on.
Okay, let's slow down.
Sorry.
It's okay. Let's just slow down, take it one question at a time. So when you said you started recording, is that right? Is that a yes?
Yes.
Have you had a chance to review one of your recordings this morning?
Yes.
And was it a fair and accurate copy of the recording that you made that day? Okay. Your Honor, I'm gonna move to the admission of Peoples 2, which is video titled IMG, and that's India Mango Golf 4676. This has been disclosed in discovery.
All right, you may go ahead.
Thank you. And as always, Your Honor, I'll work on the sound balance, but it can be rather tricky. I'll see if my display settings are recognizing a second monitor. Yes, they are. I will duplicate, and that will fix it, I think.
You know, that's my property. You can't touch my property. It's my stuff. Can you please not touch me? Can you please stop touching me? Can you please stop touching me? No, I made it here. What the hell? No, you can't do that. How can you do that? Oh, no. Have you sent me any notice? No, you can't do that. No, you can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop. You're grabbing my hand now. Okay. She's not grabbing me. Look, I'm gonna keep this light on.
Mr. Lascano, what happened after the end of People's Exhibit 2, that video? Maybe, may I rephrase, Your Honor? Excuse me.
Yes.
Mr. Lascano, what happened as that video was ending?
Her son started getting involved.
And did anyone touch you? Who is that a yes?
Yes, sorry. I know two people entered the room, and I know that it's dark. I know my phone was taken away from me. That's why I stopped recording, and I know I got pushed up against the wall.
And who was the person that pushed you up against the wall? You don't know?
I know that as soon as I started feeling pressure, the lights were up, and I felt myself push against the wall. That's when I said, I had a pepper spray in my pocket. You don't back off with me. I'm going to defend myself. It felt like it was one person. I don't know. That's when the son stepped in as well. But yeah, that's.
Mr. Lascano, did you consent to Miss Anderson grabbing your fingers on the light switch and touching you in that way?
No.
Did you give her permission to do that? At any time during this evening, did you grab her breast?
No.
Did you at any time grab anywhere else on her body?
No.
What happened after this all happened in the laundry room?
After I told them I had pepper spray, whoever was pushing me against the wall backed off. And the son threatened to then kick my ass if I did anything. And then that's when I called my roommate Paul for help.
Did Paul contact the police? Or did you? Okay. May I have a moment, Your Honor?
Okay.
It's okay.
I think I might have been no because I believe he didn't want to get that one involved. He was too scared by that.
Give me just 1 second, sir.
I'm sorry. He said something about he was too, I didn't hear was
Scared?
I object to that being admitted, Your Honor, as characterization as to what somebody else was feeling. Or matter of fact, where is Paul? Paul can testify for himself. Is he here?
Well, I understand that. I don't know that that has much bearing for the court. I mean, the question was who called 911. So I'll overrule your objection, but I can't see it having any consideration for the court.
I understand.
Pass the witness.
All right, cross-examination.
Your Honor, I confess to not being a slave to technology. I ask the court's indulgence.
We are well aware, Mr.
Well, thank you, Judge.
We will do what we can to assist you through that part.
Okay.
You're gonna play something.
Yes, actually.
Okay. All right. I was gonna say you broke it, just to scare him.
Your Honor, before you came in, this was working just fine.
Before I came in, you're gonna blame me? Okay.
Your staff was so helpful. Well, Your Honor,
Did you need some assistance? It's okay. Did you need some assistance? I don't
she was
know.
so helpful. It was working just fine before.
It looks like, yep, you're connected
Yeah.
to the internet.
Yeah, but why isn't it coming up?
Click here for pay network access.
Why is it coming up? Amazing. Okay, amazing. I'm sorry, what happened?
Oh, okay, so. No, you should be able to go back to your email, I believe.
The court closes on?
And now refresh your application.
Click on it, right?
Yep. And then once you plug into here, you should be good.
Oh, yeah, I'm plugged in.
See, this is why I count on my public service rep. No, seriously.
It's okay. I charge for her service. We'll send you the bill, Mr.
Okay.
Are you going to be seeking the admission of this, or is this the same video?
Judge, this is the this is the same video. Oh, excuse me. I'm sorry. That's another case. Sorry. Apologize. This is the same video, and I apologize.
No, it's okay. It's okay.
I don't understand how.
I just want to make. It's the same video as Exhibit 2.
It is.
All right.
It is.
No, you're touching my clothes now. That's not okay. You can't touch my property. You're not allowed to touch my property.
It's playing, but it's not on the screen.
Oh, there you go. Okay. Now we got it.
You can't touch my dog. Please don't stop it.
So I'm going to stop the video right there. Is that your voice on the video? And isn't it true that that is your phone that you're making the video with? Is that true? Now, the state had previously admitted People's Exhibit 1. We have the exact same lease. I can ask for it to be marked, Your Honor, if it's necessary.
Is it the exact same?
Exact
You're going to question him on this?
Yes.
Okay, I'll just hand that back to
So
you, sir.
I don't know if the necessity of me admitting this, unless the court feels I need to. It's the same exhibit.
Same, no, that's fine. If you can question him on Exhibit 1 then.
Okay. Now, that is your signature at the bottom, correct, sir?
Yes.
Now, and look, in terms of house rules, doesn't it say must maintain quiet hours after 9 p.m.? And when you say that some laundry was in the laundry room 9 or 10, you didn't call the police till well after 12 midnight the next day, sir.
Objection, Mr. Horn?
Yes. Is that a question?
Well, isn't it true you didn't call the police till well after midnight?
Exact time I called. I don't know what time this called.
Well, do you remember talking to the police outside on the front porch that morning, sir? Okay. So is it your statement to this court that you don't know if it was well after midnight when you called the police?
The police were probably called just late tonight.
Okay, I'm not talking about late in the night, I'm talking about after midnight.
Yes, they were called late. So I guess it was called after 9 p.m. quiet hours.
Okay, so when you tell the judge that 9 or 10, some vague time reference there, clothes were in there, this incident didn't happen at 9 or 10. This incident happened after midnight.
Check the police logs and check when the police were called just after that time.
Okay. So now, isn't it true that where the laundry room is, which is where this video was taken, correct? Okay.
Yes.
The answer, yes.
Sorry.
Isn't it true there are at least 4 rooms right on that same floor where this laundry room is?
Yes.
There's your room. Yes. There was a room where the defendant was staying at, correct? Okay. There was a room where John was staying at, correct? And there's a room where Paul was staying at, correct?
Yeah.
Okay. And isn't it true that that laundry room there is within no more than 15 feet of any one of those rooms?
Yeah.
Okay. So they're right on the same floor in close proximity to each other, correct?
Yeah.
And there is in fact a door on that laundry room, correct?
Yeah.
All right. So now, when you were in that laundry room, do you remember telling the police you could have gone to an all-night laundry, but you were fearful of doing so because they go through your stuff when you leave?
I remember telling the police that.
Right.
Yeah.
Okay. So you knew you had an option, didn't you, sir? You knew you had an option to go to an all-night laundry instead of being in that laundry room after midnight. You knew that, didn't you?
I don't see how this pertains.
Oh, okay. Well, we have very competent prosecuting attorneys that can make those objections, but your job is to answer my questions. Got it?
Yes, but
Okay, no, sir. I asked you a yes or no question with a yes or no answer. You knew you had an option rather than sir. You had an option.
No.
You could. Can I finish my question?
Sure, I can answer.
You had an. Can I finish my question?
Did he answer the question? He asked if I had an option. I said no.
Sir,
I don't have a-
sir.
Yes.
Yes.
Okay.
You will wait for Mr. Mack to finish his question and then answer.
Okay.
Go ahead, Mr. Mack.
You knew, as reflected by what you just stated that you mentioned to the police, that you could have gone to an all-night laundry, but chose not to because, according to you, when you leave, they go through your stuff. Is that correct?
Yes.
Okay. Now, when you say you put out a group chat, a group chat about laundry,
Yes, it's part of it. We have to protect.
okay, group text. Did you ever present that group text to the prosecutor? Why?
We talked about this group text a lot. Like it's this communication. It's not. Seems like I recorded. I brought it over to every single communication that we brought across. Like, I had to show it to you. It's not something I've been trying to hide.
So this group text. Now, in the group text, was the defendant part of the?
Yes.
Okay, can I finish? Was the defendant part of the group text? Did the defendant give you permission to be in the laundry room after 9 p.m. in the group text?
No.
Okay. The answer to my question is yes or no.
Yes.
She did give you permission?
Permission not. There was no permission not to be there.
Well, you say there was never permission to not be in there either, but there was a lease that said quiet hours after 9 p.m. Okay, correct, sir? Now, in terms of you being in the laundry room, even though you knew you had options, you went to that laundry room armed with mace, did you not?
Yes.
Okay, so you went to a laundry room when you knew you had options, armed with mace, correct?
Yes.
At any point in time, did the defendant ever assault you or threaten you with mace?
No.
So when the video is playing and the clothes are being taken out, the whole nub of this entire situation is she wanted to turn the light switch off for you to be out of a place you had no right to be in the first place. And you want to keep the light switch on. Isn't that just the whole sum of this whole thing?
Object, this is speculation.
I'll sustain that. You'll need to
And
phrase your
compound.
question.
When you were, let's just say, finger tussling with the defendant, what was your goal, sir?
To
When you were finger tussling over a light switch to feel safe?
maintain the vision. Yes.
Okay, so to maintain, so your goal wasn't to keep the light on?
To keep the light on to maintain vision.
Okay. So, but as a means of maintaining the vision, you wanted the light switch kept on, correct? Okay. So, isn't it true that when she had turned the light switch on, you turned it off, you turned it back on? I know you got to say yes.
Yes.
I know it's cumbersome, but you got to say, you got to answer. Correct?
Yes.
And isn't it true that the only contact that you and the defendant had was in the finger dynamic over the light switch?
No, in the video you can see her grab my arm. Pull it away.
Okay, but when you say grab your arm and pull it away, it's relative to the control of the light switch.
It's more than finger testing. She puts her hand on my arm.
Yes.
That's an increased aggression.
Okay. Well, okay. Like I said, that's why we have a judge. He will decide that. So,
You're just cutting your hand. You said fingers.
Sir, he will ask a question and you'll answer. Understood?
Yeah.
All right, go ahead, Mr. Mayor.
So when the defendant moved your hand away from the light switch, you moved your hand back up to the light switch. Isn't that true?
Yeah.
Why did you do that?
Put the light back on.
Why didn't you just simply leave the room?
Her son and her were standing in the doorway, and I wanted to feel safe with my back against the wall with the light on.
Okay, now her son, you say her son were standing in the doorway, right?
In the video, I said, hang on.
Oh, okay, no. You said her son was standing in the doorway, correct?
I'm being very journalistic. I apologize, but her son was standing in the hallway. The hallway leads down like this, and not trying to come.
Well,
Like he's a pretty big dude,
Well,
6
well,
something. He's
okay.
like, yeah, he's imposing.
well, but excuse me, sir. When you are facing going out of the washroom, okay, her son's room is to the left, your room is to the right.
Left, right. And so I have to go past him, and then he's standing right there.
Okay, so
I have to pass by him to get there, and he's standing right there.
Okay.
And these aren't my friends.
okay, so are you telling me, and we're gonna play the rest of this video, are you telling me you couldn't turn right when you got out of that door and go to your room?
I want no obstacles in my way before I went back.
Sir, I'm asking a very simple question. When you're exiting out of the washroom, okay,
Sure.
I'm asking you, isn't it true your room is to the right? You turn right to go to your room.
Not before I see both of their rooms, before both people are standing in the hallway.
Okay, sir, I'm asking you a simple matter of a structure of a house. Is it not true when you go out of the door from the washroom, your room is to the right and the son's room is to the left?
No. I can draw this out for you.
Okay. So what you're saying is you had to pass by John to get to your room, is what you're saying.
It's all the way down the hall.
Okay. So now when you talk about the grabbing of the wrist, okay, after she moved your wrist to stop you from turning the light on again, and you still try to turn the light on, correct? Wasn't there some more like finger dynamic between you and her trying to control the switch?
Yeah, after she left the room, I turned the light off. She came back in the chair.
Okay.
She kept coming back.
Okay. Yes, but she wasn't coming back to your room. She come back to the washroom, which you were wrongfully in the first place.
Wrongfully in?
Yes.
Object is the characterization of wrongfully in the room.
I'll sustain that.
Okay. You were there after 9 p.m., correct?
That's just quiet hours. I can't let me in the house.
Okay, sir, please. You were there after 9. Okay. Yeah. Okay. You were there after 9 p.m. and you were being quiet.
Yeah, in the video, you hear me being quiet.
No. Okay, sir. The washer and dryer weren't on when the video was being recorded, were they?
So it was quiet.
No, but I'm talking about when you're using the washer and dryer.
Close her out. She had taken them out. She didn't have to come back in to turn the light.
Okay. So what you're saying is the washer and dryer were never on at all.
Objection, Your Honor, that mischaracterized.
That's sustained.
Okay. Well, are you saying the washer and dryer were on ever?
What are you saying? I never even said that. I'm saying at this point, when she left the room, the washer and dryer were off. She was
Okay.
taking the clothes out, and she's like, you know what? Now you're out of the room. Now I'm gonna shut the lights out.
Yes. Okay.
She kept coming back in.
Okay. But before that, you were using the washer and dryer, correct?
Yes.
Okay.
Yes, I was never denied that.
Okay. And this was after 9 p.m.
Sure. Yes.
Okay. Now, when you and the defendant were finger maneuvering for control of the light switch, was it ever your intent to harm her? Was it ever your intent to intimidate her? Was it ever your intent to put her in threat of some kind of a physical harm? And you did have contact with her hand, correct?
Yeah.
And you were finger maneuvering against her for control of that switch, correct?
Yeah.
Just one more minute, Your Honor. Just one more. For this witness,
All right.
I would ask that has the lease been marked as an exhibit and admitted, Your Honor?
Exhibit 1 is the
Yeah.
second lease.
Yes.
That's been marked and admitted. And I don't know if there was a formal motion to admit Exhibit 2.
If there wasn't, I intended to, Your Honor, it would be an oversight on my part. I don't think there's any objection from defense counsel, so exhibit 2 should.
Any objection or?
No.
Okay, Exhibit 2 is admitted.
Thank you, Your Honor.
Thank you, Judge. As I said, Your Honor, I have no
Further questions? All right.
further questions.
Any redirect?
No, Your Honor.
All right, very good. Sir, you may step back. Well, I do have one clarification. Sir, the clothes that were taken out of the dryer, which I guess would have been machined to the right, that was a dryer?
Yeah,
Well,
I don't remember if that clothes being taken out or what.
pardon?
I don't remember if you're asking if clothes were wet or not.
Well, I'm asking which machine was that?
Like those were my clothes that she was taking out. of the dress.
Yes, were they dry or were they wet?
I know those are my clothes.
Okay, I get that. The question becomes, where, was that the dryer they were being taken out of or the washer?
I remember they weren't done. So I remember
Sir.
they're still wet. That's what I remember.
Okay. You recall the video, correct?
Yeah,
Okay, in looking at the video, there, if you come in the door, there's a machine that's to the left and a machine to the right. Is that a yes?
yes,
She is taking clothes out of the machine to the right. Is that correct?
yes.
Okay. My question to you is that the washer or is that the dryer?
Just when based off of working with washers and dryers, I assume that would be the dryer, but I don't remember exactly. So I feel like washers are usually put on top.
Well, I don't.
I don't remember, I'm sorry.
Okay. All right. Okay.
Maybe we'll follow up based on the court's questioning.
Any follow-up based upon my,
No, Your Honor.
you may step back.
Your Honor, this witness be excused.
Any objection?
No objection, Your Honor.
All right, this witness is excused.
Mr. Loscano, could you hand that back to the court? Exhibit 1, please. Oh, I'm sorry. I apologize.
All right, you may step down.
The people rest, Your Honor.
All right, very good. For the defense.
Yes. Your Honor, first of all, I'd like to make a motion for a directed verdict in this matter. I would like to make a motion for a directed verdict. This court knows better than anyone else in the courtroom what the Michigan criminal jury instructions are, which obviously apply to a trier of fact, which is, in this case, Your Honor. There's absolutely nothing here to show anything other than people finger tussling under control of a light switch. There is no indication here of the defendant trying to harm or threaten. There's no evidence here that she said, look, if you don't leave this room right away, I'm going to kick your blank, blank, blank. There's no bald fist. There's no punch. There's no kick. There's no I've got mace, contrary to what the alleged victim had. There is simply nothing here other than a landlord-tenant issue that is more suited for a civil matter than a criminal matter, Judge. And so even if looking at in the light most favorable to the state, I just don't see how any kind of intent can be induced from two people in a matter of 15 seconds trying to fiddle over a light switch. So that's my first statement. And depending on what the court says, I'll be making an opening statement.
Response.
Your Honor, I do believe that at this point, viewing all the evidence submitted in light most favorable to the people, a reasonable fact finder could conclude that the initial aggressor in the touching was the defendant. And I'll also further state that the defense counsel said there were no evidence of threats. The threat of you're out on the 22nd could be characterized as a threat. That statement about attempting to tell somebody that they can't leave, to leave their house when they're a tenant, that could be characterized as a threat. I'm not saying it is, but I do believe that there's enough evidence here for us to continue going and let the court be the finder of fact in this matter.
Anything else regarding your motion, sir?
No, Your Honor.
All right. With regard to a motion for a directed verdict in essence, the court does believe that a reasonable fact finder viewing this evidence in light most favorable to the non-moving party, that being the people of the state of Michigan, could conclude that an offense of assault and battery was committed. One thing is that the notion, and it was specifically asked during defense questioning, that the individual, Mr. Toscano, had the right to be where he was. That is clear from the leasing agreement. So he had the right to be where he was. Why, and also specifically, while that may have been the beginning of the assault, there is then the ultimate turning off of the light switch, testimony from Mr. Toscano that he is then put against a wall, certain threats about his residency being said and what was going to happen. He also testified that the defendant's son was in the hallway. So viewing, I'm not saying that would maintain itself, because I'll hear all the testimony, but certainly at this juncture, the court would deny the defendant's motion for a directed verdict. The court does believe that a reasonable fact finder could conclude that an assault and battery did take place.
Yes, Your Honor. Your Honor, this time we'd like to make an opening statement in
Go ahead.
regard. Your Honor, in this case, we believe the evidence has shown and will continue to show that the defendant is a landlord. And at the time, the alleged victim was a tenant in the house. The evidence will show that a lease was entered into by both parties with a specific statement of quiet hours after 9 p.m. We believe the evidence has shown and will show that the washroom is on the same exact floor of 4 rooms where people live, and that the door was open from the video that the court has seen, and that the noise from the washer and dryer is something that is a direct breach of the lease in terms of quiet hours. We believe evidence has shown and will show that this was not an incident that occurred in terms of complaining witness being in the wash area before 9 o'clock. It was after midnight when this entire matter revolved. We believe the evidence has shown and will show that the defendant was simply trying to exert a lawful prerogative of hers as the landlord to have quiet hours, not only for her enjoyment, but for the enjoyment and security of the other residents of the home, whom she had a responsibility to maintain quiet hours. The evidence has shown and will show, and perhaps, excuse me if I've said this earlier, that the complaining witness knew full well that he had an option. And the evidence will show that he chose deliberately not to exercise the appropriate option in going to an all-night laundromat because he knew that it was improper for him to be there at this laundry room at that time. The evidence will show, Your Honor, that there is a motive that the complaining witness has for bringing forth this false allegation, because what is not caught on the quote-unquote videos that the evidence will show has been really tailor-made for a.
Can we just pause for 1 second? I'm asking if Mr. Loscano can step out in case I do need to recall him in rebuttal.
All right, very good.
Thank you.
Okay, Judge, he's heard what I said already, and he was excused already, Judge.
Well, he was excused, but I think during your opening, there may have been something that raised, so
Yes.
he's now been sequestered.
Thank you, Your Honor.
We'll deal with it.
All right. That the evidence, we believe, Your Honor, will show that Mr. Loscano has a motive for bringing forth this false allegation. In his carefully edited videos, there is no video of him touching my client's breasts beforehand. I submit that the evidence will show that that in fact did happen, despite the defendant's, Mr. Loscano's denial. The defendant will testify herself as to the circumstances in the home and what her intent was. So, Your Honor, she will also testify as to contacting the Pittsfield Township Police Department. She will also testify as to mentioning this to a very close friend of hers. So, unfortunately, Officer Olivia Boatwright is not with us, but she was not an officer that was involved in this specific incident, but was someone that the defendant spoke to tangentially afterwards. And in conclusion here, Your Honor, the evidence will show that at no time did the defendant intend any kind of harm, harassment, physical injury, what have you. And the evidence has shown and will show that in terms of any pushing, first of all, the son, John, is not charged with a crime. So, and in terms of some pushing, the evidence has shown that this complaining witness says he doesn't know who pushed him. So how that is proof beyond a reasonable doubt that the defendant pushed him is somewhat stymieing. So, Your Honor, this is what we feel the evidence will show. And at the end of the hearing, Your Honor, we believe there certainly is not enough evidence of proof beyond any reasonable doubt that the defendant is in fact guilty of this matter. And we are ready to call the defendant to the stand at this time.
Ma'am, please come forward and be sworn.
Solemnly swear affirm the testimony you're about to give you the truth, the truth, and nothing but the truth, so help you. Yes. Have a seat and say and spell your name.
Speak up.
My name is Anderson.
All right. Go ahead, Counsel.
All right.
You may inquire.
Ms. Anderson, you are the defendant in this matter, correct?
Yes.
Do you know a person with the last name Mr. Loscano?
Yes.
And have you been sitting in the courtroom while he testified? Is he the individual that you entered into a lease agreement with in approximately August of 2024?
Yes.
The court has gotten its possession the lease agreement, and if the court maybe could let you look at that, I'd appreciate it. Now, do you recognize that lease agreement, Ms. Anderson?
Yes.
And is that your signature at the bottom of it as a landlord?
Yes.
Now, is that Mr. Loscano's signature also as the tenant?
Yes.
Now, referring to House Rules item number 3, could you please read for the court, what does that state?
Must maintain quiet hours after that.
Now, in terms of the layout of this is a home that you were renting rooms in?
Yes.
Okay. Now, would you tell the court, in terms of the laundry room, and you've had an opportunity to see the video, correct? That was played? Okay. In terms of the laundry room, are there any other rooms in the vicinity of that laundry room on the same floor? Could you please tell the judge how that layout is?
My bedroom is across from the laundry room, and my son's bedroom is next to the laundry room. And Marco's room is, okay, then you have a bathroom, and then Marco's bedroom is further down the hall, and then Paul's bedroom is even further down the hall, and then garage is in the basement.
Okay. So in terms of these rooms, how many feet would you say separates a laundry room from these 4 rooms?
For my room, it's 2 feet. For my son's room, it's 0 feet, and it's right next to my son. For Marcos's room, it's probably 10 feet.
I see.
From Paul's room, it's probably 15.
Now, can you please tell the judge relative to the laundry room, what role does the proximity of the laundry room to the other rooms on that floor plays a part in must maintain quiet hours after 9 p.m.?
The laundry machine makes a lot of noise, both the washer and the dryer, and I told Marcos and everyone that the washing machines should be used after 9 o'clock because everyone is going to work, studying for interviews. My son is doing interviews for medicine. I was going to work, people were, the household, the whole idea of 9 o'clock was to maintain quiet.
So what is it on the date and time of this incident that drew your attention to Mr. Lascano in the laundry room?
It seems like it was about midnight, and then I started hearing this. I didn't know.
Okay, ma'am, you've got to talk up.
Yeah.
Maybe it's me.
It was around midnight or after midnight when I heard the laundry machine running, and it woke me up.
Okay, now you heard testimony from Mr. Lascano, I believe earlier, saying that at the time the machine, perhaps I'm wrong, but the machine wasn't running at that time or something?
I don't object as to mischaracterizing or at least a clarification. We've
Well,
got several different timeframes here, some where the machine was running and some where it wasn't. So I don't.
Yeah, why don't we clarify what time frame?
okay, at the midnight hour when okay.
It heard the noise, and it woke me up.
Okay, so was there anybody else in the washroom doing laundry other than Mr. Lascano when you were woke up?
No.
And this wasn't at 9 o'clock. This is this after midnight.
Objection leading.
Sustained.
Now, the rooms that were there, the noise from the machine, was your testimony was loud enough to wake you up?
Yes.
Was anybody else awoken by the machine?
Was anybody else was there?
Awoken by the laundry machine?
I don't know. I woke up.
Okay. Was there a person that was renting by the name of Paul?
Yes.
Okay. To best of your knowledge, was Paul woken up by the machine?
I don't believe so. I don't know. He's 15 feet down, so I didn't see Paul. I don't know if he was woken up or not.
Okay. Okay. So now you've seen the video, and I'd like you to tell the judge, does that video capture everything that happened between you and Mr. Lascano that night? Could you please tell the judge what happened between you and Mr. Lascano before the incident with the light switch and the finger tussling, whatever light switch?
I first turned the machine off and the light off, and I woke up. And I went back to bed, hoping it was the end. And then, maybe 5 minutes later, I heard the machine again, light was on, so I went out of my room. And when I was going into the room, Mr. Lascano grabbed me.
When you say he grabbed you, what part of your body did he grab you on?
He grabbed my clothes.
Would I Kleenex or something, ma'am? I think there's a box, ma'am. I think there's a box of Kleenexes there. Okay. So
Did she need time to compose herself?
do you need a moment, Ms. Anderson? Okay, because you have to compose yourself so the judge can hear you. Okay. So after this incident happened, you say he touched your breast. What did you do? Okay, okay, ma'am, if we need to take a recess, we'll do that. But the judge has got to be able to hear clearly what you're saying.
I was in shock. I froze.
Okay, what happened after that?
I remember reaching over, turning off the light, and hoping he would just leave and go back to his room. And I went back to my room. I thought it was the end. I was processing.
So did there ever come a time when you and he had some kind of a finger contact about the light switch?
Yes. Oh,
Okay, just
Yeah.
that's a yes or no question, yes or no answer. Did there come a time when that happened?
yes.
Okay, could you please tell the judge circumstances what led to that happening?
After several times, he would go in and start the line machine, turn away. It seems like there was a couple of times. I wasn't counting. I would go in and turn, so we back and forth with the light switch. That's what I remember. I don't remember how many times I turned it off and he turned it on. I don't remember how many times that, but it just was constant back and forth. And I was hoping it would just end.
Now, but was there a time when he was finger maneuvering with you for control of the switch?
Yes, he was touching. I mean, I was turning it off and he was turning it on, and it was back and forth with us. And I don't remember how many times, but it seemed like it almost seemed like a game to him. And I was just wanting to go to sleep. Just end it. I didn't want to escalate.
Okay, now when you turn the light switch off, okay, all right? Okay, did his hand come in contact with your hand trying to turn the light switch on?
Yes.
Okay. So I want to be sure that this is clear. He touched, at some point in time, touched your hand trying to turn the light switch on. Did you consent and voluntarily say, please touch my hand to turn the light switch on? Okay. Was that touching of your hand to turn the light switch on, was that against your will?
Yes.
Okay. Was that without your consent?
Yes.
Okay. Now, you heard testimony where the complaining witness said someone pushed him, the light was out and somebody pushed him like maybe into a wall or something. Did you hear that testimony?
Yes.
Okay. At any time, did you push Mr. Lascano into a wall?
No, sir.
Okay.
He's bigger than me.
Okay. Now, in terms of the touching of your breast, at some subsequent point in time, did you have an opportunity to report that to the police?
Yeah.
Okay, ma'am, just yes or no. Okay. Do you remember the name of the police agency that you had reported that to?
Okay.
Okay. Would that be the Pittsfield Township Police?
Yes.
Okay. Did you see Miss Officer Boatwright in person?
Yes, sir.
And did you report this incident to her?
Yes, sir.
Okay. Now, in terms of weaponry, at any time, did you have any mace on you, Miss Anderson?
No, I don't have weapons in my house.
Okay. At any time, did you threaten Mr. Lascano with any kind of a weapon?
No, I don't. I don't believe in weapons.
Okay, ma'am. Okay. At any time, were you threatened by Mr. Lascano with mace?
Yes, sir.
Okay. Could you please tell the judge what happened then?
It's that once my son woke up from the back and forth, came out, then Mr. Lasano, he said, "Hey, I got mace, so back off." You know, it was, he said that, and I'm like,
Okay. But you never had any mace. Okay. Now, after this incident happened with him touching your breast, did you know a person by the name of Ivory Clinton?
"Yes, sir.
And who is Ivory Clinton?
He's my dear friend. I've known him for over 20 years. He's like family.
Okay.
I don't have any parents."
Okay. Did you report this incident in terms of the breast situation with Mr. Clinton?
Yes, I told him.
And I'm sorry, when?
Yes, sir. Yes, sir.
And when did you tell him that?
That morning, or the next morning.
Okay. And isn't it true Mr. Clinton was subpoenaed to be here this morning?
He's outside.
Okay. All right. Ms. Anderson, why did you wait and didn't report this incident with your breast to the police right away?
I didn't trust police. They were strangers. If you knew my backstory, I suffered sexual abuse and racial abuse growing up as a child. My mother threw me away because I was half black.
Okay.
And I had
Okay. So what is it that made you decide to report the matter to the police when you did?
time to process it.
All right.
And I didn't trust white authority because in my childhood, when I reported abuse, no one ever did anything.
Okay, okay, all right. So, Ms. Anderson, in this situation, and this is coming to an end here, ma'am, was it ever your intent to harm or threaten or violate Mr. Lascano in any way? Okay. Tell the judge what was your intent in this entire situation.
I wanted to just have quiet peace in the house and make sure that all the tenants, including myself, were safe. That's what I wanted. I was hoping that he would just stop.
Okay. All right, Ms. Anderson, I have no other questions. Prosecutor may have some questions for you.
Cross-examination.
Thank you, Your Honor. Ms. Anderson, what day did this happen?
It was in November.
November 16th, sound right?
Yeah.
You were sleeping and it was around midnight when you were woken up by the laundry machine? And you said it makes a lot of noise, right? And you said your son was woken up by all the back and forth between you and Mr. Lascanos, right? But Mr. Lascanos and you, when you were in having your back and forth in the laundry room, that was after the machines were shut off, right?
I believe I had shut the machine off and shut it back on. So we were tussling with the light switch. So I believe, I don't recall if it was on.
So you're not sure what woke your son up, right?
I am not 100% sure.
Okay. And your son's room is closer to the laundry room than yours is, correct? And you were living at this house at the time?
Yeah, on again, off again.
On again, off again? And you saw People's Exhibit 1, correct? The video? I'm sorry, People's 2, excuse me. I misspoke. The video we looked at earlier?
Yes.
And you said that the victim was the only person in the laundry room, right?
Yes.
And you said that you turned off the machine and the light, and then the victim grabbed your breast. And-
No, when I walked in, he caught me by surprise, and that's when he grabbed my breast when I first walked in, because that was the second time I had walked in and shut it off when he wasn't there. First time I walked in, he was already in his room, and I shut it off and turned off the light. Then I went back to bed. Thought it was okay. Then about 5 minutes later, I heard the machine again. And so I was gonna just go in and turn it off, turn the light off again. And when I walked in, he grabbed my breast and I froze.
And he grabbed your breast because he was standing at the doorway?
He was in the laundry room.
He was in the laundry room. And then grabbed your breast. And you froze.
I
I'm just asking, you said on direct you froze. I want to make sure I understand.
was just, it seems like all of my childhood stuff started coming out and I just froze.
But you turned off the machine and turned off the light and went back to your room, right?
I don't.
You don't remember? Okay,
I
fair.
you know, I know I shut off the light. I don't remember if I shut off, I don't think I shut off the light machine. I know I shut off the light and went back to my room and I hope, yeah, I was just in shock. I didn't.
And from the first time that you went in and shut off the machines and the lights till when we see the video we looked at today, that all happened within just a few minutes, right?
I mean, yeah, I mean, there was probably 5 minutes. There was he turned the machine on. I turned the machine, he went back to his room. I turned the machine off. I went back to my room. And then the second time when I went back in there, I thought I was just going to shut the machine and light off. And he was there and grabbed it.
And you would agree with me, though, that from the first time that you went in there till the end of the video we watched, that was just a few minutes, right? No, not sure about time. Wasn't counting. So when you went back in again to turn the machine off, that's when you started taking the clothes out in the video?
I think I started taking the clothes out. I mean, he had the video, but yeah, I think I started the third time when he turned it on and I went back in. I think I started taking the clothes out.
Okay. So I'm going to ask you a really, really simple question. Well, the video that we watched, that's the third time that you went in there to shut off the lights and turn off the machines?
These are the third one.
After that video happens after he had grabbed your breast, right?
No, he grabbed my breast in the beginning.
So the video we watched.
Wasn't that any video that happened?
So let me ask the question. I think we're saying the same thing. So just listen really closely. The video we watched today in court happened after he grabbed your breast.
Correct.
Okay. And in fact, you went back and forth into that room more than one time on that video that we watched, right?
I think the video showed the lights going on and off a couple of times.
And before the lights go on and off, it shows you going back and forth for some of the laundry, right?
I think I did at least one
Okay. And you told him that he had to leave your house, didn't you?
time. I said I was, I was gonna give him an eviction notice.
Is that what you said?
Well, that's what I meant.
But what did you say? You said you need to leave my house, right?
Well, I mean, if he doesn't want to abide by the rules of quiet hours after 9, I thought maybe it would be better if he would leave my.
Man, my question's very simple. But didn't you tell him to get out of your house?
I think I may have, yes.
You may have. And didn't you tell him he was going to be out on the 22nd?
I think he had paid, it was a month lease. I think he had paid through the 27th. I think,
No, but focus. Didn't you tell him he was going to be out on the 22nd, maybe 27th? It's hard to hear, but you told him that, right?
I was, whatever date I meant was the date that he had paid through.
So you told him that he had to be out on the 22nd or the 27th, right?
I don't remember the date.
Okay. You would agree with me because it's captured on the video that the first time we see you turn the lights off in that video, Marcos's hand is nowhere near that switch, right?
Yeah, but
And then you would agree with me. She said, yeah.
She answered the question. So go ahead and respond.
And then you would agree that he turns the lights back on, right?
I don't remember every single step. You're asking me to recall everything. I don't remember. I wasn't taking video. I just remember some key points.
You've had a chance to review that video before today? Is that a yes?
Yes.
Sorry, same thing. Like we just have to have the recording.
And the video didn't capture everything. It didn't capture before and it didn't capture after.
Which is the nature of all videos, right?
Yeah, but it didn't capture him, me supposedly pushing him or anything like that. It just stopped.
So ma'am, my question is, do you recall that he turns the light back on after you turn it off?
Yes,
And you turn it off again,
yes.
and he turned it on again?
I'm trying, you're asking, I don't remember everything.
Okay.
You're asking me to say something. I don't remember everything. I remember we were going on and off and on and on. That's all I remember.
And at some point, he had his hand on the light switch holding it on, right?
Yeah, just like I had before that.
And you pulled his fingers away to turn it off?
Yes, but yes. And he had touched me before.
Oh, ma'am, I didn't ask you any questions about that. My question was just about the light switch. Do you recall appearing for court here on February the 5th, 2025?
Yeah,
And do you recall that's the date that this case got set for final settlement conference? Does that sound about right? And is that in fact the day that you went to Pittsfield Township Police Department to talk to Officer Boatwright about your breast being touched? And isn't it true that you told Officer Boatwright that you were discussing the case with your attorney and decided that the updated version of events needed to be reported?
I mentioned it to the lady at the counter and she said, I told her and she said I should go report it.
So on February 2nd of 25 is when you went to Pittsfield and you were able to chat with Officer Olivia Boatwright, correct?
At that point, I had the courage.
What lady at what counter?
And Your Honor, the court asked a question which I was going to ask. I don't understand what is this all about? Who is the lady? Where?
I'm assuming it's about the date that the report, but I'm trying to figure out what lady at what counter.
Here in the court, I was going there asking her why, how I could include some other information, and because no one ever called me, and she told me to go to the Pittsfield Township Police and put the report there. And
It was one of the court clerks that told you that?
Yes, I was telling her that no one called me to I said I had some more information.
Okay, all right.
She told me to go.
You answered my question. Go ahead, Ms. London.
And that was the date that you were able to go to Pittsfield Police Department and make that report?
Yeah, I had.
It's just a yes or no. So that's the day you went, correct? On February 2nd, 2025?
February 2nd or February 5th?
I meant the 5th. I apologize, Your Honor. I misspoke. I read the 2. I meant February the 5th. Didn't you in fact tell the police officers though that that your breast was grabbed when you were removing the clothing from the dryer?
Well, excuse me, Your Honor. She's saying tell the police officers. She spoke to one police officer, Officer Boatwright. Who are these officers?
I don't know.
Well, hold on. At what point are you talking about?
I'll rephrase.
All right.
When you went to Pittsfield Township Police Department on February the 5th and you spoke with Officer Boatwright, isn't it true you told her that this happened while you were removing the clothing from the dryer, this being the touching of your breast.
No,
That's not true. So if that's in a police report or if that's captured on Officer Boatwright's body camera, that's not true.
yeah, I told her I walked in and grabbed my dress.
All right. So if we are able to get Officer Boatwright here or review her body camera and we find out that that was what you told her, that would not be true.
I told her exactly what happened.
So if it's different than what you're saying now, which one's true?
Well, Your Honor, first of all, she's acting
It's
speculative.
cross-examination, Mr. Mack. I'm gonna let the questions go. Go ahead, Ms. Linda.
Please answer the question, ma'am. My question was, if we review Officer Boatwright's body camera, or we have her testify, and she testifies or her body camera indicates that you told her that your breast was grabbed while you were removing the clothing, right? Would that be true?
I did not tell her I was removing it. I told her we were arguing over the laundry machine.
Okay. And if the body camera or the testimony from the officer indicates that you said it happened while you were removing the clothing, that would be different than what you said today, right?
I did not tell her that, so she would be lying.
She would be lying,
Yes.
and her body camera recording would be lying if it captures you saying that.
I did not say you're putting words in my mouth.
I'm just asking a question. If those two things happen to be okay.
Ma'am, are you gonna answer the question, please?
I told her,
So if Officer Boatwright says something different, she's lying.
yes.
And
All right. Well, not really, but okay, we have the answer.
and if the body camera captures you saying that it happened while the clothes are being removed from the dryer,
No, why are you, I didn't say that.
All right.
may I have a moment, Your Honor?
Yeah.
Nothing further, Your Honor.
Ma'am, what were the hours that constituted the quiet hours?
9 p.m.,
Until when?
9 a.m.,
The agreement doesn't say that though, is that
Well-
right?
waking hours.
Well, ma'am, the agreement doesn't say that, correct?
Correct.
All right. Um, because I'm a bit confused about the whole arrangement and disagreement, but is this property registered for rental with Pittsfield Township?
At the time, it wasn't because I was owner occupant, and I was told when you're an owner occupant,
Okay, so that's a no?
no.
All right.
Because I even asked,
Why was it important to you that the light switch be turned off?
because I was hoping that we would stop doing the laundry, light switch off and the laundry machine off. So when I went in there, I turned the laundry machine off and turned the light switch off.
Okay, but when you went back in, you also turned the light switch off, right?
I mean, I'm paying utilities, so I,
Well, no, you're not. According to, look at your lease agreement. Doesn't his rent include utilities?
yes.
So he's paying utilities.
Yeah, but part of the rules that I put on the refrigerator is everyone should try to conserve energy and keeping them
Ma'am,
off
why were you turning off the light?
because it was midnight. And I thought it should be shut off and everyone should be asleep.
But that agreement doesn't say that though, does it?
I thought it was assumed at 9 p.m. quiet hours. That's what I explained to him when he signed the lease that it was to be quiet hours. After 9 p.m.
Ma'am, would he be violating the quiet hours if he had gone into that room, did no laundry, but just stood there with the light on?
No,
So what was the purpose in turning the light off?
just that have him maybe go to just stop doing the laundry.
Okay. So at some point, and you saw the video, you're removing his clothing from the machine, correct?
Yes,
Was that from the dryer?
I believe it was from the washer.
So the clothes were wet?
Yes.
Where did you take those clothes? And when you took them to his room, what did you do with them?
I think it was a laundry basket or something, or maybe I put him on the floor in his room.
Pardon?
I think I put him in his room. I think I recall putting him on the floor in his room, or maybe there's a laundry basket right there by the door.
So you recall the clothes being wet and you put them on the floor.
Yeah, or in a laundry basket. I can't recall if it was a floor or the laundry basket.
Okay. When you walk into that room, is the dryer to the left or to the right of the machines?
Oh, you know what? Not just saying that. I actually pulled them out of the dryer because
Is the dryer to the left or to the right when you walk in the room?
when we walk in, the dryer's to the right. So I was pulling out of the dryer, washers to the left.
Okay,
So they were in the dryer and not quite dry.
all right. So what was your purpose in removing the clothing from the dryer?
I have them, observe quiet hours and just not do laundry at night.
Okay, so let me ask you this. Once you had accomplished that, had you not then at that point restored, I guess, this quiet hours?
I kept this whole situation when the laundry was, I took the laundry out. Quiet hours were restored, but then when you would go back, if I went back in, it was because the lights, the laundry machine, the washer was being used. I don't recall exact details, but it was just either one machine or the other was being used. I don't recall, but I just wanted to go to bed and have it cleaned. And
So are you claiming they were clothes in the washer now?
I think there were.
Then why didn't you remove those clothes?
I don't know. I just was trying to get him to stop using the laundry. I wasn't taking notes. I wasn't.
I'm not asking if you're taking notes. I'm saying, why didn't you? You're now saying that there were clothes in the washer.
There were clothes in the washer and the dryer.
So if it were trying to get him to stop, why did you only remove the clothes from the dryer?
The washing machine was, I believe it was off, and I was just trying to get him to stop. I wasn't thinking, oh, remove him from the washer and the dryer.
Ma'am, I'm trying to figure out why you did what you did.
I was just trying to get him to stop, sir. I was just trying to.
And in doing that, I'm also trying to figure out why you removed the clothing from the dryer.
Just trying to get him to stop, sir.
Okay. So once though you had removed the clothing from the dryer, put them in his room, either in a basket or on the floor. At that point, there was no longer noise coming from that room, correct? And when you came back into the room after you removed the items from on top of the dryer and went down the hallway, you came back into the room, right?
I think I tried to turn the light off.
Okay, but if you had turned the washer on, why would you turn the light off?
I thought it was time for everyone to go to bed. I just wanted that. Normally what I would do is turn the washer off.
Did you turn the washer off?
I believe, I don't want to misstate things, but I believe both the washer and dryer were on at some point, and I don't know what order I turned them off.
Ma'am, at some point when you removed his clothing, did you want to see the video? I'm not trying to trick you. I'm just trying to yes, can we put
Yes, sir.
put exhibit back up?
I think so.
Could we play the whole video? That'd be a little bit.
I don't want to.
I don't care if we play the whole video. That's fine. We can play the whole video.
It's only about 2 minutes long. Judge, I interrupt. Can I just have a bathroom break just for a moment? Whenever it's appropriate.
Okay, yes, just momentarily. I don't have many questions, but I'm just trying to figure something out here.
You're touching it close enough. That's not okay. You can't touch my property. You're not allowed to touch my property. No. You can't touch my property. No, thanks. You can't touch my property. Please tell me something. All the time you're gone.
Those are my towels, the last set of towels.
Okay.
Can you please not touch me? Can you please stop touching me?
Hear that, the
Can you please
water
stop touching me? No, I mean, live here. What the hell? No, you can't do that. How can you do that? But have you sent me an eviction notice?
You're out on the funds.
No, you can't do that. You know you can't do that. You have no legal right to do that. If you want to try doing that, let's go to court. Please stop touching me. Please stop. You're grabbing my hand. Okay. She's not grabbing me. Look, I'm gonna keep this light off. Okay.
Okay, man, you've seen that, just saw the video. After you just now, not through a question, but you said the items that were on the top were your items.
Yeah. Did you hear the little bell?
Okay, ma'am, yes, I heard a little bell that told me that was the dryer. So, when you took the items that you now say are yours off and are leaving the room, at that point, the washer's not running, is it?
No, but I thought I heard the bell.
Well, ma'am,
Yeah.
the washer's not running, right? And at the point at which the dryer door shuts, and that's when you hear the little bells,
Right.
and you grab the stuff ultimately off the top, the dryer's not running either, is it?
Right.
Okay, so at that point, safely we can assume there's no noise coming from either of those machines.
Right.
When you walk out of the room, then what is your purpose in turning out the light?
I was just thinking that if I turned on the light, he would leave the room and go back to his bed. And not use the washer the dryer.
But to be clear, the turning off of the light had nothing to do with the quiet out. Is that correct?
Well, in my opinion, it did. But,
Why?
I mean, I don't even, I just thought the lights out, you know, it's quiet hours. In fact, the light from the living room actually shows through my door.
Yeah, but that's not a violation of anything, is it?
I can't personally sleep with light. I have to have darkness. So, I mean, maybe it's not a violation, but I was just hoping to stop him from doing one.
All right.
And
Okay. I think it might be a good point to take a recess, and then you can put it back up, and then you can re-question. Court's going to stay in recess. Good.
yes.
All right. Court does recall the case of the People versus Lori Anderson.
Pass along to the people.
Your Honor, Hugo J. McIntyre with on behalf of Ms. Anderson, who is in the courtroom today.
All right.
Your Honor, it is my understanding the defendant has decided to plead to assault and battery, and in exchange will receive consideration and a prosecutor's deferred sentence with 12 months of probation.
Got a correct statement?
Yes, Your Honor, we have proffered an advisory rights form signed duly to the court, Your Honor.
All right. Ms. Anderson, could you step to the podium? She had been sworn as a witness, but could I have her sworn?
You were swearing.
solemnly swear affirm the testimony you're about to give be the truth, the whole truth, and nothing.
Yes.
Go ahead and state and spell your name again.
Lori Anderson.
All right. And Ms. Anderson, just so that we're clear, we were in the middle of a bench trial in this case. The court had not made its finding. You've had an opportunity to speak with your attorney, and you wish to now plead guilty to this charge.
Yes.
All right. The offense of assault and/or assault and battery is a misdemeanor, punishable by up to 93 days in jail and a $500 fine plus court cost. There is a sentence agreement that the parties have, which the court, after probation, the court would, however, indicate that I don't see a reason why I'm not making an agreement, but I don't see a reason why this court would not follow that. Okay. given what I've heard in this case. You understand that, Ms. Anderson?
Yes.
And understanding the maximum penalties on this, how do you wish to plead to this case?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today, is that correct?
Yes.
Any question regarding any of those rights?
No.
Look at paragraph 5. You'll see a copy on the podium there and it's highlighted. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily,
Yes.
of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes.
Just get the date right. I think it was November 16th, 2024, at the location of, it's not on that one, of Chandy Court, Pittsfield Township, Washtenaw County, State of Michigan. On that date, there was, I'm going to just ask you to acknowledge this, there was a dispute regarding the use of a laundry room. Is that correct, ma'am?
Yes, sir.
And during the course of that dispute, there was then an issue regarding the turning off of the light, correct?
Yes, sir.
Between you and the other individual. And at some point during the turning on and off of the light, there were no longer just fingers coming into contact with each other. At some point, you grabbed the hand and or arm of the other individual. Is that correct?
Yes, sir.
All right. And when you did that intentionally.
Yes, sir.
And Ms. Anderson, you would agree that given all of the circumstances at that time, that the grabbing of that would reasonably or potentially place somebody in fear. If they had some fear at that point, you would agree that that fear of some harm would be reasonable.
Yes, sir.
All right. Counsel, have I complied with the court ruling? Would it be proper to, well, I won't ask you that. Miss, I do also have to advise you before I get to that, Miss Anderson, that if you commit misconduct as defined by the Michigan court rules from the date I accept your plea to the time of sentencing, that any sentence evaluation or agreement, this court would no longer be bound by. You understand that?
Yes, sir.
You also understand that you would not then also be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Defense not aware of any, Judge.
All right. And now, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Judge.
The court will accept the defendant's plea of guilty to this charge. Today is the what?
14.
I've been in the room with Hugo Mack. It seems like the 20th. No, I'm sorry.
Oh, no, Judge.
I just thought I'd throw that out
Oh,
there.
of course, why not?
All right. Court having accepted defendant's plea, defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
August 13th, 2025 at 9 a.m.
August 13th, 2025, 9 a.m. Bond with its conditions will continue. All right. So, ma'am, I would only suggest that as you exit the building, probation will be on your left-hand side down the hallway. You may want to stop in there and at least start the process. All right. Does that date work for you, mister? I see you looking at it.
Yeah. Your Honor, that date is just fine, sir.
All right. Fantastic.
Thank you,
Thank
Your Honor.
Thank you.
Judge. So we can just go to probation right now?
Yeah, you can go down and they'll probably set an appointment with her
Okay.
down there.
Oh,
All right.
oh.
That's it till what?
All rise, 14th District Court, County of Washington, State of Michigan, sound session. All those having business before the court draw near. The Honorable Day, such as Mr.
You may be seated. There you are, Miss Lundy.
Good morning, Your Honor. Ashley Lundy with people. Here, this is the way we conflict on report the obstacle better. Do not know that any conflict exists, we waive the avoidance of all doubt.
Morning, Your Honor. Public Defender Natalie Hay, on behalf of the defender's office, Your Honor, our conflict exists between our office and this honorable court, but if one were to arise, we would waive such conflict.
And the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Gilbert Perez.
Conrad Silver on behalf of Pittsfield Township.
This is an arraignment.
This is an arraignment. Mr. Perez,
Yes,
can you state your name, please?
my name is Gilbert Perez.
So you are before the court on a misdemeanor citation or complaint that alleges that on or about October 20th, 2018, location of Packard and Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you did operate a motor vehicle while your driver's license was suspended, denied, and or revoked. Do you understand the
Yes.
nature of that charge, sir?
Yes,
That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Your vehicle could be subject to immobilization. You understand that, sir?
yes, I do.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes,
All right. Public defender, please. Sorry, didn't mean to wake you. No.
Good morning, Assistant Public Defender Lauren Perny on behalf of the defendant. We waive further reading, stand mute to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to the charge. He's looking for an adjournment of the pretrial.
Please, Your Honor.
Pretrial in this matter will be adjourned to
August 6, 2025.
August 6, 2025, 9 a.m.
Mr. Perez, are you still gonna be in custody on August 6th?
yes, I am.
And
Okay.
you're in Jackson County?
He's in Oakland.
Open, all right.
So that you know, I have his status as revoked for whatever reason.
Thank you.
I will, so that he gets credit on this, I'll set his bond at $5,000. I'll give a 10% privilege on that if he's going to be in custody. Standard conditions, including no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drugs. All right. Thank you. Thank you, Mr. Perez.
Thank you.
Court does call the cases of the People versus Timothy Haslam. Hold on.
Good morning, Your Honor. Christina Bergderian requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Lundy.
Permission to practice is granted.
Thank you, Your Honor. Christina Bergderian for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haslam. Mr. Haslam, please state your name for the record.
Timothy Haslam.
Thank you. What are we doing?
So, Your Honor, one case is a sentencing.
Which case do you have as a sentence? I have this one. No, I thought that was in warrant status. It might have been, nobody removed the sticker, but
Yeah, I think it was at some point.
all right, I got it.
We did review the pre-sentence report, have no material changes, additions, or deletions. We do ask that you adopt the recommendation.
Mr. Haslam, anything you want to say before I impose sentence?
No.
I will cancel the outstanding bench warrant in this matter, sentence you to $125 statutory fees, $99.99 restitution to Meyer payable through the court. I'll make that due 90 days after release. I'll order 93 days in jail, credit 93 served. All right. That's that one. On the other one.
You're not on the other one. We do have a resolution. However, we do not have a plea form filled out. So I did speak with Ms. Lundy. We were wondering if you wanted to adjourn it out,
What is the resolution? You guys gotta,
to plead guilty to no operator's license on his person. That was all.
fill out the form. I'll take it so we don't have to bring him back.
I just didn't have his permission to sign it. That's why we didn't,
That's count 2,
have it prepared. Correct.
count 3, actually.
Yes.
And then 1 and 2 dismissed. Is that correct?
Yes, Your Honor.
Mr. Haslam, can you raise your right hand, please? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please, sir.
Timothy Haslam.
All right. Mr. Haslam, it is this court's understanding that you are going to be pleading guilty to an added count 3 of no valid operator's license on person. That is a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand that, sir?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt.
Yes.
Okay. You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Probation.
All right. Were you on probation on October 26th of 2024?
Yes.
All right. I do have to then advise you that this could be considered a violation of your probation. If it is considered a violation, that other court could set you to the maximum allowable under that other charge. You understand that, sir?
Yes.
You understand you're giving up, I'm sorry. You also, has anybody promised you anything other than what's been stated here today on the record? My apologies.
No.
Thank you.
Has anybody threatened you or coerced you in any way?
No.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and also because you believe that you're guilty of this offense?
Yes.
I will advise you that if you do commit misconduct as defined by the Michigan court rules between the time of my acceptance of this plea and sentencing, then any sentence evaluation, the court would not be bound by. You could also not withdraw your plea. You understand that, sir?
Yes.
Counsel, are you aware of any promises, threats, or other inducements which have led to this plea that have not been stated on the record?
No, Your Honor.
No.
Sir, on October 26, 2024, at the location of Washington Avenue near Gulfside, were you operating a motor vehicle?
Yes.
Were you stopped by the police?
Yes.
Did they ask you for a driver's license?
Yes.
Were you unable to provide a valid driver's license?
Yes.
All right. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's?
Yes, Your Honor.
Satisfied, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed. Sir, anything you or your counsel want to say before the court imposes sentence?
No.
Your Honor, I would just ask for time served sentence. As the court knows, he's been in Macomb County for almost 2 months, I believe.
Well, okay. I'll give him all of the credit. I don't think that it really matters. I'll sentence him to $125 statutory fees, 90 days in jail, credit 90, sir.
Thank you.
All right, you're all set. Thank you, sir.
You're welcome.
Court does call the case, People versus Ryan Slay.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Slay, who appears via Zoom. Sir, can you please state your name for the record?
Ryan Slud.
Thank you.
Thank you, Your Honor. I have, this case was previously set for final settlement conference, and then, of course, Mr. Slay was taken into federal custody and he failed to appear for that final settlement conference. I was successful in talking to him again, and we are asking to reset this case for a final settlement conference. I will note for the court that he is currently at the Bureau of Prisons in Milan, but he's expecting to begin a transfer this coming Friday. We don't know for ultimately he'll be ending up in Hazleton, West Virginia, but he may be staying in Oklahoma for some time. All that to say, I'm not requesting a date, but I believe a writ for Hazleton, West Virginia for an October final settlement conference date would make sense, because we know for sure he should be there by then.
All right. I'll set jury final settlement conference for October. Say again. October 17th, 2025, 9 a.m. Jury selection if necessary. 20th.
Yes.
October 20th, 2025 at 8:30. Counsel, so that he doesn't have to be transported, because both of those proceedings are in person. If there is a resolution to this matter somehow, let's try to get that done. He doesn't have to be transported out.
Understood, Your Honor.
Bond will continue in this case. Thank you, Mr. Slay.
Thanks, Mr.
Thank
Slay.
you. Thank you.
Court calls the case, People versus William Parker.
Good morning. Tom Pietrowski on behalf of Mr. Parker, who's standing in court to my right.
Sir, your name?
William Parker.
All right, thank you. What are we doing?
We are working our way towards sobriety court. It's just taking a little bit longer than what I anticipated, just asking for a couple more weeks.
Matter August 6, 2025, 9 a.m. Bond continued.
Thank you, sir. Thank you.
Court does call the cases of the People versus T.R. Peterson.
Public Defender Natalie Pate, Judge Peterson, is ending in 0150.
What's, pardon?
Miss Saxon on the other piece.
All right. Miss Saxon, could you put your appearance on, please? Is she frozen?
Yeah, she might be.
Oh, she's gone. Oh, no,
I turned her camera off.
you got it.
Yeah.
Miss Saxon?
Good morning, Your Honor. Tina Saxon for Ms. Peterson on case 241. I was doing.
Got it. Okay, what are we doing?
Oh, sorry.
Good morning, Your Honor.
Good morning, Miss Saxon. Ms. Peterson, can you state your name?
Yes, Howard Peterson.
Thank you. All right.
Good
what are we
morning, Your
doing?
Honor. Tina Saxon on behalf of T.R. Peterson for case number 241.
Okay, for the third time, what are we doing?
Your Honor, in my case, I'm requesting an adjournment for two reasons. I did reach out to the people last week to see if we could possibly work something out as far as the resolution goes. I believe we still need to have a discussion. And then I do need to have a conversation with Ms. Peterson as well. So I'm asking for an adjournment in my case ending in 0150.
And Ms. Saxon, what are you intending on doing on your case?
Your Honor, I'm asking for a final settlement conference date, please.
Okay. All right. So in the case ending in 0150, I'll adjourn that matter to August 6, 2025, 9 a.m. bond on that case will continue. On the other matter, jury final settlement conference will be set for August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person, bond continued. Thank you. Thank you. Court
Thank you,
does
Your
call the
Honor.
case, People versus William Dapkowski.
Good morning, Your Honor. Paul Pavelski on behalf of Mr. Dapkowski. Your Honor, it's date and
Your
time.
name, sir?
William Dapkowski.
All right, go ahead, sir.
Your Honor, date and time for pretrial. Last time we adjourned it for him to be evaluated by sobriety court, for sobriety court, and my client got the evaluation, but then I think the probation officer and the evaluator were both on vacation, so it has been completed. The probation officer gave him a date of August 13th for his evaluation with him. And he said it would probably take a week to get his report done after that. So could we potentially come back August 26th or whatever date?
So you need a date after August 13th.
Plus a week.
Plus a week. Which sobriety court is this?
It's here in this district. I think for Judge Freshour's sobriety court.
All right. I'll adjourn the matter. I need a date after August 20th, please.
September 3rd, 2025 at 9 a.m.
Adjourn this matter September 3rd, 2025, 9 a.m.
Thank you, Judge.
Bond will continue. Thank you. Court does call the case People versus Ricky Ballard.
Hearing for the people.
Yes, good morning, Your Honor. Robin McCoy, P630557, on behalf of Mr. Ricky Ballard. Okay.
Your name, sir?
Ricky Ballard, John.
Thank you. I have before me a plea form that indicates the defendant will be pleading guilty to the charge of operating while visibly impaired, first offense and 93-day offense. On a successful plea to that charge, count one would be dismissed. That's the court's full understanding of the agreement. Yes.
That's correct, Your Honor.
May I have him sworn?
Do you solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Go ahead and put your hand down and state and spell your name.
Ballard Jr.
Has he executed, hang on, sir. Has he executed an advice of rights?
I thought he did. He said he.
I don't have one. I need
Okay, we'll just.
to execute one. I'll pass the matter briefly.
Okay, that's sorry. Sorry about that.
Court calls the case People versus Eric. Is it Casey?
Ready, Your Honor.
Christina Rivera for the people.
Good morning, Rep. J. on behalf of Mr. Casey. Judge, I was just recently appointed. I don't have the discovery yet, and I've been told there are videos, so I'm asking for adjournment, Your Honor.
That objection, August 6, 2025, 9 a.m.
Thanks, Judge.
Bond continued. Thank you. Court calls case People versus Natasha Olmos.
And I'm gonna actually want to put the people, I'm gonna sub it on this one, Your Honor.
David I. Goldstein appearing on behalf of the defendant.
Jeez, oh Pete.
Well,
Because I think I might have made a mistake and I don't want Christina to suffer for my.
She needs to take it.
I thought it was because they needed a senior prosecutor to deal with the senior attorney, but
Ashley's not that old. She's just.
I'll remember that.
Wow, okay.
Your Honor.
Guess all deals are off.
what deals?
Yeah.
Your Honor, I did make an offer to Mr. Goldstein to allow his client to plead to count one, dismiss 2 and 3. I did not reduce that to writing. Does the court need a plea form for that? If they're.
I do.
Okay,
I do need
apologize.
a
I'm
plea
so
form
sorry.
on that. And your name, ma'am?
Natasha.
Okay.
Morning.
Almost.
Yes.
All right. All right. Let me pass it briefly. I'll get you right back up. I'll stick once I have that form.
I apologize. Your Honor.
And she needs to execute an advice of rights because I don't have one. Court does call the case of the People versus Rick Artuso.
The Assistant Public Defender Natalie Pay on behalf of Rick Artuso, and the case is ending in 1656 and 1657.
Morning, Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as to the remaining matter.
Your name, sir?
Rick Artuso?
All right. What are we doing?
Your Honor, there's, the people have indicated there were some potential other charges coming through, and they're trying to kind of, it's a restitution issue, and they're trying to kind of package this up as far as a resolution. There's a pending matter in front of Judge Conlon at Circuit Court as well, Judge. So I was going to suggest an adjournment of the pretrial to try to attempt to resolve it. So.
Okay. So if I understand what you're saying, there's a case that's pending before Judge Conlon that may have restitution issues in that one also?
They're all larceny cases, Judge, so there's
Gotcha.
probably going to be a combination of restitution in each case.
And then there are more charges coming.
Maybe, I was told they're not sure, they might that's part of it, they may package it up in a deal, but it's all kind of pending right now, Judge, I apologize.
Got it. No, okay, I got you. So when will a decision be made as to whether or not those are gonna be charged or just packaged up?
I'm gonna defer to the people, the seasoned Miss Londy over here.
Wow, wow. Holstein and Burgess are in trouble. Go ahead.
The two old white guys are attacking just Londy. Your Honor.
I'm not going there. All right.
Your Honor, we don't have a time frame at this time, but we will update as soon as we do.
Okay, so why don't I do this? And are you joining with that? Peter?
Yes, I am. My case just require Mr. Artuso to go to the Secretary of State, and he was just released from custody on the 8th. So I'm asking for an adjournment.
I'll adjourn all of these matters to August 6, 2025, 9 a.m. See where we are.
Thank you.
We are on it.
Thank you, Your Honor.
Thank you.
All right, you're all set.
Thanks.
Court does call the case of the people versus Tariq Abdul Salam.
This is a show cause for failing to appear at the arraignment without counsel.
Abdul Salam. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. We'll give a 10% privilege on that. That warrant will issue immediately. That's called the case of the people versus Christopher Banks.
Christina Berger.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Banks. For the record, sir.
Christopher Banks.
Thank you, sir. What are we doing?
Thank you, Your Honor. I'm respectfully requesting an adjournment. I just was able to get correct contact information for Mr. Banks today. However, he did show me that as the paperwork that the court required that he get for the veterinary records for his case, he does have them with him today. I will need some time to provide them to the court. He just has one copy. I do now have electronic copies that I can provide to the court. That being said, as to the pretrial, I'm respectfully requesting an adjournment to discuss the discovery with my client as well as with the people.
Any objection to that? All right. I'll adjourn the matter August 6, 2025, 9 a.m.
Thank you, Your Honor. And I do have copies of those vet records that I will send to the court and to the people,
And to the people.
by the end of the day today. I
All
can
right.
safely say.
All right.
Thank you, Your Honor.
Thank you. Bond continues. Court does call the case people versus Luke Barrett.
Christina Berger for the people.
This is a show cause for failing to appear.
Luke Barrett. No response. Bench warrant will issue for defendant's failure to appear. Bond 5,000, 10%. That warrant will issue immediately. Court calls case people versus Thomas Bennett.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Bennett. Mr. Bennett, please state your name for the record.
Thomas Bennett.
Okay, thank you, sir. All right.
Your Honor, we are asking to set this for final settlement conference, please.
Jury, final settlement conference will be set August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue with its conditions. Thank you.
You're all set, Mr. Bennett.
Thank you. Court calls the case People versus Damian Poupette.
Good morning, Your Honor. May it please the court, Ezra Goldman on behalf of Mr. Poupette.
Your name, sir?
Damian Poupette.
Okay. All right, what are we doing?
Your Honor, this is an adjourned pretrial. Mr. Poupette was going to get evaluated for sobriety court. And
Okay.
he completed the evaluation that he can do. The results are not back yet. It's another one of those. So I have to ask the court for an adjournment.
Okay,
And I have to.
which sobriety court is he?
This is going to be this one. In this
14A.
court. Yes.
All right.
So
So he did the evaluation. Are we, that
results?
last case you heard, are we on that same timeline or?
No, we're a little better, except for my own schedule is a little, but the results were supposed to be back on Monday,
Okay.
2 days ago, but everybody's been, out of town and what have you, and they're all back.
Okay, so, but
So,
I have the September date or I have, cause I'm gone.
oh, I was gonna say August 20th, but the court's gone,
Well, I don't know if I'm gone that day. They just tell me don't come in. Okay,
You can do September 3rd. Or.
I don't have anything earlier in August after the 12th. But would August 6th work or I have to go to September 3rd?
Your Honor, last time I appeared by Zoom, the court complained that I don't like to come here, but I do like.
Well, that's true. You don't. I think I heard you before you took my God. It was horrible.
So I just said another thing for September 6th. So one or the other, it's in Dearborn, so I'm gonna have to do one or the other by Zoom if we do the 6th.
Okay, why don't we do the 6th? Well, it's August 6th or it's September 3rd. So you said something for August 6th, you said?
Just now, like 10 minutes ago. So September 3rd, I have nothing
All
so
right,
far.
why don't I do that? I'll adjourn it out to September 3rd, 2025, 9 a.m. If it requires a plea be taken, if he's accepted and a plea be taken, counsel can contact my office. We can try to arrange to take a plea via Zoom so that we can get him moving, but we'll have this.
Appreciate that. Your Honor, I have to ask one more question. I know that people do not appreciate that, but I must ask. The tether is costing him $11 a day.
So Londi's not going to appreciate it?
No, she already told me she doesn't like my
Nobody's
question.
going to appreciate it?
No, I mean,
Okay, no, I want to watch it happen.
I respect her objection to my question, but I got to ask it anyway. This tether is costing him $11 a day. Mr. Poupette works remotely, so he is home. He could test on a portable device as many times as the court wants him to, and be sure that he's not drinking.
What device is he on?
Ankle monitor, and I know that it's a second offense, and I know that it's a high BSC. I know all this, and I respect those objections, but I'm just asking. It's purely financial. And
I understand, but I would leave that in place. I may, if there's an evaluation prior to that point in time, certainly you could submit something to the court in writing for my consideration, but
for now, we're leaving it. I got you, Judge.
Okay. All right.
Have a very nice day.
Thank you. Continued. Court recalls the case of the People versus Ricky Ballard.
Robin McCoy, P63057, on behalf of Mr. Ricky Ballard.
I haven't sworn. I did. All right. Okay, I now have an advice rights form. As previously indicated, the defendant in this case is going to be pleading to the charge of operating while visibly impaired first offense. That being added count 2, count 1 would then be dismissed. All right.
That's correct.
Have been sworn, sir. Can you state your name again for the record, please?
Of course, Ricky Ballard, Your Honor.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, $300 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. The court could order your vehicle immobilized Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Of course, Your Honor.
All right. And understanding that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy and quoting rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you are indeed guilty?
Yes, Your Honor.
On May 10th, 2025, at the location of US 23 near Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, sir.
What'd you have and how much?
Tequila, Your Honor. Half of a pint, Your Honor.
All right. Were you stopped by the police or was there an accident?
Stopped by the police, Your Honor.
Why'd they stop you?
I was told multiple things, Your Honor. Speeding, I was told that. I was told, kind of running into the guardrail, or not the guardrail, the thing makes noise on the side of the road.
The rumble strip?
Yes, yes, Your Honor. And I got pulled over, Your Honor.
All right. Are you disputing the right of the police to pull you over in this matter?
No, Your Honor.
All right. After the police pulled you over, were you ultimately arrested?
Yes, sir.
Were you taken to the hospital?
Yes, sir.
Was there a blood draw?
Yes, sir.
And what were the results of the blood draw?
0.17, Your Honor.
0.179?
79, Your Honor.
Okay. Do you have any reason to dispute those results?
No, Your Honor.
All right. Sir, taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, sir.
All right. You also understand, sir, that while I'm taking your plea, if you commit misconduct between the date I accept your plea and the time of sentencing, that any evaluation by the court or any sentence agreement, the court would not be bound by. You understand that, sir?
I do, Your Honor.
And you also understand you would not be entitled to withdraw your plea.
I do.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have caused this plea to occur?
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel.
Okay, and Your Honor, my client did complete a substance abuse evaluation and there's a recommendation, which I can email it to the court and the prosecutor.
Well, don't send it to me. If there's an evaluation that's been done, you can provide that to probation, but I've referred him to Von Swartz. If that is acceptable to probation, I'm not going to have a problem, but if it is not, he must attend Von Swartz and do his assessment there.
Okay, just because he did complete it with Crystal Reyes and First Step Referral, they gave a recommendation. So, and they talked about the level for him. And let's see, they said
There's no reason to read that to me now. I'll be honest with you. You need to submit that to probation, as I've indicated. If that report is acceptable to probation, I'm not going to have a problem with that assessment being used for a sentence. If it is not, he must then go to Von Swartz.
That's fine. Okay, Your Honor, I just want to make sure that you know that he's taking this very seriously. He's never had anything like this happen before, so.
Sentencing in this matter will be August 13th, 2025, 9 a.m.
Okay, would that be in person or via?
In person.
Okay, 9 a.m. 13th, okay.
Bond with its conditions will continue. Thank you, sir.
Thank you, sir.
All right, thank you, Your Honor.
Court does call the case of the people, we call the case people versus Passion.
For the people.
David I. Goldstein appearing on behalf of the defendant.
Your name, ma'am?
Natasha Olmos.
All right, I do have now a plea form in front of me that indicates that the defendant will be pleading guilty to the charge of operating while intoxicated with an occupant under 16, the 1-year offense. Upon her successful plea to that charge, counts 2 and 3 would be dismissed. That's the court's full understanding of the agreement.
That is correct.
May I have her sworn?
Or affirm that the testimony of truth so help you God.
Yes, I do.
Go ahead and lower your hand and state and spell.
Natasha Olmos, NATASHAOLMOS.
Thank you. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated with an occupant under 16. That is a misdemeanor punishable by up to 1 year incarceration, fine between $200 to $1,000 plus court costs. The court could also order community service in any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, ma'am?
Yes, I do.
All right. And understanding that, you still wish to plead guilty?
Yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
You signed an advice of rights form today, is that correct?
yes,
Any question regarding any of those rights?
no,
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes,
of your own free will,
yes,
and also because you believe that you are indeed guilty
yes,
of these offenses or this offense?
yes.
On the date of October 5th, 2024, at the location Gulfside near Washtenaw Avenue in Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes,
Prior to operating that motor vehicle, did you consume intoxicating liquor?
yes,
Do you recall what you had and how much?
yes.
Okay, what'd you have and how?
I think I had, a pint of vodka.
All right. Were you stopped by the police or was there an accident?
I was stopped.
Why'd they stop you?
They said I was swerving.
Erratic driving?
Yeah, yep,
Are you disputing the right of the police to stop you in this case?
no,
All right. Were you ultimately then arrested?
yes,
Were you taken to the hospital for a blood draw?
yes.
All right. And what were the results of the blood test?
0.186.
186.
Yes,
And also there was THC or its derivative in your system.
correct.
All right. And at that time that you were operating that motor vehicle, was there someone else in the vehicle?
Yes,
Was it a occupant under the age of 16?
yes.
Who was it?
My daughter, Camila,
And how old was she at the time?
7
7? All right.
or 6. She might have been 6.
What's her date of birth?
It's 2/21/18.
All right. All right. Ma'am, I do have to advise you that if I accept your plea, any sentence evaluation, and you commit misconduct between the time that I accept your plea and the date of sentencing, that if you commit misconduct as defined by the Michigan court rules, that any sentence evaluation on your case, the court would not be bound by, and also you would not be entitled to withdraw your plea. You understand that?
Yes,
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right, and have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to count 3. Counts 1 and 2 are dismissed.
So around, Your Honor.
Yeah, you're right. I'm sorry. I'll accept the plea to count 1. Counts 2 and 3 are dismissed. Thank you, Mr. Wilson. Defendant is referred to Von Swartz for an alcohol screening and assessment in the victim's impact panel. Sentencing in this matter will occur
August 13th, 2025 at 9 a.m.
August 13th, 2025, 9 a.m. All right.
Your Honor,
Yes.
my client did want me to address the court on the issue of, well, it's part of the bond. She has, this offense occurred in 9 months now. My client has no other criminal history. I don't know how it came in my file, but when I got my file from prior counsel, there was a CCH in there showing no convictions for anything, not even a traffic offense. She's been on a tether since February, and I looked in the court file, in my file, I don't see any indication of any violations of that tether. My client has also been engaged voluntarily in counseling, and we've discussed this, she will provide that to the probation department as part of the pre-sentence investigation.
Outpatient, sorry.
I'm sorry.
It's outpatient.
Outpatient, yeah, well, you're right, but it's counseling. But, Your Honor, anyway.
She's been involved in outpatient treatment, you mean?
Yes, Your Honor.
Go ahead.
So I'm asking that the tether be removed, Your Honor.
Response from the people.
Your Honor, we would object to having the tether removed. The defendant had a BAC of 1.86. Her 6-year-old daughter was in the car with her at the time. She also had weed in her system. I believe that this room is appropriate to continue at this time.
What I will do is I'm going to deny the motion to remove the scram at this time. However, if you provide documentation to the court, I may consider something regarding her outpatient treatment.
Okay.
Okay, thank you, Your Honor.
Thank you.
Right.
On. Run out of funds.
Yeah.
That's it? Why is Simon here?
He likes to come to this court, Your Honor. He told me he hates every other court except this.
Good call, Joe. Joe, something I learned today, you can get good deals if you go over and call Miss Lundy old. All right, court is standing in recess.
Court Madam Session, the Honorable Case Subject Susie presiding.
Maybe seated. Court does call the case, People versus Deanne Kruger.
Echelon for the people.
Your Honor, Joe Simon on behalf of Janine Cougar should be there on Zoom. If you'll unmute your device and state your name.
Janine Kruger.
Your Honor, I think we're here for arraignment.
Yes, sir.
And waive formal reading and stand mute.
Pending having wait formal reading, standing mute, court will enter not guilty plea.
And as the court can see by the date, the address on the complaint, my client lives out of state. She'll be requesting permission to continue to reside in the state of Wisconsin.
He resides in Wisconsin?
That's true.
On purpose? No, I'm kidding. All right.
With regard to the pretrial, I've asked Ms. Lundy to check into a couple of things and ask to adjourn the pretrial.
I'll indicate that the defendant can continue to reside in Wisconsin. Will the 6th of August work for you?
Your Honor, if you would just please give me a second. Yeah, I can make that work. What's the next available, Your Honor? Oh, let's keep August.
I'll adjourn the pretrial in this matter, August 6, 2025, 9 a.m., or as your invite indicates. I will set the defendant's bond at a $10,000 personal recognizance bond. All of the standard conditions, including no assault behavior or possession of any weapons, no possession of alcohol, recreational marijuana, or any illegal drugs. I'll also indicate that the defendant is not to have any contact with Margaret Anderson.
Your Honor, can we make just one request on that? That's my client's sister and this.
Oh, it's your sister, okay.
Well, may they converse for their mother is not in good health. So may they converse for that limited purpose.
Your Honor, I am asking for a categorical no contact order. My understanding is that this happened while at the mother's house, who is in bad health. So
Got it.
I'm just asking.
I'm gonna order at this time that there be no contact. And certainly the parties, if you talk to, I guess, Miss Anderson, and she feels differently, then maybe.
Yes, we'll let everyone know if she has a different thought.
All right. All right, and the defendant may, I guess, reside in Wisconsin.
May she appear by Zoom for the next court appearance?
I don't have a problem with that. She should submit the form.
Thank you.
Ma'am. C case of the people versus DeSure Bond Sander.
Assistant Public Defender Natalie Pate with on behalf of Mr. Bond Sanders. All right, please state your name for the record, sir.
DeSure Bond Sanders. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
And has he signed it by right?
Yes.
All right, may I have him sworn?
Raise your right hand. You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth to help you God.
Yes.
Lower your hand and state and spell your name.
Israel Bond Sanders, DAJOUR, last name BONDSANDERS.
All right, it's the court's understanding that you're going to be pleading guilty to an added count 2 of allowing an ineligible driver to operate a motor vehicle. That is a misdemeanor punishable by up to 90 days in jail, $100 fine plus court costs. You understand that, sir?
Yes.
All right. Understanding that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No.
Look at paragraph 5, you'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record that count 1 would be dismissed?
That was gone.
Oh, he said, has anyone promised you anything or stated anything?
No.
Nobody promised you anything
No.
else?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On October 19th, 2023, at the location of Clark Road near Gulfside, Pittsfield Township, Washtenaw County, State of Michigan, were you in custody and control of a motor vehicle?
Yes.
Did you allow someone who was otherwise ineligible to operate that motor vehicle?
Yes.
All right. Counsel, well, sir, I do have to advise you that if between the time of your plea and the time of my acceptance of this plea and the time of sentencing, which we momentarily, if you commit misconduct as defined by the Michigan court rules, you would not be entitled to any evaluation or particular sentence in the case, and you would not be allowed to withdraw your plea. You understand that?
Yes.
Is counsel aware of any promises, threats, or other inducements which have caused this plea which have not been stated on the record?
No, Your Honor.
All right. And has the court complied with the court rule?
Yes, sir.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Sir, anything you want to say before I do impose sentence?
No, sir.
Fines and costs of, how long have you been in?
Like 20 days, I think. Like 20 days.
Been in 20 days?
Yeah.
Yes, Your Honor. He's been in, I believe, I have written down 19. I don't think I counted today though. And he isn't expected to be released until at least sometime after likely August 8th. So I'd ask the court can maybe consider state minimums for the fine, given his incarceration.
Fines and costs of $125, 20 days. Another 20 days Washington County Jail, credit 20, sir. Thank you.
Thank you, Your Honor.
Court does call the case People versus Jillian Satori.
Ready, Your Honor.
After a lot of people.
Your Honor, Joe Simon, on behalf of Ms. Sartori. Jillian, come on right up here and state your name.
Jillian Sartori.
And Your Honor, we're here for an adjourned pretrial, but I don't think we're going to get to a resolution today because of the report received and the court's issuance of an arrest warrant. We want to address that, obviously. My client is excuse me, I should not have said is, a daily smoker for virtually, I don't know, years. And she insists, and she's ready to address, Your Honor, that as soon as you ordered her not to smoke, she stopped, and she hasn't been smoking. Now, her levels, she had one mistest on a random call while she was in Birmingham at an orthodontics appointment. She could not get to community corrections the next day. The next day they called, that day in time, the next day they arranged for her to come on an off time, and she took her makeup test. That's why it says makeup from 7/1. And yeah, we figured. I can just tell you that, and my client is happy to do that. I can tell you anecdotally, Your Honor, my last comment, I had a client who was similarly situated in the 14A4 court. And it took 2 months for him to have his negatives, for him to get completely clear. And, we could always question his truthfulness, but I believe he was being truthful. He was also getting independent tests that were showing clear while community corrections was still showing positive, which I know that comforts the court because their tests are more complete maybe and more thorough. But my client absolutely insists she has been following your bond order completely.
All right, anything from the people?
I think I heard the court ask for levels, which would be
Yes.
my inquiry as well. We have all seen people test positive for weeks or months after stopping, but what we'll be telling, I believe, is the levels.
Okay.
I don't know that I have a position if we have those.
Yeah, all right, very good. And what I'm gonna do is I'll pass the matter, we'll get the levels over. All right,
Do you want me to send her directly over there?
no, we're gonna get levels.
From them.
We're gonna get levels of the past test, so she stopped, I'll know.
Thank you, Your Honor. Just, please.
Court does call the case of People versus Sean Charnley.
Conrad Siller on behalf of Pittsfield Township.
And after that, people.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Charnley. Mr. Charnley, please state your name for the record.
Sean Charnley. Thank you.
Your Honor, we have resolutions on 2 of the cases. The Fink cases. I'll just grab my computer.
And that's correct, Your Honor. While we're getting ready to put that on the record, I'll let the court know that we are hopeful to resolve the state case as well. There's a matter of restitution. That's sort of the issue that's holding us up, is figuring out how that can get paid or when it can get paid. Ms. Kearney and I have discussed time served because I believe the defendant has 115 days of credit at this point. But the problem is there's like $300 and some odd in restitution, so sort of stuck.
So what do you wanna do on this?
Cool. So on the Fink cases, Your Honor, the offer is for Mr. Charnley to admit responsibility to double parking.
In both cases?
Just on the ending in 0438.
That's correct, Your Honor, and if you accept that admission in 0438 and move to dismiss 1573.
Charnley, do you admit responsibility to the fact that on March 24th, 2024, at the location of Carpenter Road in Pittsfield Township, that you double parked a motor vehicle?
I do.
All right. Court will accept that admission to double parking in case 438. Count 1 in that case is dismissed, as well as case ending in 1573 is dismissed. On that case, fines and costs, are you expected out anytime soon? What?
Don't know.
Don't know.
He's been referred to recovery court on his felony cases in the circuit court.
Got it.
So that process is just.
All right, so what I'll do is $180 fines and costs payable by December 31st, 2025. All right. Okay. On the other case, what are we doing?
I just asked for an adjournment to the next possible date. Hopefully we can work something out and,
All right. August 6th, 2025, 9 a.m. All right, thank you.
Thank you.
Fine. Court. They don't have them. Huh?
Custody next. That's what I closely.
Court does call the case People versus Nadia Cosley. Oh, they do.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Causey. Ms. Causey, please state your name for the record.
Nadia Causey.
Thank you.
So, Your Honor, I believe we have resolutions on both cases. So on the Fink case ending in 02.
That'd be Pittsfield case, but go ahead.
I'm sorry, yes, you're right. The Pittsfield case ending in 0291, Ms. Causey has her permit and Mr. Stiller has extended an offer of double parking.
That's correct, Your Honor. So I move get count two double parking in case 0291. If you accept that admission, it's Mr. Regan charge.
Ms. Cosley, do you admit responsibility to the fact that on March 6, 2025, at the location of Ellsworth Road in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes.
All right, court will accept that admission. Count two, count one is dismissed in that case, and that being the case, 291. Fines and cost of $180. When can you get that paid, ma'am?
In the next 2 weeks. So like 14 days.
Yes, I know what 2 weeks is, but thank you for that. Paid by July 31st.
Okay, thank you.
All right. And what are we doing on the other case?
So I understand that Ed now has insurance, so we've offered an ad count two of no proof of insurance, 257326, the civil infraction.
Ms. Causey, that fine is $155. Do you want to accept that? It's a civil infraction. So similar to the other one.
It's 155 for the no insurance case.
Correct.
I can accept that fine, yes.
Pardon? What'd you say?
Yes, I'll accept it. Sorry.
Okay. So on that case, you admit responsibility to the fact on April 26, 2025, at the location of Ridgewood Drive, Pittsfield Township, Washington County, State of Michigan, that upon the lawful request of a police officer, you are unable to provide insurance.
Yes.
All right, court will accept that admission to no proof of insurance. Fines and cost of $155. When can you get that paid?
3 weeks.
You get paid every week?
Yes, I just have my DTE and my internet and phone bill due this week and next week. I have a little budget on my fridge of my checks and bills.
Okay, that's wise. All right, why don't, she's got to squeeze this into her budget.
Yeah, I'm trying to be very responsible with my first apartment.
Your first apartment?
Yes.
Okay, that means she's cash poor. So, ma'am, pay this by August 29, 2025.
Okay, thank you.
You're welcome. Have a good day.
You too.
Court calls the case People versus Dion Covington.
That's a lot of the people. This is not ready for that.
Good morning, sir. What's your name?
Dion Covington.
All right, you are before the court on a misdemeanor citation or complaint that alleges that on or about June 23rd, 2025, location of Carpenter near Center Valley in Pittsfield Township, Washington County, State of Michigan, that you did possess drug paraphernalia. You understand that, sir?
So
that is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs and any substance abuse treatment. Do you understand that, sir?
So
all right. First question I have for you is, do you want to be represented by an attorney?
yes, sir.
All right. It's public defender.
Good afternoon, or good morning, sorry. Assistant Public Defender Lauren Perny on behalf of Mr. Covington. We waive further reading standing to the charges as for another pretrial.
Defendant every way formal reading standing mute, court will enter a not guilty plea. I'll adjourn the pretrial in this matter August 6, 2025, 9 a.m. Is he gonna be still in?
He's is set for sentencing today. There's a sentence agreement or recommendation to probation, so he should be released.
Should be, okay. I'll set his bond then at a $5,000 personal recognizance bond. In this case, standard conditions, no assault behavior, possession of any weapons, no alcohol, recreational marijuana, or any illegal drug. You understand that, sir? What is he being sentenced on in the other case?
Possession.
It's another drug case. All right. What I'm going to order then is that the defendant also report over to community corrections upon his release for what's your drug of choice?
It was for cocaine, sir.
Cocaine. All right. I want testing 2 times per week. Okay. All right. I'll sign that order. Court calls the case People versus Ashley Fix. Not so much. Court does call the case People versus Shania Williams.
Conrad Solar on behalf.
Good morning, Assistant Public Defender Lauren Perny on behalf of Miss Williams. Miss Williams, please state your name for the record.
Shania Williams.
Thank you.
Your Honor, this is a licensed case. Miss Williams was released from custody last week. She is getting back on her feet. She has a ticket that she needs to pay off, and to pay that ticket off, she needs to get back working. So we're asking for an adjournment to allow her time to do
September
so.
3rd. All right.
Yes, sir.
2025, 9 a.m.
Thank you.
Thank you. Bond continue.
Thank you.
All the rest are in.
Yes, sir.
Court does call the case People versus Ashley Fix.
Conrad Solar, excuse me, Conrad Solar on behalf of Pittsfield Township.
And Assistant Public Defender Natalie Pate with and on behalf of Ms. Fix, who stands to my right, please state your name for the record, ma'am. Ashley Ann Fix.
Thank you.
Thank you, Your Honor. There is an offer in this matter that Mr. Siller extended that would require Ms. Fix to engage in some mental health treatment. I have reached out to jail services regarding her potential participation in CMH while she is there. She is currently serving a sentence and expected to be released in early September. So all that being said, I'm respectfully requesting a adjournment of this case so that she can engage in those
Do
services.
you want this October or August or September day?
I think August would be okay, Your Honor.
During the matter August 6, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Counsel, so that you're aware, we'll probably slow down only because I only have in custodies left. So we're just gonna. Sorry. Court does call the case of People versus Matthew Fonseca. Finesca.
What was the defendant's name, Your Honor?
I think it's Finesca.
Oh, Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Louis Fonseca.
Yeah, I said it right the first time. Anyway.
Your Honor, on both cases, we're asking for adjournments. Mr. Fonseca, as the court can see, is back in custody. There was a new case that's authorized. It's essentially a delay authorization. I think the date of offense was some time ago, but it was authorized. So he has a new felony before Your Honor. I believe that's set for this Thursday. So now that there's an additional.
For tomorrow?
Yes. Now that there's an additional felony, we were working on a global resolution, but now things are a little shaken up. So we're going to keep working on.
August 6, 2025, 9 a.m.
Thank you.
Bond will continue.
Thanks.
No, but they can give us.
She said they don't have.
I get that, but they don't get the amount found in the system, even if it's for something. Because that's gonna be a problem.
I agree. I didn't ask the future question.
ask us a future question, so we'll figure it out. All right. Let's call the case of the people versus Daryl Frederick.
Conrad Solar on behalf of Pittsfield Township.
Assistant Public Defender Natalie Tate with and on behalf of Mr. Frederick, who is approaching.
Your name, sir? Daryl Frederick. All right, thank you.
Thank you, Your Honor. I'm respectfully requesting a brief adjournment. I have discussed this with Mr. Siller, and I know he already reached out to the police department regarding the media discovery, so I'm requesting an adjournment so that I can receive and review that with my client.
August 6th, 2020.
Thank you, Your Honor.
Thank you.
It's a big jail line today.
Yeah, it is. Let's call the cases of people versus Chad Jones.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Jones, who's approaching. Mr. Jones, please state your name for the record.
Chad Jones. All right, he's back. No, right.
Your Honor, we're requesting adjournments on all cases. Mr. Jones is being referred to recovery court on his felony files.
Okay. Do they have a timing for that? I mean, I can bring him back August 6th, but I don't know.
I don't know, it's taking long. So for example, on another defendant up today, they said we'd have an answer by the 3rd and we don't have an answer on him. So I think it's taking a little bit longer than normal. Maybe because
Okay.
Summertime.
So let's do this. Because it's summer, really?
Well, everyone's enjoying themselves, but Mr. Jones, we are also trying to get Mr. Jones into treatment. He just has a holdout of Canton that we're also trying to resolve.
Gotcha.
So
Let's go to 2025, August 6th. Bond continued, just so that these will keep track of it. If we have to turn it out again because we don't have it, that's fine, but,
thank you.
all right, thank you. Court does call the case of the people versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Lester. Mr. Lester, please state your name for the record.
Paris Lester. Thank you.
Your Honor, we are asking for an adjournment there. Mr. Lester has a pending felony before Your Honor. There was discussion about mental health court.
When is his felony?
I believe it's up tomorrow.
Same courtroom.
Okay.
Tomorrow.
Um,
All right, I'll adjourn these to August 6th.
okay. Thank you.
Well, hold on. I don't think he's been arraigned. Has he been arraigned?
So.
He has not been arraigned. Hang on a second. So in the case ending in 805. Well, it doesn't look like he's been arraigned on this one. How many cases do you have?
I just have 805, but
There's two counts in 805, maybe that's the confusion.
No, that's not the confusion.
No, we were not aware of these cases.
So, all right, so on the case ending in 805, I've adjourned that to August 6th. He also has 2 new cases.
okay.
All right. And, right, okay, so we're gonna have to kind of do these separately. Case ending in, so 10125-1034. Let's do that one first. Mr. Lester, you are before the court on a misdemeanor complaint that alleges the offense of retail fraud 2nd degree that is alleged to have occurred on April 10th, 2025 at the location of 771 Airport Boulevard, that being the Costco. You understand the nature of that charge, sir?
I haven't heard about that, no.
Pardon?
Haven't heard about that.
Well, whether you heard about it or not,
I
you
didn't know.
understand what you're charged with?
Yeah.
All right, so that is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that, sir? So the first question I have for you on that case is, do you wish to be represented by an attorney? All right. Before you do the waiver or the formal reading, that will become a Pittsfield Township case. Let me do his other case. You have a case, in that case ends in 1036. And in that case, sir, that complaint alleges that on or about April 17th, 2025, at the location of 3825 Carpenter Road in Pittsfield Township, that being the Meyer store, that you committed the offense of retail fraud in the third degree. Do you understand the nature of that charge, sir?
Yeah.
All right, that's a misdemeanor punishable by up to 93 days jail, $500 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, yes, yes.
All right, do you wish to be represented by an attorney on that? Okay, that's also a PD case. All right, go ahead, Ms. Barron.
Then on both cases, we'll waive formal reading, stand mute to the charges, and request a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all.
The last time I was here, we talked about that. Why do we go to treatment?
Pretrial in these cases will be adjourned to August 6th, 2025, 9 a.m. On the case ending in 104, well, in both cases, under standard conditions, including no assaultive behavior or possession of any weapons.
The last time I was here, that's what.
There's also to be no alcohol, recreational marijuana, or any illegal drug. In the respective cases, he is at this time not to enter in any Costco store in the state of Michigan, as well as he is not to enter any Meyer store in the state of Michigan. I got everything on there.
So also that's something that we'll sign.
And the bond, and so he's in right now on something else.
Yes, his bond, some of the other cases, 5,000 on the felony case. I'm sorry, no, 5,000 on a probation violation on 15, 100 on the felony, and then 100 on the already arraigned case here.
Okay, gotcha. I'll set his bond in these cases at $5,000. I'll give a 10% privilege on it, and then we'll see where we go. Okay, thank you.
Thank you.
Calls case of the people versus Anthony Miller.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Miller. Mr. Miller, please state your name for the record.
Anthony Lavelle Miller. Hello, Your Honor.
Hello, sir.
Your Honor, we're asking for an adjournment. Mr. Miller also has a pending felony in front of Your Honor that's scheduled for tomorrow.
During this August 6, 2025, 9 a.m.
This week, okay.
Time will continue.
Yeah.
While we wait on that, court does recall the case of the people versus Sartori.
We'll come talk.
Your Honor, Joe Simon on behalf of Ms. Sartori.
All right. I don't know what's going on. They have indicated that they don't have access to them because they switched over to a new system. I don't know if that's a permanent thing or if it's just for today. We're going to figure that out, but I don't have the levels at this point.
May I suggest, Your Honor, that Your Honor, that we adjourn the pretrial to that August 6th date, that we have her test as often as the court directs in the interim. And in my understanding that levels will be able, but of course that will start a new level, won't it?
Well, I'm not entirely sure.
Okay.
I've not run into this where they don't have access to a level. So I gotta first of all figure out, is that a permanent thing, which would be a disaster? But, we're not beyond that, right? Um, and, and then what we can get may just be something we just don't have access today. I'll make that assumption so I can smile the rest of the day.
And Your Honor, at this time, the people would request the court go ahead and cancel the warrant, and it does get the levels, and it does appear that there was a violation after the time in which the defendant was put on bond. Maybe the court would reissue it. Otherwise, we'll come back on maybe August 6th or whatever Mr. Simon, I'm not sure.
I'll cancel the warrant. We'll adjourn this matter out to August 6th, 2025. She's to continue her current testing
Thank you, Your Honor.
regimen. All right.
I understand. If you want to wait.
Thank you.
Thank you, Your Honor.
Court calls case People versus James Raggett. Did you have something else?
On the Zoom, but it's an interpreter.
Got it.
Good morning, System Public Defender Lauren Perny on behalf of Mr. Raggett. Mr. Raggett, please state your name for the record.
James Patrick Raggett III.
Your Honor, we are here for a bond violation as well as a pretrial. I would like to address the bond violation and bond. But that requires me talking more. So at the pretrial, we're just asking for an adjournment. The agreement is that if Mr. Raggett does a assessment, it could be reduced. However, he is in custody. We need to locate if we can locate someone who does assessments while he's in custody, depending on the court's ruling today. But that will be worked out. Okay.
The bond violation?
So I believe the bond violation is for Mr. Raggett's new criminal case. That is also before Your Honor. We set that case for final settlement. I didn't see any positive tests or anything like that, or any missed tests. Mr. Raggett would like this court to consider releasing him today. He did pay there was a bond that was set on the domestic violence case. He paid that bond. He also paid another bond out of the 15th District Court that was holding him to demonstrate to the court that he's serious about resolving these cases, will come back to court. This bond violation is bond denied. His main priority is to get back to work. He's been working for Motor City Bikes for 10 years. I did speak with his boss there, and his job is available if he were to be released. He also did send me a letter demonstrating that Mr. Raggett has been a good employee, and he has worked there for quite some time. They also work with a nonprofit. Mr. Raggett is a co-founder of Common Cycle. They provide community access to kids for bikes. I believe his mother is present. That is who he will be staying with, who obviously is not with.
The underlying case is a domestic.
Correct, yes.
So part of the bond violation not only would be the new case, but would also, well, on either case, he's not to be using and not to engage in any assaultive behavior.
Yes, I suppose police contact assaultive behavior, but again, Mr. Raggett does dispute those allegations, and we did set it for final settlement. So we'll see what happens on that date on that case, but obviously we're not going to admit to the violation today and ask that, the bond violation be adjourned out, I suppose maybe to the 8th, or after the 8th, to see what happens on that file. Again, he has not had any positive or missed drops. He has not missed any court dates. Since I've been representing him over the last couple of months, he's been very attentive, very communicative with me. He does have 2 kids, 19 and 14.
Do we have at least the allegations regarding the domestic? I mean,
I have the police report, yes. The allegation is essentially I'll refer to the people to defend their charges. But again, Mr. Raggett asserts his innocence in that case and
Well,
disputes that.
yeah, you can depend on people to do that. The problem is that I don't have, and I understand why you may do that, but I don't have a context for. I don't have a context or anything without some type of indication as to what's alleged to have occurred.
You're actually allowing for the people of the state of Michigan helping out to answer some of the court's questions. I was able to locate a 2025 DV case, this defendant's name on it, which I do believe may be a current case. The name victim in that case is Kayla Henderson.
Yes, it's the case, for your information, Ms. Lundy, it ends in 0923.
The defense counsel, there's a whole other issue that hasn't been raised.
Okay, yes, you may.
Thank you.
Yeah. Record should reflect you've had a bench conference in this case. I'll continue. I'll adjourn the bond violation hearing and the pretrial to August 6, 2025, 9 a.m. If any additional information comes up regarding I realize the domestic is set after that, but we're also looking to get an assessment here. At this juncture, I'm not going to change the defendant's bond in this case till I have a hearing on the bond violation.
Thank you, Your Honor.
All right, thank you. Court calls case of the people versus Vincent Dunlap.
Yes, Your Honor, Brenda Bird on behalf of Vincent Dunlap. Mr. Dunlap, can you please state your full name for the record?
Vincent Edward Dunlap. Thank you. All right, what are we doing?
Respectfully, Your Honor, I did get a chance to speak with APA Lundy and my client, Your Honor, and we would like to take the prosecution up on their offer to dismiss count 1 conspiracy to commit retail fraud, 2nd degree, and plead to add a count of retail fraud, 3rd degree.
Mr. Burns, so that's what the court.
I had to get it signed. I tried to get it signed in the back, Your Honor, but.
Okay, I need that signed off. I need to please. Reform in this case indicates that the defendant would be pleading guilty to an added count to a retail fraud in the 3rd degree. The 93-day offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's understanding of the agreement.
That's for presentation.
Correct. Have them sworn.
Raise your right hand. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and say your, spell your name.
Vincent Edward Dunlap.
All right, that'll work. Court, Mr. Dunlap, the court is of the understanding that you're going to plead guilty to the charge of retail fraud in the 3rd degree.
Yes.
That's a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form today?
Yes.
Any question regarding those rights? Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of March 11, 2021, at location of 3825 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Meyer store that makes you think that you're guilty of this offense?
I tried to steal some liquor.
Okay. And the store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No.
And this property you took or tried to take That was property that was offered for sale by Meyer?
Yes.
All right. And sir, I do have to have you understand that if I accept your plea and you commit misconduct between the time of sentencing and this plea, that any evaluation, if one was given as well, the court would not be bound by that. You understand that, sir?
Yes.
You also would not be entitled to withdraw your plea. You understand that?
Yes.
Counsel, are you aware of any promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. And have I complied with the court?
Satisfied, Your Honor.
All right. Court will accept the defendant's plea of guilty to count two. Count one is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be
July 30th at 12 p.m.
July 30th, 2025, 12 p.m.
Your Honor, respectfully, is there another date? I'm in Oakland County on July 30th.
You are?
I am.
Because you like them better?
No, no.
Oh, okay. I'm just asking. I can get to August 13th. Is he being held on something else?
He is, and I was what was going to ask to address that, Your Honor.
Okay. Then I'll adjourn his sentencing to August 13th, 2025, 9 a.m. All right. And what were you going to address?
Respectfully, Your Honor, actually, now that I'm thinking about your question, is he being held on something else? No. He indicates to us that his felony cases, he got a personal bond with the condition that he has to get into treatment.
Got it.
He's being held on this $100 bond here, and we're going to ask for a personal bond with the condition that he must comply with.
Well, the way I do it, and there typically is a standard order, you may be able to get the language from the public defender's office. I will release him to inpatient treatment on a PR.
Sounds good. Yeah.
I have no problem doing that.
Thank you.
All right, so I'm going to continue his bond. You get that order through me, I'll sign off.
Yeah.
Thank you. Court does call the case of People versus Todd Rayberg.
Conrad Silver on behalf of Crystal Township.
Oh, that's right. Didn't care. Anybody else know but Joe?
I move with slow here.
Yes, sir.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Rayberg. Mr. Rayberg, please state your name.
Todd Rayberg. Thank you.
So, Your Honor, we're kind of in the same position we've been in. We're trying to get Mr. Rayberg into treatment, but he has a hold out of Livonia that's holding him. We've been trying to get Livonia to see him while he's in our jail, but they're not cooperating. So, but I'm going to keep working on that. He does have other cases that he's being held on. He has releases on all of them. It's just the holds that is preventing them from him from being released.
But that's out of Livonia.
Yes.
Stopping everything else.
Yes, basically.
Okay.
These cases will likely be resolved if he completes treatment.
If you can get in.
Mhm.
Okay, so you're still working on trying to get Livonia to see him? Did
Yeah.
they not see via Zoom or what? Never mind. Never mind.
Long story.
I probably don't want to know. August 6th, 2025, 9 a.m.
Thank you, Your Honor.
And it's not Mr. Rayberg, it's technology, it's bureaucracy and technology that's Livonia's like, Washtenaw is hard to deal with.
It's what?
Washtenaws technology is hard to deal with and blah, blah, blah. Yeah, so I'm trying to work it out because that's not my experience. So,
Okay.
yeah, we're going to work on it.
No, I know that you will. I'm just like,
I don't know. Yeah.
I mean, I think if they just called a jail and want him via Zoom.
That's what every other district court.
Whoa, you're getting bitter and I'm not going to criticize my colleagues at the 16th District Court. Court does call the case, People versus Derek Simpson.
Christina Bear doing for People.
Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Simpson.
No relation.
Mr. Simpson, please state your name for the record.
Name is Derek Allen Simpson.
Thank you.
Your Honor, I am asking for an adjournment. I think we're close to coming to a resolution. There was a resolution. However, Mr. Simpson was in warrant status. I just need to nail out some details with the people. He is being held on a 15th district court case. I believe that bond's $2,500. His next court date there is the 24th.
Okay, I'll adjourn this then to August 6th, 2025, 9 a.m. Bond continued. Thank you. Does call the case of the people versus Kevin Smith.
Conrad Solar, Nashville Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Kevin Smith, who is approaching. Please state your name for the record, sir.
Kevin Smith.
All right. Do I have an advice of rights?
You should, Your Honor, as well as a police report.
I have a police report and I see it. It got tucked under something. All right, I do have a plea form before me that indicates that the defendant will be pleading no contest to operating while intoxicated to 93-day offense. Upon his successful no contest plea to that charge, count one would be dismissed. The operating with a high BAC.
That's correct, Your Honor.
That is correct, Your Honor.
May I have him sworn?
Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand and state your name again.
Kevin Smith.
All right, Mr. Smith, it is this court's understanding you're going to plead no contest to the charge of operating while intoxicated. That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary, could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
Yes, yes, sir.
Sir, do you understand what a no contest plea is?
Yes, sir.
All right, two things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that? The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Is that a yes?
Yes, sir.
All right. Basis for a no contest plea?
Potential civil liability, Your Honor.
All right. Sir, to that charge, how do you plead?
No contest, sir. No contest?
You understand that by pleading no contest, you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form, is that correct? Any question regarding any of those rights?
No, sir.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce?
Oh, no, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 226681. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Sir, if I accept your plea, you understand that, and you commit misconduct as defined by the Michigan court rules between the time of the acceptance of the plea and your sentencing, that two things. One, any sentence evaluation regarding this, the court would no longer be bound by, and also you would not be entitled to withdraw your plea. You understand that, sir?
Yes, sir.
All right. Court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have there been any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
Not that I know of, Your Honor.
All right. Have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Yes.
Court will accept the defendant's plea of no contest to this charge. That being count 2, count 1 is dismissed. Defendant is referred to Von Schwartz for an alcohol screening and assessment and the victim's impact panel. Sentencing in this matter will be July 30th, 2025, 12 noon.
Thank you, Your Honor.
Continue. Thank you. Caseville versus Michelle Campbell.
Good morning, Defender Lauren Perry on behalf of Ms. Campbell. I believe she's ill.
Okay.
So why just ask for adjournments on both of these files?
Adjourn each of these files to August 6, 2025, 9 a.m. Bond continue.
Thank you.
Good morning, Your Honor. Alex Barry Santoro appearing on behalf of Plaintiff Dale Kratz and Dina Davis, P81545. Nice to see you.
Good seeing you, sir.
I
I
have closed captions on, but it's not showing.
Objections to garnishment?
That's accurate, Your Honor. I did file a writ of garnishment, and there was an objection served after the 14 deadline to effectively stay the garnishment. So I'm here today to
object to any stay of the garnishment. Right?
Yeah, that's the lawyer.
I'm brilliant. I figured that all out on my own.
Yeah.
And they're not here. Taylor Adams, Tiffany Gross.
Do you want me to call the hall or something?
Well, Adams, Gross.
No, I know them.
No.
The landlord docket here sometimes gets spicy because I saw a case from last week where the landlord and the tenant, they didn't get along at all. The landlord switched off the Wi-Fi, and when the tenant was away at work, he went down there when she was away to some medical. She has some medical issues, so she has to be away to get treatment. He goes down and unscrews the light bulbs to save energy, and she has this nerve illness of some sort. She shouldn't be on ladders, but every time she comes home from one of these treatments, she had to go on a ladder to screw in the light bulb again. Judge Simpson wasn't happy about that. So sometimes these landlord-tenant hearings gets spicy.
The defendant having failed to appear, the motion regarding the objections to the garnishment are denied. Garnishment may proceed. That denial is based not only on the defendant's failure to appear, but also on the merits of their objections.
Thank you, Your Honor. I appreciate your time.
Thank you, sir. May Shen versus Fatima Stevens.
Fatima Stevenson appearing on behalf of herself. Good morning.
Good morning, Your Honor. Jay McCurdy on behalf of Jing Mei Shin, P8321.
All right. And this is your motion for relief from judgment, ma'am?
That is correct.
All right. What do you want to tell me about it?
Council and I originally in late May, I believe, were discussing the option of me purchasing the home that I'm currently renting, because at that time I was made aware that the owner was was intending to sell the home. So it would have benefited all parties if we were able to make this transaction occur. It has taken a little bit of time. We've all kind of, well, I can't say we've all, but counsel and I have corresponded through email, as you've seen. The property manager, who is also a realtor, and I and the realtor I had secured recently have also been in communications as of yesterday. I was just made aware late yesterday afternoon that the property manager who was in correspondence with my realtor and lender is not the listing agent. So therefore had no authorization this entire time to work on the deal. And so, so anyway, long story short, I had not looked for alternate living. I had not, I wasn't intending to seek alternate arrangements to move out because my intention was to actually purchase the property. It wasn't going to be a quick thing, but it was going to take a little time. But as long as I showed progress and all the relevant parties that were interested were kind of kept in the loop to showcase good faith that we could move forward with that and stay the eviction.
Thank you, Your Honor. The home is not currently for sale. Hasn't been listed yet. My client wants to get the property back.
But, okay, just so that I'm clear, the original is conditional order of dismissal was put into place with contemplation of a sale?
That's correct.
No, Your Honor.
Oh,
That is not.
oh, disagreement.
Stevenson is representing that we've been in discussion for sale of that home. That is not accurate.
Okay, but was there somebody well, let me ask this. Whether they had authorization or not, was there somebody operating on plaintiff's behalf that was leading toward a sale?
So there was a, after the affidavit was sent in late June, Ms. Stevenson sent me this email that she has, I guess, attached to this motion here, that she's been approved for a mortgage.
Okay.
And as you can follow through this email chain here, essentially, she wanted to put together an offer, and I said, if you're going to do that, you might want to do it quick because we're running out of time here. And that's essentially where that conversation ended on my part.
Right, but there were also other individuals that were.
Text messages, Your Honor?
Yeah, well, there are other individuals that are involved that are seeming to indicate that the purchase.
On the plaintiff's side, Your Honor, there is a realtor who's the property manager who had asked Ms. Stevenson for a pre-approval letter or something at some point. Nothing was provided. I have an email chain here that I can submit for the record. It's called it, and it clarifies what happened.
Clarifies. Well, okay, so here's what I'm getting at. There's someone on the plaintiff's side that is talking to somebody on the defendant's side regarding the sale. I'm a bit concerned because as I'm hearing you, the person on the plaintiff's side is a realtor, right?
That's correct.
There are, it seems to me, discussions that are going on regarding, well, between the person that's a realtor on the plaintiff's side and a realtor on the defendant's side.
So the person who's a realtor on the plaintiff side has no agreement to sell the home. There's no,
I get the fact that there may not be some agreement between plaintiff and this person.
okay, in no way does this person represent the plaintiff or their interests.
In some way they do, don't they?
So, Your Honor, I think the statement that this person is the property manager is incorrect because this person has told me they're not the property manager of the property.
Who are they then?
They helped,
Vis-a-vis the property.
they helped the homeowner purchase this home or find this home as a property for their portfolio.
Say that again?
They helped the homeowner find the home as a property for their portfolio. As an investment property, this property.
Okay. Okay. If that's all they are, why are they entering into discussion?
Your Honor, I don't know. If we look through, I have an email from that person, in an email chain that both Ms. Stevenson and I were included on from yesterday, and it describes an email between her realtor and this other person describing what.
This other person being whom?
The person's name is Kirk Glassel.
And that's the person that.
Mr. Defense Attorneys, why is this news in this case that seems to have been up before Judge Glanville? No, sorry, up before Judge Simpson. Before? Why is this news to Judge Simpson? Why is this news?
That now you're saying is nothing regarding this property.
That's correct, Your Honor.
Then why are they involved in an email chain?
This email, so Ms. Stevenson, I would say, was speaking to a realtor. This realtor reached out to this person they believed to be the real estate agent for this property, although that wasn't the case. And they had a discussion of this email that both Ms. Stevenson and I were.
Turn off that phone.
And no, go ahead.
Yeah, this email that we were both a party to verifies what that discussion was, and that they, what they believe the intent of that discussion was.
If I could clarify one thing, Your Honor. In the email from counsel, it clearly states in the email that I had submitted with a motion for the recommendation was for me to send the offer letter to this individual in particular, and then.
This person who now is being claimed to be nothing.
Yep, exactly. That's.
I do have
Well, okay, hold on, folks. This may make sense to you, it doesn't make sense to me. Why would she be sending an offer letter to somebody who really has no affiliation to the property?
Oh, I was thinking he would communicate that offer to the home. Should there have been an offer? Because I'm not.
Then right, but is. Okay, Mr. McCurdy, that's part of my problem. Part of my problem is this person and your client may be saying they have nothing to do with the property. Apparently, the defendant believes they do and is operating with some apparent authority. And you yourself also may not know what that position is, but like you said, I'm not a realtor, but this person is doing something. And the very fact that the person is a realtor, I think that there certainly is the potential for some confusion regarding that. And I think that's part of my
I do have more recent communication as of yesterday with the same person.
With who?
With that same realtor and my realtor and the lender.
And the lender?
So if Your Honor, if I
Go ahead.
clarify, I have an email right here between all parties just clarifying what has happened in an email. And the email includes her realtor. This email chain includes an email from her realtor, back and forth. I believe it's relevant.
Okay, but Mr. Mukherjee, the very fact that all of this needs to be clarified, isn't that a problem?
So, Your Honor, after I spoke to Ms. Stevenson yesterday, she made it clear that she was gonna believe that she's been misled here. So I reached out to the realtor to see what was going on.
Right.
If she hadn't been misled, if there was discussions with the loan officer, if there was discussions with a fellow realtor. And what he described to me was something close to what we're talking about here, but not, but missing the target by a little bit. He believes this was a last minute attempt to confuse the situation and stay the eviction. And he clarified that in an email because the realtor who reached out to him had not signed an agreement with Ms. Stevenson. It was just an informal discussion about what, if that property were to be for sale. Now, he clarifies in the email that I have in front of me that he doesn't know where these numbers are coming from and that he.
What numbers? The offer?
Yeah, correct, Your Honor. Because no discussion had ever occurred about what that listing price would be. No discussion occurred about a wire transfer.
Okay, all right, but counsel, something's going on. I have two realtors on opposite sides, regardless of what their authority is. All right, I have two realtors, and then at some point, according to the defendant in this case, there are communications with a lender. That.
Oh, yeah.
The
Go ahead.
realtor the realtor who's standing on the plaintiff's side had I don't believe had any communications with the lender for Ms. Stevens.
Is that right or no?
I have email here with Kirk Glassel in communication, several phone call, or a few phone calls, I should say several, with my realtor, and she was relaying information between him to the lender. And there's including the good faith deposit, the amount of that, including something about a back rent that and all of these other components that would,
Okay. Okay, that's my concern. It may very well be, Mr. Mukherjee, that your client gave no authority for this person to act in this fashion. But what's clear based upon the representations of the court is that they were. And I don't know.
It looks like it. Yeah, it seems like girlfriend/tenant trying to pull something off here. Oh, well, when I told you when we started looking at this, Judge Simpson's landlord-tenant court, sometimes shit goes down. Sometimes shit goes way down.
Ms. Stevenson has been putting forth since the conditional dismissal that she was wanting to purchase this home.
Mm-hmm.
After the affidavit went in with the order, I received this email saying, I've been approved for a mortgage. I'm going to try and put together an offer for this home. If any of those things are true, I don't know. Beyond that, no communications until the writ was posted to the door. And then all of a sudden this started as of last Thursday or Friday. If Ms. Stevenson would like additional time, we're happy to accommodate her. We can make any arrangements she finds like reasonable. But I don't believe the writ should be overturned.
Oh, Judge Simpson is not happy. Oh. Oh, he's not happy.
Yeah. Evidentiary hearing. I didn't know when I could do it. When do we set the crime?
August, oh, no, man.
Okay. Afternoon.
This seems to be an accurate interpretation of what's going on here. She pretended to want to buy the home, get a realtor, no communications to owner, but tell the judge you want to buy, that's why you haven't left. Slow roll, scam, so she can stay for free. Yeah, that seems like what's been going on here.
Yeah. So
Okay.
Yeah, it's already at 1 p.m.
Got it. I understand. The problem that I see here is that there's something else that's going on, which, as the defendant has stated, led her to do or not do things. Plaintiff may have a different version that she's coming up at the last minute, doing whatever. Regardless of all of that, I have two realtors. I all of a sudden have a lender involved. I would just say that if Miss Stevenson has gone to those extremes just to delay, it's a lot. I don't think that that's what she did. I don't think the communications that I've seen and the ones that are being described are that. Something, rightly or wrongly, it seems to me, was represented to her regarding the sale of this property. Okay.
Property was never listed. That's
right, but I don't.
Okay.
I hear you, but if you had your, from the plaintiff side, your everyday run-of-the-mill property manager, not a realtor, they're just managing your property, make sure that repairs are done, collect whatever, okay? And she's having discussions with that person, then I might tend to agree that there's not enough there doing anything. This is different because this person's a realtor. And by the way, I don't think somebody goes up when somebody's a realtor and say, do you have the listing? I mean, I don't know that comes out of anybody's mouth right out of the gate, unless it's the realtor that says that to somebody. You assume that they have the ability to sort of move in the way that they're moving, right? So I get it, but something transpired here that either Miss Stevenson was misled potentially, or something occurred where she just didn't understand it and how the transaction was going to go.
Or it's the other way around.
Or something. I think for your client, Mr. McCurdy, I don't know if she knows what the heck has transpired. Because somebody is apparently, well, I'm not making this conclusion, but at least from Ms. Stevenson's perspective, somebody is acting on her behalf or their behalf. And it's just, it seems to me doing things and making things that may be representations that have to stick to your client. But I don't know. Now, having said that, other problem, Ms. Stevenson, that you have is typically any agreement regarding the sale of property would need to be in writing, right? But so there may not have been an agreement, and that may be this court's ultimate conclusion. But I also realize that there are discussions that happen before there's any writing that's put into place. I mean, just in a practical sense. So from what I've seen today, I think it would be improper and prudent on this court's part to to allow the writ to be executed. So at this juncture, the court is going to stay the order of eviction of the writ in this case. I'm going to order an evidentiary hearing on the issue regarding a sale. I will set that for August 11th, and I apologize for pushing it out to that point, but my docket is what my docket is, folks. And I'm going to try to take a vacation, or at least not be here. So August 11th, 2025, I will set that at 2 p.m. Okay, there's a criminal evidentiary hearing ahead of you, and I've got to take care of the criminal matter. But in the interim, I might suggest that the parties try to talk to get straight exactly what's transpiring on the plaintiff's side and what may have been said. Ms. Stevenson, you also, and one of the things that you said this morning is that you hadn't had time to make alternative arrangements regarding yourself. So I might suggest that you at least have a plan B, because I don't know what I'm going to rule on this. All right?
I agree.
All right. Thank you, folks.
Thank you, Your Honor.
Thank you.
Why?
They're written on that signs.
No, I'm going to give it to.
I actually think here that Judge Simpson. Now we don't have access to the communications as Judge Simpson has in their filings, but yeah, I think he got it on the face of it. I think he got it switched around, but who knows? Who knows? Hi, Dave. No, we covered the hyperbaric chamber case the first hour. You're late. You're late, Dave. So now, as we are awaiting the next hearing, I'm expecting, we are checking in on Judge Simpson.
Why are you up here?
You don't put that on the front, yes.
This is that one.
Yeah. However, she filed more stuff.
Okay.
Yeah.
Thank you. Court does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
So I'm
Morning, Your Honor.
Good morning, sir.
As I said, I'm expecting another hearing. I think it's the latest I saw. It should begin at 11, which is in 10 minutes. Once it's up and running, we will go over there. But for now, let's check in on the landlord-tenant docket. And I said it in the beginning. These things get spicy sometimes.
Morning, John.
Good morning. State your appearance, please.
Right. Ian Redmond, P 70599 on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
All right. Why
So
are you there?
what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the.
What? Claim to be a tenant, then file bankruptcy to stay. Now the bankruptcy is lifted, and here they are again, apparently.
Case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud BMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding Rule 4001A3, a bankruptcy rule,
right.
Creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
Wow.
All right.
So my interpretation, she's a squatter who then, in order to avoid being thrown out, made a lot of claims. Those were, of course, rejected, and then she filed for bankruptcy. And in bankruptcy, everything against a person gets stayed until the bankruptcy case is ruled upon. And it seems like the court said, go fuck yourself. We're lifting this back to court. That is my interpretation of this. 2 in a row. 2 clusterfucks in a row. I said it. Judge Simpsons landlord-tenant docket gets spicy sometimes.
Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order.
Of course she has.
In the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay. And that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor.
Yes, go ahead.
Additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case, and in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that
Seems like we have a professional scammer there.
need that because I'm not.
The reason that I mention all of this, Your Honor,
go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Oh, that's an interesting way to force her.
Yes, Your Honor.
What do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear, specially and conditionally, for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well,
she's a sovereign citizen. Oh no. Oh, please tell me she's a sovereign citizen. Oh, wow. What did we get ourselves into? What did we get ourselves into? Oh, this is amazing. Poor Judge Simpson. You can see on him. Oh no, I didn't want this today. Oh, this is amazing.
Then you are not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh.
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and then you can go challenge it. With who?
With Whitlow. Ms.
Then
Whitlow,
you need to go against Miss Whitlow.
Oh, I assume her and Miss Whitlow are the same person. And she's trying to scheme this by using an alias and then having a lease with that party. And now she's trying to insert herself as a named party. No, as Judge Simpson said, if you're not a named party in this case, fuck off. Well, he's using his own words, but yeah.
Pardon
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that that I stated that I'm not, I lost my spot, not consenting to this court's jurisdiction. So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay.
So this might be a default judgment. Oh, ha, just because she thought I'm going to walk in as a separate person. Yeah, no, not working, not working. This is not the first rodeo for Judge Simpson.
If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You're not a named party. You're not a named party in this.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay.
or whatever the heck you're doing.
Well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
Oh, this is going to be a separate video.
okay, I'm not really understanding, but
No, because you're a dumbass.
Well, let me put it a little bit more simply. If I grant the relief of the plaintiff in this case and grant an order of a judgment and an order of eviction in
Okay.
10 days,
okay,
any claim of your interest in that property, you have to go after the Whitlows because that's the only person you have a contract. Allegedly have a contract with.
okay. No, there is an actual contract.
I don't know that, man.
We've actually been.
I don't know that.
Okay, I know you don't know that. 'Cause it's not before you.
Correct.
I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. again. Stated to
Again?
me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract, but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have rights on the property.
Okay.
Oh, she's not giving up. Oh, lady, go away. Move out. Fuck off. Oh, this is funny. I told you guys, Judge Simpsons court, landlord-tenant court,
All right, Your Honor, I will
shit happens.
speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
Oh, I think
Based
I'm
upon
going
the
to stay with
representation of
Judge Simpson
counsel,
for a
I'm gonna
while.
grant their motion to reopen this case. I'm going to issue a judgment in the plaintiff's favor for possession with a writ to issue 10 days of my signing. Should the matter be appealed, also contained in that judgment and order, the appeal bond I would set at this time at a rental rate or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Oh,
Thank you, Your Honor.
All right.
I will prepare that.
Oh, Judge Simpson, let's make sure. Let's make sure. $15,000 a month. Oh, yeah. Yes.
Presented to you this morning.
May I say something? Our lease payments was not that high at all.
Not his problem.
I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
That is, you need to get the Whittlers in here, which will be very, very hard because you're probably Hitler. So she has to come in as her alias. Look at the smile on Judge Simpson. He knows exactly what he's doing.
Thank you.
Thank you.
Thank you.
Oh, that was amazing.
I know you didn't write it.
We'll await. I did.
Oh,
No.
no, I don't think so.
I don't know if Mr. Fink is ready on.
Mr. Fink, are you ready? But hold on. I'm going to take about a 10-minute break because my head is hurting right this minute. Well, it's not hurting. I mean, I could go on, but I need about 10 minutes after that.
Thank you.
Court's in recess.
Oh, wow. Oh, that was amazing. Oh, this is so going to be a separate video. Oh, oh, yeah. So she allegedly, as an alias, rents this $1 million property, and shenanigans ensues. He probably doesn't pay rent at all. And they have been trying to get rid of her for quite some time. And in this scheme of hers, allegedly, she then filed for bankruptcy, which means everything goes to stay. They can't continue with the eviction. Then the bankruptcy court said, fuck off. And now it's unstayed. And then she tries to go to court as herself, renting from herself under another name to get this. And she had no standing whatsoever. So this was more or less a default judgment, which Whitler or whatever the name was, now they can come in and appeal, which will be a problem for this lady, because then she has to come in as her alias. Now, I would not be surprised if we, in a later landlord-tenant hearing, will see her come in as her alias and try to... Oh, that was amazing. Yeah, I'm going... Yeah.
Go ahead.
Good morning, Your Honor. Ashley Lundy for the people. Your Honor, at this time, people would waive any conflict in this honorable court in the office of the public defender. People do not believe that any conflict exists and agree the avoidance of all doubt.
Good morning, Your Honor. Intern Malaika Fatima requesting to practice under MCR 8.120 under the supervision of the Deputy Chief Public Defender, Lauren Brown.
You know, you having to ask permission. This now takes really a long time. It's okay. Permission to practice is granted. Go ahead.
Thank you, Your Honor. We do not believe there is any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
Oh. The court, for its part, does not believe that a conflict exists either in Michigan court rules or the cases decided thereunder. To the extent that the conflict does exist, given the waivers, the court will consent to hear the matters. The court does call the case of the people of the state of Michigan versus Ronald Fleming.
Good morning, Your Honor. Ashley Lundy for the people.
Stephanie Canna on behalf of Mr. Fleming, who should be appearing via Zoom. Yes. Mr. Fleming, could you state your name for the court?
Ronald Fleming.
Thank you. Your Honor, today's the date and time to go over the competency evaluation, or I'm sorry,
Competency review.
the report. And the report has been provided to me. I do believe the prosecutor has a report.
I received it, Your Honor.
And in the report, it is indicated that my client is not competent, but they do believe he can be restored to competency within the statutory timeframe. So, Your Honor, we are asking, we will stipulate to those findings, and we are asking for another hearing regarding competency.
And Your Honor, I'm sure the court recalls we've been pending competency for quite a while on this file, but the defendant, I do believe, was admitted to the forensic center in June. So he's been there now for about a month and a half. So I'm optimistic that we may actually be able to get the treatment restored and done at this point. I would request also an adjournment and would stipulate to the findings in the report as provided to myself, defense, and the court, and ask the court to continue the order for his treatment and allow him to attempt to regain competency.
And just so that we're all clear, the report that I'm looking at is the July 15th report. She needs this.
Yes, Your Honor.
Yes, Your Honor.
All right. Based upon that report, the findings are, and it's been stipulated to by the parties, that the defendant still remains incompetent to stand trial at this time. The court will then continue that finding. And I will set a review hearing. Give me 90.
October 16th. 9 a.m.
October 16th, 2025, 9 a.m.
Thank you very much, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Fleming.
Thank you.
Court calls case People versus Tariq Wilson.
Stephanie Canna on behalf of Mr. Wilson, who should be appearing via Zoom. Mr. Wilson, could you please state your name for the record? Mr. Wilson, could you state your name for the record, please?
Mr. Wilson, can you hear us? Not sure if he can hear us or not. I heard. All right. I'll pass him. Hear us. Court does call the case People versus Carista Riopel.
Good morning, Your Honor. Requesting permission to pursuant to Michigan Court Rule 0 under the supervision of a actually long.
Oh, really? Okay, Commissioner Practice.
Thank you, Your Honor. Christina Berger, for the people.
Morning, Judge Mike Gaddy, Assistant Public Defender on behalf of Ms. Riopelli, who is here via Zoom. If you could state your name, ma'am.
Carista Riopel.
Your Honor, I have had a chance to speak with Ms. Riopel, and we are asking to adjourn this matter so I can visit her and go over the mitigation information that we have prepared. I'd like to do that in person with her. So I'd ask the court for a couple of adjournment so I can accomplish that.
So you want 2 weeks or 3 weeks out?
Maybe 3 weeks, Judge.
August 7th. I think it's probable cause conference will be adjourned August 7th, 2025, 9 a.m.
Thank you, Judge.
Thank you.
Continue. Thank you. Court calls case People versus Amanda Scardutz.
Morning, Your Honor. Maria Burton, Assistant Prosecutor, appearing on behalf of the people.
Good morning.
Good morning, Your Honor. Kelma Dadush on behalf of Ms. Skardautis. Ms. Skardautis, can you please state your name for the record? Oh, she's not unmuted.
I don't know if she can. Where
Amanda?
she's at MDOC.
Can you try to see if someone can unmute you at MDOC?
You're trying to force it. Oh, we got her. Ma'am, can you state your name, please?
Amanda? Can she hear us? Amanda, can you please say your name for the record?
I don't know if she can hear us.
Earlier, did you be?
Yeah, but she's not responding. They're at different facilities, correct?
No.
Yes.
Oh.
Yes.
The two that couldn't hear me, because I got two
Oh.
that are unmuted but cannot hear me. All right, I'll pass that matter.
Thank you, Your Honor.
You'll contact or try. Court does call the case People versus Mariah Thomas.
Kelma Dadush on behalf of Ms. Thomas. Ms. Thomas, can you please state your name for the record? Same. Okay.
Ms. Thomas, if you can hear me, if you can wave your hand, I would appreciate it. Yeah, I'm not getting.
My name isn't Miss Thomas.
Yeah, I was gonna say, I don't think that's her.
Okay, what is your name, ma'am?
My name is Anitra Coomer.
Got her.
Judge, she was adjourned via step.
He was adjourned.
And Ms. Coomer, just for the, I'm coming to see you on Monday.
Okay. Yeah. Okay.
All right. Sorry about that. I
Okay.
guess it was adjourned
That's
via
fine.
step. Thank you, ma'am.
Yeah.
Maybe they can put Amanda in that.
Pardon? So do we have Miss Thomas?
So that was Miss Thomas because.
Yeah.
Yeah, so no, we don't have.
Okay. This is going well.
Well,
So you want to adjourn that out?
well,
Was she,
Miss Thomas's?
pardon?
No.
Is Miss?
Miss Thomas is only MDOC, days of behavior 11, when that facility signed.
Oh.
I can come get-
Okay, so she's at 11.
Yes.
We are adjourning Amanda. I think she has to say her name for the record anyway.
Yes, she does.
Okay, thank you.
Well, I have to make sure it's her too.
I believe that is her.
Amanda? I just don't know why we don't have. That's it, Huron Valley.
Yes.
See if you can get through to them. Court does call the case of the People versus Donnell Young Senior.
Good morning, Your Honor. Jeff Dean, Special Assistant Attorney General here on behalf of the people.
Good morning.
Morning, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Young, who's here to my right. State your name, Mr. Young.
No.
What are we doing?
Your Honor, I did have a chance to communicate with Ms. Williams from the AG's office. At this time, Mr. Young would like to set this matter for the preliminary examination.
All discovery is complete.
Yes, Your Honor.
The people have their witnesses available the 29th.
29th, yes, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That's before Judge Barr.
One thing, Your Honor.
Bond will, thank you. Bond will continue.
Thank you, Judge.
Your Honor.
You have a question, sir?
Oh, yes, Your Honor. I just wanted to make sure that we repeat it again on the record that we've made a pre-preliminary exam offer, and as of the date of the preliminary exam, we'll be withdrawing that offer. Just want to make sure the defendant is very clear about that. Thank you, Your Honor.
All right. Understand
Yes,
that.
yes, we have gone over the offer, Your Honor. It's the people's, I don't want to say standard, but the offer that they generally make.
Okay. And you understand that if it proceeds to prelim, it will be withdrawn.
Yes, sir.
All right. Very good. Thank you.
Thank you. Good morning, Your Honor.
Thank you. You too, sir. Court calls the case, People versus Hector Gonzalez.
Prisoner hearing for the people.
Morning, Your Honor. Michael Vincent on behalf of Hector Gonzalez.
Good morning, sir.
Mr. Gonzalez, put your name on the record. Hector Gonzalez, Your Honor.
Thank you.
Your Honor, today's date, time for probable cause conference. We wish to have a prelim exam on this matter.
All right. And all discovery is complete.
Yes.
We'll have their witnesses available the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Washington. Who are you? No, I'm kidding. I'm kidding. I just haven't seen you in a while. I didn't recognize you. The 29th is not. Any objection from the people if I go to the next day?
We're gonna check, make sure he's there. Okay. Just make sure. Yeah.
Set preliminary examination August 5th, 2025, 9 a.m. before Judge Freshour. Bond will continue. Thank you.
Thank you, Your Honor. Thank you, Your Honor.
Court does call the case of People versus Jessica Hafner.
Your Honor, after the order requesting permission to cap this under MSR 8.120 under the supervision of the AG.
Who? He has an intern?
Yes,
He does?
very good.
He's not old enough. All right, permission to practice is granted.
Thank you. I've got a nice phone report.
Thank you, Your Honor. Today's the date and time set for probable cause conference. We are just asking for a brief adjournment at this time. The court should have the.
Did you state your appearance?
I'm sorry, Judge Cabral on behalf of Ms. Hafner. Ms. Hafner, please state your name for the record.
Jessica Hafner.
Thank you.
Judge, we're just asking for an adjournment.
You're looking for an adjournment of this?
Yes, Judge.
All right. You want the 31st or the 7th?
The 7th? The 7th, please.
Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond continues.
Thank you, Judge.
Thank you, Judge.
Wait on the hallway for me. Let me talk to you.
Mr. Wilson, can you, where's Can you hear me, sir?
Yes, sir.
Okay. I think something happened the first time, so let me call your case. Court does call the case, recall the case of People versus Tariq Wilson.
Stephanie Cannon on behalf of Mr. Wilson, who is appearing by Zoom. Mr. Wilson, could you please state your name for the record?
Terry Wilson.
Thank you. All right, what are we doing?
Your Honor, I do believe I turned in a German form on this. When I attempted to make contact with him, MDOC let me know that I had to go through a lengthy process. I've started that process. He can add me to his phone call, to his visitations, and I should be able to speak with him. But in the meantime, I have filled out the application, turned it in, and I'm waiting to get approved as somebody who can come to the jail. So I'm asking for an adjournment. I do believe I asked for a 3-week adjournment because of the process.
That objection, probable cause, August 7th, 2025. Thank you, sir. Court does call the case, People versus Rahman Mohammed.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
Kyle Burdell on behalf of Mr. Rahman. Mr. Rahman, please state your name for the record.
Rahman Mohammed. All right.
And Your Honor, we will be waiving the preliminary exam today. I have a form I'm going to ask Mr. Mohammed to sign. All right.
And sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses are committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on both counts. Your turn.
Judge, this time, waive formal reading, stand mute.
Defendant having waived formal reading, standing mute to both counts, court will enter a not guilty plea. Pretrial will be set for
With Judge Covey.
July 29th, 2025, 1:30, Judge Covey.
Thank you, Judge.
Thank you. Bond will continue. Lee, can you her sign off on? Court does call the case of the People versus Matthew Brown. Matthew Brown?
Yes, I am here, Your Honor.
Correct. Ms. Constantino?
For some reason you can't get through.
Sorry, Judge. I hit the wrong button. Good morning, Your Honor. Christina Costantino on behalf of Matthew Brown.
Hey, good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
All right. And what are we doing?
Your Honor, I was just recently appointed to Mr. Brown's case, given that we would be asking for an adjournment of the probable cause conference.
All right. Probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond will continue.
Thank you very much.
Thank you.
Thank you.
Amanda. Court recalls the case of People versus Amanda Scardudos.
Yes, sir. Yes, sir.
Here's now.
Good morning, Victoria Burton here, Chief Assistant Prosecutor again appearing on behalf of the people.
And Kelma Dadush on behalf of Ms. Scardudas. Ms. Scardudas, can you please say your name for the record?
Sure, my name's Amanda Lynn Scardudas.
Thank you.
Your Honor, we have come to a plea agreement. Unfortunately, we came to that agreement after the plea form was due, so we're asking for a very brief adjournment so that we can have that ready for the next court date.
2 weeks out, that was July 31st, 2025, 9 a.m. Bond continue.
Thank you. Ms. Scardudas, I'll talk to you, okay?
Okay, thank you so much. Y'all have a very wonderful day.
You do the same. Thank you.
Thank you.
Here, he'd shoot it. You're not gonna. Darn. All right. Court does call the case, People versus Andrew Patton.
And then on behalf of the people, Your Honor.
Good morning, Your Honor. Christina Costantino, appearing on behalf of Mr. Patton. Mr. Patton, can you please state your name for the court?
Mr. Patton. Thank you. What are we doing on these?
Your Honor, with regards to the case number ending in 5110, it's my understanding that discovery is complete to my knowledge, and we would be asking to have that matter set for a preliminary exam. But with regards to his other matter ending in 5154, I have just been appointed late last evening to that matter, so I would be asking.
In the case ending in 5154, probable cause conference will be adjourned to August 7th, 2025, 9 a.m. Bond on that matter will continue. On the other matter, would the people have their witnesses available? Would the parties be available? Will the 29th work, or did you need another day?
The 29th will work, Judge.
Examination in this matter will be set in person July 29th, 2025, 9 a.m. That's before Judge Washington.
Thank you very much, Judge.
Thank you. Bond will continue.
Thank you, Your Honor.
Thank you. Calls case, People versus James Williams.
Christina Costantino, appearing on behalf of Mr. Williams. Mr. Williams, can you unmute and state your name for the court?
Yes, ma'am. James Williams.
Your Honor, this is a date and time set for a PCC. We have been working on mitigation, but our mitigation specialist does need some additional time to complete a mitigation report, given that we would be asking for an adjournment of the PCC.
That objection, August 7th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge. Have a good rest of your day.
Thank you. You too.
Thanks.
Court does call the case, People versus Richard Atkins.
Brown appearing on behalf of Mr. Atkins.
Morning, Mr. Brown. Your name, sir?
Kiwan Atkins Richards.
I'm sorry, Your Honor, I was listening for Kiwan. I didn't realize that was him. If you're Richard McDuffie for the people.
All right.
We'd ask the court to set this for examination.
Discovery is complete.
Your Honor, I have a request from counsel for the 911 call. I believe that will be here by some point next week. I just want to confirm, since Mr. Atkins Richards is a co-defendant along with Mr. Correll Brown, who's represented by Mr. Kilroy, that counsel is seeking to hold separate exams in that whole exam.
Separate exam.
When is that other one set?
Mr. Brown is up for his first CCC probably right after this record from today's time.
We'd like the earliest date possible.
Judge, just for the record, Robert Kilwell, I was just appointed, I met with Mr. Brown last night and he wants to proceed to exam.
All right.
Just for your info.
Very good. Preliminary will be set July 29th, 2025, 9 a.m. That is before Judge Barr.
Thank you.
Bond will continue.
Thank you.
Case, People versus Bianca Rowell.
Morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor, again appearing on behalf of the people.
Kyle Burrell on behalf of Ms. Rowell. Bianca, please state your name for the court.
Bianca Rao.
Your Honor, Anali is en route to your staff.
All right.
And so I don't think that we need to worry about this matter much further.
Okay.
Before it could get to you, unfortunately, I'm sorry.
That's fine.
Okay.
Any objection to the dismissal?
What do you think, Bianca?
No.
No, Judge. No objection on this one.
Case is dismissed. I'll sign off on that when we. Court does call the case, People versus Correll Brown. He's the co-defendant.
Yes.
Hey, did I get 29 bar?
Good morning, Rob J. Kill on behalf of Mr. Carl Brown. Carl, would you state your name?
Correll, bro.
Judge, I would, like I said, I was disappointed, but again, we met last night for a significant period of time. I do have the discovery. He's seeking a preliminary exam in this matter.
All right. People have their witnesses available on the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
Thanks, Judge.
Your Honor, just confirming again for this record, since Mr. Brown requested a separate exam, that these are on the same.
I'm going to let Judge Barr decide whether or not the exams are held jointly or separate.
Okay.
I put them both before him. He can make that decision. Thank you.
Thanks.
Court calls case People versus Taylor Adams.
Assistant Public Defender Jay Bellinger on behalf of Mr. Adams, who approached us. Mr. Adams, can you please state your name for the record?
Taylor Adams. Thank you.
Your Honor, I am just requesting a 3-week adjournment for purposes of completing mitigation and having that reviewed by Ms. Londy.
Without objection, August 7th, 2025, 9 a.m. bond continued.
Thank you, Your Honor. I will be giving you a copy. Thank you, Your Honor.
Court calls case.
Rob J. Kill on behalf of Mr. Would you state your name for the record?
Kimani him.
Judge, I met with him last night. There's a lot of issues that we have to discuss. I'm asking for a brief adjournment.
Probable cause conference will be adjourned to July 31st. Deity.
Absolutely, good people.
This is the Judge Simpsons on behalf of Mr. Al-Daishi. He's now approaching.
Rahman al-Dar. Anti-pockets.
Go ahead. What are we doing?
At this time, Your Honor, we'd be saying this matter for a preliminary exam. To my knowledge, all discovery is complete.
People have their witnesses available on the 29th.
We'll try, Your Honor.
Preliminary examination in person, July 29th, 2025, 9 a.m. That is before Judge
Washington.
Judge Washington.
Thank you, Your Honor.
Thank you. Bond continued. Court calls case People versus Demond Bransford.
I'd like to class him up here on behalf of the Demond.
Pardon?
State your name for the record.
Demond Bransford.
Thank you.
Your Honor, at this time, we would like to waive over to circuit court.
Sir, is that correct?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants found over to circuit court on all 3 counts. Your turn.
We acknowledge the information and receipt of the information.
Then have you wait for more reading. Standing mute, court will enter a not guilty plea. As to all counts, pretrial will be set for
July 30th at 1:30 with Judge Conlon.
July 30th, 2025, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
Court does call the case of the People versus Amar Amadou. So I don't get to yell at her, I get to yell at you.
No, I'm sorry. She just kind of handed them off to me, Your Honor, and left. So, I'm sorry. What was the name, Your Honor? Yes. Thank you, Your Honor. Student Attorney Kara Rosingen requesting permission to practice under Michigan Court Rule 8.120 under the supervision of APD Hannah Apple on behalf of Mr. Amano.
Permission to practice is granted.
Thank you, Your Honor.
Where's your client?
I'm sure I don't have any idea. I'm sorry, you'd have to ask Miss Cannon. You'd have to ask Miss Cannon.
I'm going to reiterate, I'm sure I have no idea.
But we are asking for an adjournment in this case, Your Honor. We're requesting a 2-week adjournment.
You can hand me that. It's not gonna happen. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Court does call the case of the People versus Troy Brumfield.
Assistant Public Defender Hannah Ashwell here on behalf of Mr. Brumfield, who's approaching now. Mr. Brumfield, will you state your name for the record?
Troy Brumfield.
Thank you. Your Honor, Mr. Brumfield wishes to waive his preliminary exam today.
All right. Is that correct, sir?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Thank you. Your Honor, defense would acknowledge receipt of the information, waive reading, and my client would stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Simpsons.
July 28, 2025, 1:30, Judge Hamoud. Bond will continue.
Thank you.
Sign off. Court does call the case, People versus Dominic Billing.
Student Attorney Kara Rosengren on behalf of Mr. Billings. Could you say your name for the court?
Dominic Billing.
Your Honor, Mr. Billings is going to waive his right to preliminary exam today.
All right. Sir, is that a correct statement?
That is.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes. I do.
Understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Mr. Billing waives formal reading and stands mute, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
September 8th at 1:30 with Judge Simpsons.
September 8, 2025, 1:30, Judge Hamoud.
Thank you, Your Honor.
Bond will continue. They're gonna need that. I didn't pull it out. Court does call the case of the People versus Robin Finn.
And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Ms. Finney, who's approaching. Ms. Finney, can you state your name for the court?
Yes, Robin Lee Finney.
Thank you.
Thank you. And Your Honor, I apologize. I do have a green sheet. I am requesting an adjournment, a 2-week adjournment in this matter for continued discussion with the APA.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case of the People versus April Black.
Stephanie Cannon on behalf of Black. April Black.
Thank you.
And, Your Honor, in this case, we are asking for a brief adjournment for mitigation purposes. My client has provided me some information. I need to provide that to the prosecutor's office.
Probable cause conference, April 7th, or August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor. August 2nd. Oh, you want to address the cover? Your Honor, may I address bond? I'm so sorry. May I address?
He's out.
What?
Go ahead.
Oh, I didn't hear what you said, Your Honor. I'm so sorry. Your
I'm
Honor.
happy to change it.
Oh, he's out.
Go.
You're not going to change it?
No, I don't know what you're asking.
Oh, so Your Honor, my client is currently on tether. We're asking that the tether be removed. I have reviewed her file and the information in this case. She is charged with malicious destruction of property and resisting an officer. The police report itself is replete with information that has nothing to do with her resisting charge. It's my understanding, since then, she's been very cooperative with the police regarding the situation that pulled the police to the scene, which was a shooting. My client wasn't a part of the shooting. She was a victim of the shooting, her and her mother. In their haste to get away, the police did stop them. And my client has allegedly done some behaviors where she destroys a little bit of property, maybe they'll say, and she's going to pay for that. She understands that she has to pay for that, and she did resist. However, my client in that time frame was exceptionally emotionally distraught from the shooting. Her whole thing was to get away from the scene, to leave. And yet somehow, some way, my client, and again, she's done photo, she's done lineup, she's done everything the police have requested of her regarding that shooting. She has no other criminal history. She's not a threat to the public. She's come to every court appearance, and she will continue to come to every court appearance. We're asking that the GPS tether be removed, Your Honor. In addition, it won't allow her to go see her mom when her and her mom were trying to get away from the situation. And so she's also confused as to why the court is keeping her from interacting with her mom when her and her mom were victims trying to get away from the scene.
Response.
Yes, Your Honor, I did your agreement on this, so that perhaps gives me a little bit more insight. So what happened here is, in my understanding, is there was not actually a shooting, it was an FA of Ms. Black's mother. And the reason that she has that color is that Ms. Black is accused of repeatedly trying to go to the home of the people she believed did that, which is just a few doors down from her mother. So there's no order that prevents contact with her mother. The order prevents contact with her mother because at the time this happened, Ms. Black was visiting her mother. And when the police responded, they actually used a lot of restraint with Ms. Black as far as they tried to just get her to calm down. They understood she was upset. She repeatedly told the police that she was going to the residence where the suspects were. And they kept telling her, no, you're not. And she kept telling them, yes, I am, and kept trying to walk over there. They had to physically stop her multiple times. Eventually, they ended up having her sit in the car, try to give her some time to calm down. When they let her leave from the car, she again said she was going there. And so, Your Honor, calm down as far as going to that location, that there was that concern for safety. So there's no attempt to stop her from seeing her mother and to keep her from going location that's just a few houses down.
Your Honor, and I'm sorry, because she just finished. I'm so sorry. Please continue.
So that's why she had the tether. There could not be a hot zone because Ms. Black lives so close to the location, and so to resolve that issue, it was a tether with a no-go instead of a tether with a hot zone. So that's why there's that.
Gotcha. And I don't see an order prohibiting contact with the mother, so I don't know where that.
So she goes there, she takes her children there. This is somewhere that she used to go every single day because she takes her mother there. She's not been charged for the felonious assault of anyone. She didn't go to those people's houses. She's not trying to go to those people's houses. She's calmed down a great deal.
But the allegation is that she tried to go there on that night, that she tried to alleged act.
Yes, Your Honor. So that is an emotional situation at that time. She's not that person, Your Honor. And she's asking for the court to give her the opportunity to show that that was a momentary lapse of judgment that she will not go back to.
Motion to modify bond is denied. Bond will continue. The GPS will continue.
Thank you, Your Honor.
Court does call the case of the people versus Antoine Brown.
And then on behalf of the people, Your Honor.
Antoine Brown.
Your name, sir?
Antoine Brown.
Thank you.
And your Your Honor, we are requesting a preliminary exam in this matter.
All right. All discovery is complete.
To my knowledge.
People have their witnesses available the 29th.
Yes, Your Honor, and I do believe as far as discovery, we did request the 911 call early this week, so it should be here prior to exam.
Okay.
Okay. Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge Bond will continue.
Thank you,
Thanks.
Your Honor.
Oh, you're on your work. Court calls the case, People versus Ibrahim.
Alexander, on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich, on behalf of Mr. Diakite and matters that end in 1232 and 1233.
Morning, I'm Rob J. Kilwell. Judge, I'm on 5153.
Okay, what are we doing? Sir, Mr. Dick, he's still muted.
Yeah.
Did you? Why is he brought up?
Oh, there he is. Sir, can you state your name, please?
Ibrahim Jakaite.
Okay. What are we doing?
In the matters that I represent, Mr. Diakite on 1232 and 1233, we will be requesting a set for a preliminary exam. To my knowledge, all discovery is complete in both of those cases.
Same with 5153.
You want an exam set?
Yes, Your Honor. I did meet with him last night.
So, people have their witnesses available the 29th.
We'll do our best, Your Honor.
Preliminary examination will be set in person, July 29th, 2025, 9 a.m. before Judge
Judge Washington.
Washington.
And Your Honor, when appropriate, my client would like me to address bond.
Go ahead.
Yes, Your Honor. Mr. Diakite would like me to request a release on tether. He does not reside at the same location as the complaining witness in the 1232 case. Prior to incarceration, he began working full-time as a caregiver. He'd like to be able to return to that work. He does not have to be, he has no patient or be able to return to court. He does have ties to the state of Michigan as he has family who resides within. So he'll be some reconnaissance bond for release on tether in his cases.
Your Honor, just two things on my case. I'm trying to figure out what the bond is. Does your the 23 case?
The 23 case bond is 1,010%.
All right, thank you, Judge. I would just echo that, Judge, request for bond. And again, this is a 23 case that happened in the jail.
Response?
Your Honor, I would object to any modification of bond. This defendant is looking at 3 cases here, and I'll focus each one by one. In his R&O case, he is an officer tried to stop the fight and told the officer that he was going to kill him when he got out of jail. At his next case, he was throwing rocks at someone's windows. Officers arrived, saw a motorcycle leaving, confirmed it was the defendant, and a pursuit began where he reached speeds of over 100 miles per hour in a 45-mile-per-hour posted zone. He was caught after his motorcycle had stalled, and the motorcycle turned out to be stolen. And then in his third case, him and the victim, who were working together, had a dating relationship. An employee at that restaurant called 911 to report that the victim had been dragged from the restaurant, kicking and screaming, to a car, and the colleagues at work had saw visible scratches on her face. And after being put in the car, the defendant then drove away, and the victim jumped from the car, and officers found her in the middle of the roadway. I also wanted to report that he has a previous DV conviction from 2023, and he currently has a hold from Delta County with bond denied. So I would be asking that bond remain as set in today's.
Anything else?
No, Your Honor.
All right. Given all those circumstances, motion for bond reduction is denied. Bond will continue in all 3 matters.
Thank you, Your Honor.
Thank you, Your Honor.
Court does call the case. The cases of the People versus Brian Gerard.
Appearing on behalf of Brian Gerard. Please say your name for the record.
Brian Gerard.
Your Honor, at this time, we are requesting to adjourn this matter for pending negotiations with the prosecutor.
Probable cause conference will be adjourned to July 31st, 2025, 9 a.m. Bond will continue in these matters.
Thank you, Your Honor.
Court does call the case of People versus
Carolyn Foster Tucker on behalf of Tamarian Jones.
Your name?
Good morning, Jones.
Thank you.
In a brief adjournment in this matter, I've talked to APA McDuffie and she indicates that there's an offer that we need to discuss. Your Honor.
Thank you. The People versus Hiram Haywood.
Ready.
Good morning, Victoria Burton here, People's District Prosecutor, again, here on behalf of the people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Hiram Haywood.
Your name, sir?
Hiram Haywood.
All right.
Your Honor, today is the date and time set for the probable cause conference. However, we are working towards drug court resolution. We need time to be able to put in a request so that we can make sure that he can be accepted to that drug court. So we're going to ask for a 2-week adjournment. By the time we
And I don't mind giving you the 2 weeks, but the timing that I was getting yesterday, I don't know that that's going to happen. To be honest with you, so I'm going to go. Certainly don't want to go so far out, but I'm going to go August 7th. Just one more week out. 2 weeks. August 7th, 2025, 9 a.m. His bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus the Rehab Brand.
Pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecutor Attorney Alexander.
So you're under supervision of who? So it's Zenda today? You guys made up? Okay, well, never mind. I don't know. Something Douglas was in the middle of it all. All right. Permission to practice is granted.
Good morning, Your Honor. Roba Hamden requesting permission to practice. I'm so sorry.
Now, it's okay. You're scared? Am I doing it?
I just my mind went blank for a
It
second.
did it? Mine does that too. Go ahead. Just hold it.
Requesting
Hold on.
Oh, okay.
Take a deep breath.
I'm breathing fine, Your Honor.
Apparently not.
My mind just went blank.
All right. All right. Just relax. Go ahead.
Good morning, Your Honor. Roba Hamden requesting permission to practice under MCR 8.120 under the supervision of Assistant Public Defender Jay Ballinger.
Okay, very good.
Sorry, Your Honor.
Oh, so it's his fault. I get it.
I don't know. I got thrown off.
It's Bellinger's fault. Trust me.
Probably you don't have to apologize.
All right. Your name, ma'am?
Zaria Brand.
Thank you. All right. What are you doing?
Your Honor, mitigation information was sent to Prosecutor Zenda for review. The prosecutor is seeking adjournment to review.
To look at all of that over. All right.
I'm sorry?
That needs to be reviewed and an answer given.
Yes, and they also wanted to speak to the claiming witness as well.
Pardon?
They also wanted to speak with the claiming witness.
Yeah. Okay. Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. I'm sorry about that.
Sorry about what?
My mind just went blank. I
No,
don't know.
it's okay. You made it through. The end of it. Court does call the case. People versus Justin Hodge.
Roba Hamden. I am here with and on behalf of Justin Hodge. Can you please say your name for the record?
Justin Paul Hodge.
Thank you.
Your Honor, we would like to set preliminary examination at this time, to
All right. Is all discovery complete?
the best of my knowledge.
All right. People have their witnesses available the 29th. Preliminary examination in person, July 29th, 2025, 9 a.m. before Judge Barr.
And then, when appropriate, we would like to address bond as well.
Of course you will. Go ahead.
Your Honor, my client is asking for contact with his 2 children to be reinstated. He advises that he would not need to be in contact with the claiming witness in order to do so.
Response.
Your Honor, we would object to any modification of bond. The defendant was on probation when this case occurred for another domestic violence case in Wayne County. He's currently being held out of Wayne for that. He currently has a hold out of Wayne for that DV with bond being set at 1,570. And this current case involves the defendant having an argument with his girlfriend, taking her phone and smashing it, and his admitted to throwing the phone. So at this point, we believe bond is set as appropriate.
Were the children there at the time?
They were.
They were present at the time of
The 2-year-old was present.
the 2-year-old. So one of the children was there. Any other? No response?
No, Your Honor.
All right. Motion for bond modification is denied at this time. Bond will continue with the conditions. Thank you. Across the case of the People versus Jamie Burke.
If you ever to make this. Emma Tadish on behalf of Mr. Burke, who is here in person. Can you please say your name for the record?
Yes, good morning, Your Honor. My name is Jamie Kaylee Burke.
Thank you.
Thank you, Your Honor.
Your Honor, we were going to be requesting an adjournment. We had the wrong phone number for Mr. Burke. We had his mother's phone number. That's how we have been reaching him in the past. She is now hospitalized. She was this week and still is. We were going to be asking for a 3-week adjournment. So until he's
August
able.
7th, 2025, 9 a.m.
You're wonderful, Judge. Thank you very much,
Thank you
Your
for
Honor.
saying that. Not everybody agrees, but I think you're right.
Honestly, thank you.
All right.
Clearly.
Thank you.
Really appreciate that. And it was for August 7th at 9 a.m.
Yes, sir.
Right here, correct? Same building, same
Same
floor?
building.
Fantastic. Look forward to seeing you. Thank you, Your Honor. I hope you have a good night.
Thank you, Your Honor.
Thank you.
Let's call the case People versus Kyle Humphreys.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Humphreys.
Okay, go ahead.
Hi, Your Honor. We'll be requesting a brief adjournment for some further negotiations. Mr. Humphreys we've been working on a release for treatment with him. I've been in contact with Sarah Stewart, and he may be released for treatment soon, so that may play a part in the plea negotiations.
And that's correct, Your Honor.
All right. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continue. Let's call the case of the People versus Frank Clark.
Emma Tadish on behalf of Mr. Clark, who should be appearing by Zoom.
Frank Clark.
Say your name again, sir.
Frank Clark.
I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of attempted resisting and obstructing a police officer. But the 1-year offense, upon a successful plea to that added count 2, count 1 would be dismissed. There is a prosecutor recommendation that indicates here of HIDA. That's the court's full understanding of the agreement.
Yes, Your Honor.
Yes, Your Honor.
Sir, can you please raise your right hand? He's gonna have to have more light where he is. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
State your name again, please.
Frank.
Full name.
Frank Clark.
Thank you.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes.
You also understand, sir, that while I'm taking your plea, it's froze. I don't. Well,
You still there? Not on my one screen. Okay. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court. You understand that, sir?
Actually, I didn't. Can I get a better understanding?
Judge Simpson will not be the judge who is sentencing you. You'll be sentenced in front of another judge.
Did you
Okay.
discuss that with your attorney, sir?
That was in one of the paragraphs. Yeah.
Yeah.
You did?
Yes.
Okay, so you understand that that's what will happen. I will be taking the factual basis for your plea, but Judge Perry will be the one imposing sentence.
Yes, I understand.
Okay, and you do understand also, since you had a question about that, that you do have a right to have the judge who takes your plea also sentence you and that you're waiving that right.
Yes.
All right. Now, understanding all of that, sir, do you still wish to plead guilty to this charge?
Yes.
To the charge of attempted resisting and obstructing a police officer, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You went over and a advice of rights form with your attorney,
Yes, Your Honor.
and you gave her permission to affix your name to that.
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that the trial rights, which are contained in paragraph 5, that you're giving up those rights as well as all the rights that are contained on that form.
Yeah. Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or on parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will,
Yes.
and because you believe that you were indeed guilty of this offense?
Yes.
August 31st, 2024, at the location of East William Street near Maynard in the city of Ann Arbor, Washtenaw County, state of Michigan, did you come into contact with police officers from the Ann Arbor Police Department?
Yes.
What happened that makes you think that you're guilty of this offense?
Body cam footage.
What happened on that day that was captured on the body cam footage that makes you believe you are guilty of this offense?
I heard the officer say it, talking to me.
Your Honor, may I go out there?
I was shot.
Okay. Mr. Clark, what is it that you did after the police officer tried to speak to you that makes you guilty of this offense?
I was running.
Running from?
Yes, I was running from the police.
Okay, so the officer tried to have you stop to talk to you?
It appears so, yes.
Does it appear so, or is that what happened, Mr. Clark? Were they trying to talk to you that day?
Yes.
Okay, and did you take off right after that and run away from them?
Well, yeah, I was running, yes.
Well, when the officer said your name, did he not?
No.
Okay, did he ask you then to stop?
Yes.
Okay, and when the officer asked you to stop, did you understand that the officer wanted to talk to you?
At the time, no.
Your Honor, we likely should have done a no contest. I believe he was intoxicated at the time that this happened.
So there might be some memory issues happening right
No,
Right?
not my memory. No, I recall, but
Okay, so here's what we're gonna do. No, so here's what we're gonna do. Where are you right now?
I'm in my home.
In Ann Arbor?
No, I don't live in Michigan.
Are you in Ohio,
Yes,
Mr. Clark? Okay.
Do you remember what happened that day
yes,
clearly?
yes,
Sir, do
Your
you
Honor.
clearly remember what happened?
Yes, Your Honor.
All right. So you came into contact with the officer. What did the officer say to you?
He said, "Let me talk to you for a moment," and he was talking to me and my brother.
Okay. When the officer said, "Let me talk to you for a moment," what did you then do?
I talked to him for a second and then I ran.
Okay. At the time that you ran, did you know that was the officer done talking with you?
No,
Okay, so you knew the officer still needed to talk to you and you ran.
yes,
Sir, you understand that if I accept your plea, that if you commit some type of misconduct between the time of this plea and the sentencing, that any sentence recommendation or evaluation of the case, the court would not be bound by. You understand that?
yes, sir.
All
Yes, Your
right.
Honor.
Okay. Is counsel aware of any other promises, threats, or inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Defense is satisfied, Your Honor. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 1st at 8:30 a.m. with Judge Perry.
August 1st, 2025, 8:30 before Judge Perry.
Thank you.
Bond continued. Thank you.
Thank you, Your Honor.
Court does call the case People versus Serrano Johnson. Serrano Johnson.
Permission to approach with the prosecutor.
Everybody want to put their appearance on and then ask?
Ron Brown appearing on behalf of Mr. Johnson.
Your name, sir?
Cyrano Johnson.
You may approach.
Address bond, Your Honor.
Well, what are we going to be doing on the case first?
I got your green sheet. I forgot to give it to you.
All right. You're asking for an adjournment of the proper cause.
Yes, Your Honor.
I'll give you a date moment depending on the outcome of your bond motion. Go ahead.
Your Honor, I've provided the court with a letter from Second Baptist Church, Reverend George Waddles. The pastor is present here in court today along with my client.
see you.
My client's
Hello,
family
Pastor.
members.
Go ahead.
If released, he would live at 111 North Adams, Apartment 1 in Ypsilanti. By profession, he's a chef. He's been a resident of Michigan approximately 20 years. Like I said, he attends Second Baptist Church. He also volunteers at Hope House. And Your Honor, he's a caregiver for family members. So he has a lot of things going on. He volunteers in his community. I understand from the last hearing that he was not candid with the court as to his consumption of alcohol. But and I'm
not candid would be an understatement. I mean, he just outright lied.
Well, I wasn't there.
That makes it no less a lie.
I'm asking you if you want to hear from him. A humble apology.
I will certainly hear from him, but not if he's gonna
sort of spew that garbage he was giving me the last time, because that's how he ended up in custody.
I apologize, Your Honor. I panicked. I apologize. Yes, I did consume.
Pardon?
Yes, I did consume, of course. But yeah, I panicked when I was talking to the guy. I apologize for our last encounter.
You consumed alcohol and when I tried to get you to just tell me that, you just lied to me. Right?
Yes, I tried to go back and you told me.
Pardon?
I tried to go back on it, but it's too late. I had already said it. So, yeah. I apologize, Your Honor.
So on the date that you drank, what happened?
What was the trigger? What made you drink?
Working on somebody's funeral arrangements and drink a couple beers, drink a few beers.
Okay, so did you have any O'Doul's?
At first, but
At first. Okay. How many O'Doul's did you have? Six. And then you had how many?
Labatt's about four.
Sure. Okay. Now you know that's different than what you told me.
I was trying to tell you, but you told Mr. Allen
You were trying to tell me what?
nothing. That's what I
No,
told
no, 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 no. Let me tell you what you said, because I remember it very clearly. You told me that you had six O'Doul's. I told you to get to the levels that you were, if you were just drinking O'Doul's, because you were insistent on that, you would have had to have a little over a case of O'Doul's. Remember that?
Yes.
Then, at that point, you realized, well, he looks stupid, but he's not. And then you started telling me that you had two beers. Remember that? What?
Yes, Your Honor.
And I knew, given the level that's on here, that wasn't true. Now, the other things that you told me was that you were in treatment. Remember that?
Treatment. It's trying to go to treatment.
Well, okay.
I'm just trying to.
I don't understand the question.
You said I told you.
He said at the last.
Did you or did you not tell me that you were
wasn't
in
there.
treatment or had started treatment?
We were looking for a place to go to treatment. That's where we're starting. We're trying to go. Yes. My insurance is different.
Let me ask you this. When you made the statement about treatment, were you trying to get this court to believe that you were in treatment?
No.
You're saying no?
Self-incriminate myself. I don't know what you want me to tell
You
you.
don't want to self-incriminate yourself?
I already don't.
So see, okay. And I know you know this, but I'm just going to remind you. That's what happens when you lie.
And I apologize.
I know a whole lot more than it appears that I know. And the moment you told the people at Community Corrections about O'Doul's, I knew you were lying. That was my first start. Now, if you can tell me that you can put down about a case and two or one beer, about 25 beers, and not go to the bathroom, because that's the only way that was going to happen with O'Doul's. Yeah, so that's was kind of the stupidity of the lie. And then it just got worse for them. Then you ended up going to jail.
I get it. Oh, I get it. So. How are you gonna get it? You have insurance to cover treatment?
We're working on that. We just changed insurance, so it's not clear about.
His family's here, Your Honor.
They're
Oh, I
working it
know
out.
they're here, but you told me, Mr. Brown at the bench, that he's got insurance that will cover his insurance. And I'm just asking, will his insurance cover treatment?
We're working on that now to get a definite, yes, it will cover some sort of treatment, yeah.
Anything from the people?
Your Honor, the people do believe that Mr. Johnson is in dire need of treatment. We do have some concerns after the statement today. He may still not understand the extent he needs treatment, Your Honor. And I did have a chance to look at the letter that Mr. Brown provided that was from Mr. Johnson's pastor. It is a lovely letter and talks about the lovely things that Mr. Johnson has done. And the people aren't arguing that Mr. Johnson is a bad person. At no point that we allege that. We're alleging that he committed a crime, and it would appear that perhaps the root of that could have been an alcohol addiction, Your Honor. And we think about treatment, that situation could reoccur. And it's not clear that Mr. Johnson understands that or the need for treatment. So we do have some concern there.
Anything? Johnson, here's what I'm gonna do. I'm gonna first of all adjourn his probable cause conference to August 7th, 2025, 9 a.m. With reference to his bond, I will set his bond at a $25,000 personal recognizance bond. On your release, you are to report to the Department of Community Corrections for placement on a scram tether because you were on a correct. You're going to go on a scram tether, so I'm going to monitor you 24/7 for any alcohol consumption. I'm also going to order that within the next 10 days, defendant is to be enrolled in treatment. He is to notify the court that and the prosecutor's office that he is in treatment.
How many days?
He's got 10 days to do it. If he doesn't get in, I'm issuing a warrant, or he might as well just come over to jail and turn himself in, quite frankly, because I'm going to issue a warrant and I'm going to have him picked up. You understand all of that, sir?
I do.
Thank you.
Thank you.
No, just, we'll do that. Okay. Thank you, sir. Court does call the case of the people versus Michelle Campbell. Campbell, can you state your name, please?
Yeah.
What's your name?
Michelle Campbell.
Thank you.
Your Honor, at this time, we are requesting for an adjournment due to a pending negotiation.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of people versus Antoine Coleman.
Good Chairman Dadush, with and on behalf of Mr. Coleman, who is approaching.
Thank you.
Your Honor, Mr. Coleman has completed his 14B recovery court evaluation. He was accepted as of 4 a.m. last night, so we didn't have time to do the plea. If we can have that would be great, Your Honor. Thank you.
Shortest I've got is the 31st.
That's okay. Thank you.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued. All right. Thank you, sir. Court calls case People versus Vincent Lambert. It's Mr. Brown's case. Ron Brown.
Ron Brown, thing on behalf of Lambert. Your Honor, we're requesting adjournment. I filled out the green papers.
What's the purpose of the adjournment?
Additional discovery.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court does call the case of the People versus Sean Cotton.
Stephanie Cannon on behalf of Mr. Cotton, who is appearing by Zoom, Your Honor. Mr. Cotton, could you please state your name for the record?
Great if we could hear you. You need to unmute. Thank you.
Sean Cotton.
Thank you.
Your Honor, we are going to go ahead and set this for a preliminary exam.
All discoveries complete.
To my knowledge, yes, Your Honor.
People have their witnesses available the 29th.
Your Honor, we'll try our best, and just for the record, I discussed with counsel that Mr. Cotton's offer that was previously extended is hereby rescinded.
Preliminary examination in person will be set July 29th, 2025, 9 a.m. before Judge
Washington.
Washington.
Thank you so much, Your Honor.
Bond continued. Court calls the case of the People versus Paris Lester.
Chairman Dadush, on behalf of Mr. Lester. Say your name for the record.
Paris Lester. You're requesting an adjournment.
Yes, please, Your Honor. Just to
Probable
continue.
cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Curtis Damon.
And Lori Yackey, Assistant Public Defender, with and on behalf of Mr. Damon. Mr. Damon, could you state your name for the court?
Yes, Curtis Mitchell Damon.
Thank you.
And Your Honor, I have been in discussion with the APA. I am asking for one more adjournment to get paperwork of Mr. Damon's progress, completion of inpatient treatment and progress of continuing treatment.
Probable cause conference, August 7th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court calls case People versus Anthony Miller.
Chairman Dadush, on behalf of Mr. Miller. Say your name for the record.
Anthony McGrail Miller. Thank you. You're requesting an adjournment.
Yes, Your Honor, and a chance to address one. Yes, Your Honor.
Probable cause conference will be adjourned July 31st, 2025, 9 a.m. Bond continued.
Your Honor, can I address one, please?
Go ahead.
Your Honor, Mr. Miller, I believe it's the second PCC, he failed to appear at his last court hearing, but he had been in custody in Wayne at the time. That's why he failed to appear. He was there from September to April, he told me. So we are going to be asking for either a reduction or a personal recognizance fund. Your Honor,
September to April?
Yes.
Yes, Your Honor.
He has a part-time job. He works at a gas station. He has a sister that he can go to stay with or a friend. But the only reason he failed to appear is because of that, and he will make us all future court hearing.
And how did he come back into custody?
A warrant that was picked up from released from Oakland County. I was released from Oakland County, and then,
This
they-
warrant was out.
right, they didn't pick me up, they released me, and then, they picked me up and,
So when were you released from Oakland County?
You told me September to April.
no, I was released from Wayne County, but I was picked up on a warrant in Oakland County after doing my 9 months from Wayne County. So I was picked up on a warrant from Oakland County 3 days prior to arriving here. And, Washington County when I was released from Oakland County, Washington County didn't, come to travel to get me, and they released me from Oakland County. And then I went to Wyandotte, and then my, officer was giving me a lift. And he asked for I gave him my name. He said, "Oh, you have to take care of warrant in Washington County." So he was giving me a lift. I asked him for a ride because I wasn't hiding anything. So he said it was protocol to get the name. So I gave my name. I wasn't hiding anything. He said, "Well, you have a warrant."
You didn't turn yourself in, I guess is my point,
Yeah.
right? You came into contact with the police. They told you had a warrant. They told you had a warrant. What'd you do? Did they take you into custody at that point?
Yeah,
They took you into custody, and that's how you got here.
right.
Okay.
But the reason I failed to come to report to court because I was in from September, but I understand what you're saying. So,
What do you understand I'm saying?
Cause I felt, after being released, I didn't.
You should have come down here and taken care of your warrant
What,
because you knew you didn't appear.
no, cause I failed to repair because I was in custody, but.
Once you were released, you didn't turn yourself in after, even though you had a warrant?
Right.
You knew you had it.
I didn't turn myself in, so, but I throw myself on the mercy of the court. I will report I'm not a threat to.
Are you on probation anywhere else?
In Wayne County.
You're still on probation in Wayne?
Yeah, from the release of my, 9 months that I did.
And what's going on in Oakland County?
Nothing.
What's the
Everything, they ran it concurrent. They ran my, sentence concurrent with, Wayne County for, the 9 months that I did. But as I said, I'm no threat to society to humanity. And, and I will make my court appointments. I'm not trying to, avoid the law or, my responsibilities. It was just that the hindrance was because, I was in custody, but, I feel myself.
Right, but then when you weren't in custody, you didn't come down here.
Your Honor, if I may add, having court cases in 3 different counties is likely a lot.
That's why you maybe should confine your criminal activity to one place.
Alleged criminal activity, Your Honor.
Well, they're not alleged anymore.
Your Honor, if you give him one more chance.
Yeah, I know.
Please.
I would ask you, can we follow on the personal bond that that I had? I will make all my court appointments. I'm not going to try to avoid it to come up in front of you again and say, well,
And he will contact us if he's confused or has a lot of court dates out of a lot of different counties. He will.
Where is he living?
He has a sister. He has a friend in Detroit that he could stay with, or his sister at I don't know how to say that. Wyandotte.
19783, still Detroit, Michigan.
And how do I know he can stay there?
Well, my probation officer, that's where
Go ahead.
My probation that's where my probation is located in Detroit, Michigan. So
how do you know that he could stay with his sister?
That's where my probation is.
Sure.
Was that the question?
It was.
Have you talked to your sister and she's allowing you to stay there?
Yeah.
Well, I would need some indication as to exactly where he's staying before I'm gonna even consider a release. So at this time, motion for bond reduction is denied.
Thank you, Your Honor.
Court calls case People versus Jay Dingman.
Public defender on behalf.
Ding. Your Honor, I've looked in the hallway and in the courtroom. I haven't seen Mr. Dingman. I did speak to him on the phone
You
yesterday.
did see him?
I did not. I did speak to him on the phone yesterday. I can't explain his whereabouts today. If we could approach briefly, just very briefly, Judge.
No, we were moving along so good. Come on. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000 cash. Sure, warrant will issue immediately.
Can I read audition on behalf of Mr. Mayor, who is approaching? Can you please say your name for the record?
Carl Murray.
Your Honor, we're asking for an adjournment. He does have a PCC on another case on the 22nd. We would love to resolve them together, so if we can have an adjournment to that date.
5 days out.
Yeah, I've already reviewed the discovery on this case. I just need to do it on the other case.
2025. 9 a.m. Bond continues.
Thank you.
Okay. Court calls case People versus Thomas Lee Ellis.
And Lord Yagi, Assistant Public Defender, with and on behalf of Ms. Ellis, who's approaching.
Your name, sir?
Sorry right now. Thomas Ellis.
Okay.
Your Honor, we are asking for another adjournment. Mr. Ellis did do the screening and assessment for 14B, but we need a follow-up letter from his doctor. So we're asking for an adjournment for that reason. He's going to see his doctor today. So.
Probable cause conference without objection, August 7th, 2025, 9 a.m.
August 7th. Thank you, Your Honor.
Court calls case People versus Sean Newcomb.
Good morning, Your Honor. I don't have any body cam to prove it, but I am Lauren Brown, Deputy Chief Public Defender. Go ahead and state your name. Sean Newcomb.
Thank you.
Your Honor, we are on the verge of working this matter out. We do need to go ahead and submit a request for drug court, a referral. We're gonna waive this matter over.
You're gonna waive?
I'm looking right at the waiver right now.
Sir, you're gonna waive your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir. I'm trying to plead guilty at circuit court and get out of here. That's too much information.
So you understand that you will not have that hearing and you'll proceed to circuit court for further resolution?
Absolutely.
All right, people also waive their right. Preliminary examination having been waived, been bound over to circuit court on the single count.
Thank you, Your Honor. We acknowledge receipt of information, waive its reading in the record. My client was sending, actually, I think he needs to sign that waiver. I didn't know to sign it.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 30th at 1:30.
counsel.
That's July 30th.
July 30th, 2025, 1:30, Judge Conlon.
Thank you. May we briefly address the issue about?
Yes.
Your Honor, my client's bond is currently set, I believe, at 10,000 cash or surety.
It's 5,000 personal recognizance. Unless he did something.
That got revoked, yeah.
What?
But obviously that was revoked because here he is.
What do you have as his bond?
Your Honor, if you recall, Mr. Newcomb had that incident with the saliva distributed amongst the people.
Ah, yes. Yes, I do recall. Yeah. Go ahead.
Well, Your Honor, that was some time ago. The saliva has dried up and my client was coming off competency issues.
What?
He's coming off competency issues.
I got a lot of people that are coming off competency issues and don't spit in my courtroom.
Well, Your Honor,
On people.
he is very truly sorry for that. And he would like the court to know that.
I would like to
Again,
offer apologies myself, Your Honor. Did not mean it was very, very spur of the moment and reactive. I did not think that through. It was beyond my personal actions that I can really say would be something I would normally do. It was really, really odd for me to have done something like that.
Really quickly, Your Honor.
Why?
Well, if I say why, then I will need to approach. Okay.
I can just say no and it wouldn't matter, right? Yes, you may approach.
Your Honor,
Yes, go ahead.
okay. So again, he was in court a few months back or several weeks back. He was going through some issues. Again, he's calm. He's much more even keeled. He's not that same guy. And I understand the contempt of court is something that the court takes seriously. I get that. He's ready to apologize and try to repair that aspect of it. What he's asking for the court is to see the person who stands before the court now, not the person who was here weeks ago, not that person, because he's not that person anymore. See the person who stands before the court now and allow him to have a return to a bond. It doesn't have to be a person. We'd be happy if the court would consider $1,000 cash or surety, but he's improved, and we want the court to see that.
At this juncture, what I'm going to do, and I mean, you know, doing what you did that day put a lot of people in jeopardy, inconvenienced a lot of folks. We basically had to have somebody, I had to stop court, come in, clean up after you. Attorneys could not use the doorway. Your act, when it happened, clearly was intentional on your part. And bottom line is, I just don't tolerate it, ever.
Yes, Your Honor, I completely understand that. And the people's reaction when it happened really floored me, and I realized what I had done immediately after I had done it. I wish I could take it back, and I know I cannot. And all I can do is offer my deepest apologies and pray for.
I am going to deny the request to reduce the defendant's bond at this time or change it. Maybe Judge Conlon, when he sees him, will feel differently, but I do not at this time. So his bond will continue. Thank you.
Thank you, Adam.
Is this all I have? All right, court does call the case People versus Cortez Gray.
Organized holder.
I'd like to talk about hearing on behalf of Cortez Gray.
Your name?
Cortez Gray.
All right, what are we doing?
We would like to set this matter for a preliminary examination.
All discovery is complete.
Yes, to our knowledge.
People had their witnesses available the 29th. Preliminary examination, July 29th, 2025, 9 a.m. before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case People versus Mariah Thomas.
Chairman, that is on behalf of Ms. Thomas. Ms. is not unmuted. Oh, there you go. Ms. Thomas, can you please state your name for the record?
Mariah Thomas.
Your Honor, we are going to be setting this matter for preliminary examination, please.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available to, well, we gotta need a writ. on this, so the earliest I can get it in, that's 20. Set her preliminary examination in person, August 5th, 2025, 9 a.m. before Judge Perry.
Thank you.
Thank you. Bond continued. Court does call the case of the People versus Samuel Peoples. Everybody gets single cases.
Stephanie Can on behalf of Mr. Peoples, who is appearing to my right. Mr. Peoples, tell the court your name, okay?
Samuel Peoples.
Okay.
Thank you. Your Honor, we have a couple of things up today. We have a pretrial, and I'm sorry, I left my paper for this. As to the pretrial, I am going to ask that it be adjourned to try to come to a global resolution. Actually, I do not have one, Your Honor. I will provide one to the court shortly. So that we can come to a global resolution on this case. It's come to my attention today that they are thinking or considering potentially issuing out 2 more warrants that are sitting in the queue. These are all from events basically last year, all in 2024. And so I'm waiting for them all to come through so we can try and get a global resolution, Your Honor. So we're asking that the pretrials be adjourned for that purpose.
In the probable cause.
Yeah, I'm sorry, the probable cause conflict, yes, Your Honor.
And, Your Honor, it looks like, Mr. Peoples also has another PCC for next week's docket on a different case, so I didn't know.
Well, I guess if he's got another one, I don't mind, well, I do mind, but I would put it on for next Tuesday. But I don't know if that resolves what counsel's indicating, because
There are 2 warrants that I'm in case still reviewing. At this point, we don't need to hold up this process for those 2 warrants. That can be.
well, I don't know that that's the case. Are they gonna be authorized? What's gonna happen with them?
So what I discussed with counsel, I just saw those last night. I thought that they had reviewed everything, but apparently they're still. But looking at what those warrants are, and some of the facts and the age of them, it's very likely that those will end up being part of a global resolution where we may agree not to authorize them anyway. So that's why I said they don't need to hold this up. But as for Mr. Peoples has a number of other cases that are charged, are authorized, but maybe misdemeanors, or he has a lot of other things out there. So I think that the overall global resolution will take care of those.
How much time?
I'm sorry, Your Honor.
How much time did you need to get that all together?
Your Honor, can we?
I would put this to the 22nd, but that doesn't make any sense. He'll appear on the 22nd. I just want to give enough time if you guys are going to try to put all of this together.
Your Honor, I am working very diligently as is the prosecutor to try and reach this global resolution.
The 2 of you working diligently.
It's rare,
Yeah,
but it does
okay,
happen.
whatever.
And so I do have documentation from various doctors and everything that I need to provide to the prosecutor's office, which I will do likely today. Your Honor, if you want to just set it with the other PCC, that would satisfy.
5 days.
Or we could adjourn this one out to adjourn the one next week.
That's what I
Okay,
said.
then we'll ask for more time, Your Honor. That would, yes, Your Honor, in your wisdom.
So why don't you do this? How much time are you gonna need to do all of this?
3 weeks. Your Honor, can we have 3 weeks?
So I will adjourn this to August 7th, 2025, 9 a.m. Then you should prepare would be a step to adjourn the other PCC, which is set for the 22nd, to this same date.
And Your Honor, it will be done. Now, Your Honor, we're asking for bond modification at this point. Thank you, Your Honor. Your Honor, I'm asking that my client be allowed to be released in this matter. I don't think that the prosecutor's office, based on our conversation, is objecting to that release. My client was released from jail. He was in the middle of a psychosis. He was having some issues. The family was responding accordingly to the issues that he was having. Your Honor, my client was then voluntarily committed 2 days after the new case. He was just in the middle of his psychosis. During that time frame, his doctor, they went through a med review, they changed his medicines. And I believe he was there for more than a month on this, getting better. I've spoken to his doctor. I have documentation. Again, I'll provide it to the prosecutor. He is now has a ACT. He works with the ACT team. He has an assisted outpatient treatment program. He has an open mental health case. They visit with him twice a day, making sure he's taking his meds. He is now on an injection.
If you file a bond motion or stipulation with his plan laid out, directing that he follow it, and the monetary amount of the bond, I'll consider it. But I mean, I'll let you go through, but I'm not, I can tell you I'm going to deny your motion right now because I don't have proof of, not that I don't believe you, but I don't have proof of anything that you.
Your Honor, I will gladly provide that to the court today. And both of the letters and all the information that I have regarding Mr. Peoples. I mean, so that you can have that, Your Honor, with the hope of getting him out. I will let the court know that he is not being properly medicated. The longer he is off of his meds, the unfortunate news for Mr. Peoples. You're fine, calm down. I'm gonna see you. You're fine. The unfortunate news for Mr. Peoples is he is on a litany of medicine, which I have provided to the with the pharmacy that he goes to, but they're not giving him his meds. I asked him this morning. He said he didn't have meds today. And I understand, Your Honor, and I'm going to try very hard. I'm going to make sure I get you that information today so that the court has it today with the hope of like.
If the parties can agree to something with the plan that he's on laid out to the court, then I will strongly consider it. But
Thank you, Your Honor.
I don't have anything.
No, that's not a problem, Your Honor. I will get it to this court.
So motion for bond reduction, I guess technically at this point is denied. Bond will continue. Thank you.
Give me a couple hours. Okay.
Court does call the case People versus Taiwan Griggs.
Stephanie Cannon.
Yeah, well,
there's that. Your Honor, my client, he was in jail because he came in on all of the bench warrants he had, because he had been in treatment, as the court knows, for so long. And he got out yesterday. When he got out, I didn't realize that. I went to jail to try and see him. Subsequently, I have reached out to see if he would talk to me or if I could find him, Your Honor. My client has appeared for every single appearance. I believe this is just a case of.
For what?
I went to see him yesterday.
Provided the transportation, so of course he was here.
Yes, Your Honor.
Okay.
But Mr. Judge, hear me out on Mr. Griggs. So Mr. Griggs has been in mental health treatment and in substance abuse treatment. He had open warrants that he had to turn himself in on. He does turn himself in on it. He is able to get bonded out. I just don't know that normally I call him and we have a conversation, Your Honor. This case has been up several times and the court is aware that he has been here every single time. He's never missed. Your Honor, how about this? If I can get him on Zoom, will you allow that?
Oh, were you done?
I'm just, sending good vibes your way.
Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Bond will be set in the amount of 10,000 cash assured. Will not issue that warrant until Monday. So you can go try to find your client.
I will, Your Honor. Thank you.
Yeah, I think I saw the text, but I don't know what time she needed me by, but I haven't. I responded back.
Good morning, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And Karma Dadush on behalf of Mr. Priester, can you please state your name for the record?
Jalen Priester.
Your Honor, we've just received discovery. We were going to ask for an adjournment to review that and a moment to address bond, please.
What was the last thing you said?
And a moment to address bond, please. If you'll allow it.
You don't really want my answer. Probable cause conference will be adjourned July 31st, 2025, 9 a.m. as to bond.
Thank you, Your Honor. We're gonna be asking for a reduction on his bond. Mr. Priester has a full-time job at the University of Michigan Building Services. He is able to go back and stay at his father's address if he is released. He is able to get released on, if Your Honor would agree to his release, he can be on a hot zone tether, as I believe the magistrate had ordered that if he were to be released. I don't believe he has any other cases holding him.
He does not.
I don't believe he does.
Okay.
And he just wants to be able to go back so he's able to not lose his job that he has. So for those reasons, we're going to be asking for a personal recognizance, Your Honor.
Memorial Day of this year, 3:00 in the middle of the afternoon, Mr. Priester and a buddy of his thought it was appropriate to go shooting through an apartment complex parking lot. One witness that he was apparently trying to get says that she has received death threats via text from him and his buddies, as well as they tried to run her off the road. 2 other innocent bystanders had bullets ringing through their apartments. One in particular was laying in the bed trying to take a nap at 3:00, and she was woken up by the bullets coming through her window, entering into her bathroom. He has currently a $35,000 cash surety bond. He is only 22 years old. With this type of activity, I would certainly oppose any type of bond modification.
Well, Your Honor, if he is put on a home confinement tether with the ability to go back to work, that would perhaps ensure that he does not go anywhere that he's not supposed to be going or do something he's not supposed to be doing.
The unloading of a firearm, which are the allegations at dwellings where people are. I'm quite frankly shocked that his bond is so low. I'll be absolutely honest with you. And so if I were to receive a motion from the people, I would raise his bond. I am certainly under these circumstances not going to reduce his bond.
Understood.
Defendant's motion for bond reduction is denied.
Understood. Thank you, Your Honor.
Court calls case People versus Suzette Hampton.
And on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender. Is approaching, Judge. State your name, ma'am.
Suzette Hampton. Thank you, Ms. Hampton. All right.
Your Honor, we're asking to adjourn this. I want to go over the video discovery with Ms. Hampton, and Ms. Landy and I have actually talked about possible resolutions.
All right. Probable cause conference, August 7th, 9 a.m.
Thank you, Your Honor.
Court does call the case of the People versus Hampton.
Stephanie Cannon on behalf of Mr. Turner. Mr. Turner, could you state your name for the record?
Anthony Sherrod Turner.
Thank you.
And Your Honor, we are going to ask for an adjournment of this matter. We're trying to get an offer. My client has been accepted into mental health court. I have been working.
He has been?
Yes, Your Honor, he has.
Okay.
He's been accepted. I have the paperwork here, but I don't have the misdemeanor yet that would allow him to go. So while everything is filled out, I can't do anything until I negotiate this down to the misdemeanor. I thought we were on that, Attorney Childers and I. However, he's not here today, and it's
July 31st, 2025, 9 a.m.
Say the words, July 31st. Your Honor, can we address bond in the meantime?
Go ahead.
Your Honor, I would ask that my client be allowed to be released. You can tether him. He has a place to live. He's been in there for quite some time. It is my belief that this will go down to, hopefully, with his being put in health court, go down to a misdemeanor. And he has already met with the mental health court. My client is super excited about it. When I met with him on Monday, he talked about it quite a bit. He likes the mental health court staff. And if the court wants, he'll even go to the next mental health court session to start this process.
Response from the people.
Well, I leave it in the court's discretion. It doesn't appear that there is any significant history, and it doesn't even look like we had a cash and surety request at arraignment, so I don't.
No, he was on a PR, didn't appear. It was a while. We finally got him back. And started heading down this course. But where would the defendant be residing?
Did you give him your address, Mr. Turner?
312 West Huron,
Sign your name.
In Ann
right.
Arbor?
Ann Arbor.
Yeah. At this point, why don't we get the plea and everything worked out? Once he's had his court, that court can decide, but it's what reductions.
Thank you so much, Your Honor.
Do what we gotta do. Court calls the case, People versus Ardashir Hassani.
Good morning, Your Honor. Assistant prosecutor appearing on behalf of the people.
Malika Fatima appearing on behalf of Ardashir Hassani.
All right, your name, sir?
Ardashir Hassani.
Thank you.
Your Honor, at this time, we are requesting for an adjournment.
Okay. Would you be able to accomplish your task by the 7th, or did you need one more week out? You have no idea, do you? All right, I'll just make the call. Bravo, Costco.
Your Honor.
Thank you, Your Honor.
Thank you, sir. And here we go. Court does call the case of the People versus Daniel Magoo.
Good morning, Your Honor. Ashley Lottie for the people.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Ms. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
No. Not at this time.
Let me then do this. You have two cases before this court, one being the case ending, well, let me give the full case number 25F40523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
your other cases when you represent yourself, so we'll just do it.
You're talking about the case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up to 1 to 5 years incarceration. Order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I'm here in exclusive equity.
You counsel in representing yourself, you will be held to the same standards as anybody apply or.
This is a matter under the Eastern District of Michigan Federal Court. Case number 2511226.
We're not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel will be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979. In that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count one is fleeing and eluding fourth degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a $2,000 fine plus court costs, mandatory suspension.
My Secretary of
Two
State, anything
is
is canceled. I have no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor.
This is a
charged
matter of
with
trust, Your Honor. This is a matter of trust.
punishable
I am protected
by up to
under a
90
trust.
days in jail, a $100 fine plus court costs. Count three on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and $200 nor $500 fine plus court costs. Count four is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are through the federal government. I have federal government registration. I do not have contracts with the
Vehicle
state.
could be subject to mobilization. Count five on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. I would indicate to the defendant the same admonishments regarding the perils in representing oneself stated in the other case also apply to this case.
Were you served your notice and summons yet, Your Honor?
Would consider or would appoint counsel to represent him in this matter, and he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you get
Do
your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
where your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel. I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
inform the court otherwise. Ms. Lonnie.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned himself, and that it requires in part that I let him know what he is charged with, and I've read them kind of in fully, more so than I would have, because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor.
What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand. There is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
Yeah, and who restricted my phone
Probable
calls?
cause conference. You know what? You're going to have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say, but I'm not going to have you interrupt me, and I'm not going to have you interrupt people when they're talking. As long as you were saying.
Thank you, Your Honor. There's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that, so it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that, and then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As to bond.
Your Honor, I've been reviewing X-Trail and I wanted to double check if the defendant has been arraigned. It's not clear to me from a couple of different things, but
it does appear that he has been set with a $10,000 bond in 25F30979, as well as 25F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would like to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene from the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
A co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low, and I also am going to request a SRAM tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that?
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Hearing argument regarding bond, the court does believe that it was abuse at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public,
no victims,
believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The police officer did not report that at all.
The court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here. Thank you.
the tethers I requested, if he is able to post, Your Honor?
I will.
Thank you.
Thank you. If everybody doesn't mind, the court's gonna take a very brief recess, and then I will come back and we will finish, then we'll be back.
All right.
Court's in recess.
Judge Simpson presiding.
You may be seated. I know the majority of you didn't think after this morning I'd come back, but I most decided not to. But here I am. These are, okay. Court does call the case of the People versus Jonathan Hughes.
Carolyn Foster Tucker on behalf of Jonathan Hughes.
Client down in our jail is refused to be seen. So
Ben.
I will adjourn this out. August 7th, 2025, 9 a.m.
Thank
Court calls the case of People versus Elizabeth Hill.
And good afternoon, Laura Yagi, Assistant Public Defender, with on behalf of
In your objection, I did want to just,
Probable cause conference, August 7th, 2025, 9 a.m. Yes, Esteban.
simply wanted to request, there is no testing order whatsoever on this file. I provided the court, you may have the hard copy of, Ms. Hill's. I think it started with trouble and she may now be on scramble, vice versa in her circuit court case. I just wanted to ask that we have an order here to accompany that so that we get those results, because currently they're only being sent to,
Oh, you guys don't get them. I get them because of our name, but I got you. You're on a
Scram
now. Right. When did you go on a scram?
They put it on me before I got out of jail.
The defendant's bond. And we'll order a scram tether on this case. We don't have to put another one on.
Thank God, we're not a space.
What do you say?
We're not a space.
We got 2 left, so we can put one on each leg. That's been done there.
Your Honor, I'm so sorry. I'm just asking for civil standby. I think it was an oversight at arraignment, but we just need a civil standby for her to get her belongings.
To do what?
For her to get her belongings from her residence. Get her belongings with a civil standby, and for some reason
I don't need to order a civil standby. You call me.
They wouldn't come out when I.
If I scream loud enough, is really? I've never. Ms. Yagi, craft an order.
Okay. It's like, okay for
Do an
civil.
order. They want an order?
Understood.
Do an order.
Got it.
People out of room, I'll put a big signature on it.
Thank you, Your Honor.
All right. Thank you. Court does call the case People versus D'Angelo Simmons. Also.
People, Your Honor.
Okay.
On behalf of D'Angelo Simmons. So the client is
Where's your client?
admitted to restoration treatment on the 14th.
So where is he?
Not here
Why?
because he's getting treatment.
We got plenty of people getting treatment. Why is your client here?
We We would like to.
Okay, I'm messing. Look, he's not here. He's in the forensic center. There was no way.
So we would like to adjourn this matter.
You had no clue.
Um,
Kinda did, but
I-
never mind. All right. Probable cause conference, we'll adjourn this out to the 8th, or the 7th, I'm sorry, August 7th, 2025, 9 a.m. On continue.
thank you, Your Honor.
Thank you, Honor. Oh. Okay, all right, let me. Hold on one moment, folks. Where's the text? Oh, there you go.
I'm tucking in my shirt for you.
No, you don't kill. Ready, do solemnly swear for the information contained in the search warrant affidavit is true to the best knowledge information. Court does call the case of the people versus Dutton Howard.
And on behalf of the people, Your Honor.
Assistant Public Defender Nik Starow on behalf of Mr. Howard, who is now approaching the podium.
State your name.
Don Howard. At this time, Your Honor, we'll be requesting an adjournment to have video discovery be provided.
All right.
And here's a green sheet for you, Your Honor.
You. Adjourn this to August 7th, 2025, 9 a.m. Bond continued. Okay. Thank you.
Your Honor.
Court does call the case, people versus.
Assistant Public Defender Hannah Apple, appearing on behalf of Ms. Hughes, on behalf of Mr. Gaddy. Not with Ms. Hughes, Your Honor. My understanding is that our office has attempted to reach Ms. Hughes several times. We've not been able to get in contact with her. I'd ask for an adjournment for the record.
Bench warrant will issue bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court does. Yes. Go ahead. You may.
Good morning, Ms. Liliana. You're in front of the Honorable District Court, Washington County, State of Michigan. We need your assistance with one matter this afternoon. Our number is 1423.
Yes, certainly. I'm ready with your instructions.
Please sworn. Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and translate from the Spanish and from Spanish to English in the manner now before the court tells that?
Yes, I do.
All right. Court does call the case of the people of State of Michigan versus.
Jennifer Douglas for the people.
Sorry,
Jennifer Douglas for the people.
Hola, seré su intérprete de español el día de hoy. Este sería el caso del estado de Michigan contra Jorge López. De parte de las personas del estado sería Jennifer Douglas.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Lopez.
Y a favor de parte del señor López, abogado de la Oficina del Defensor Público, Nicolás Bakovich.
Defendant is requesting an adjournment in these matters. I will adjourn the probable cause hearing to August 14th, 2025, 9 a.m.
Your Honor. Sorry.
Pero el acusado estaría solicitando que se aplace esta audiencia para tener la audiencia de causa probable. Se estaría aplazando, moviendo para el 14 de agosto del 2025 a las 9 a.m.
Yes.
I do have a meeting set up with Mr. Lopez, and
I understand. I read the form, which shouldn't say what it says, and we'll talk about that.
Understood. Thank you, Your Honor.
Sí, entiendo de
it?
que leí, pero mencionabas, abogado, de que tenía una reunión con usted, con el señor López, y después menciona de que sí, entiendo, leí lo que dice la forma que no debe decir eso, y vamos a estar abordando eso.
Bond will continue. Thank you.
Se va a continuar, gracias.
All righty. Thank you, Madam Interpreter. Can counsel on the last case approach, please? Thank you, Madam Interpreter.
Sí, have a good day. Bye.
After you call.
Okay. Court calls the case of the People versus Shafi.
APA Rachel McDuffie for the people.
Good afternoon, Tina Sachs on behalf of Mr. Shafi.
Mr. Shafi here. Yeah, very. Sir, please state your name.
Rashad Shafi.
All right. All right, what are we doing on this case?
Your Honor, my understanding is that Mr. Shafi is currently set for preliminary exam, which are being adjourned because he has been in treatment, got out, is in treatment again. So I believe counsel's request is to adjourn this case. I want us to quickly address bond. Well, just for the same administrative purpose I did on the other case I had.
All right. How much time, Ms. Saxon?
Your Honor, I'm asking for 3 weeks. Mr. Shafi's supposed to still be in the program for a total of 28 days. He just went in on 14th, so I was hoping to.
Gotcha. All right, I'll adjourn this then to August 7th, 2025, 9 a.m. All right.
Thank you.
Mr. Bond.
And Your Honor, regarding bond, there is a testing order on this case, but I just provided the court, I think via email, it might be in the file. Ms. Shafi's technically in violation on this case, but Community Corrections has 2 sets of reports that don't overlap. So I just provided the court with his other reports from those previous 2 cases that were set for exam so that you had a copy. It appears that he briefly relapsed and then went back into treatment. So
I was in a motorcycle accident, so I missed my
don't.
time.
Mr. Shafi.
Yeah.
I'm sorry.
He was, I remember from the last time, there was an accident, he was in the hospital and he missed his testing. And then he's good with me.
I just provided a copy because they
Thank
didn't send it to me.
All right. Okay, thank you, Bond. Continue.
Thank you, Your Honor.
Court does call the case People versus Emily Bates.
Emma Babish on behalf of Ms. Bates, who's appearing on Zoom. Ms. Bates, can you please state your name for the record?
Emily Bates.
Thank you.
Your Honor, we are going to be asking for an adjournment. We need to get proof from Ms. Bates regarding treatment in pursuit of a plea offer. So we're gonna be asking.
August 7th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you, Ms. Bates.
Thank you.
Court calls case People versus Desmond Jones.
Hey, Rachel McDuffie for the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Jones. Your Honor, I will need to fill out a green sheet. I did not have contact with Mr. Jones. So I
Yeah,
will,
because if you had contact, you.
I would have told
how to
him
appropriately
that he
dress.
had to wear pants. Yes, Judge.
Yes.
Yeah. So I will
We
get a
won't
green
see
sheet.
that the next time if I grant you adjournment.
No, absolutely not. Yes, he will have pants on. If I could have an adjournment so that I can get updated contact information with Jones, and I'll get a green sheet to the court.
July 31st, 2025, 9 a.m.
Thank you, Judge.
I'm continuing.
Thank you.
That's what it sounds like. She does not, don't listen to Jen. She has no idea. Court calls the case People versus Dominic Kelly Payne.
And Assistant Public Defender Hannah Apple appearing on behalf of Mr. Kelly Payne, who I do not see here in the courtroom. Judge, I did talk to Mr. Kelly Payne yesterday. He did have court in the 22nd Circuit Court this morning.
My understanding in corresponding with Ms. Noveski that he was there and Judge Kunke and their team came up with a plan of action for Mr. Kelly Payne. I expected him to be here in person. You
Did
discussed
he
this.
like the plan of action they came up with?
Yes, I believe so. It allowed him to remain out of custody and a treatment plan so that he can stay compliant with drug treatment court. I don't know why he hasn't made it here yet. But considering that information, I'd ask the court for an adjournment.
And probable cause conference will be adjourned July 31st, 2025, 9 a.m.
Thank you, Judge.
That was so nice of me. Miss Apple has a nice way of asking. Don't buy it all the time, but. Court calls the case, People versus Coran Lee Master.
If you ever look at the people.
Probably just Lemaster.
My name is Alex Parks. I'm requesting permission to practice pursuant to Michigan Court Rule 8.120 under APD Hannah Apple.
She.
Fantastic. Yeah.
Okay. She wants to keep handling cases. All right, your name, sir?
Karan Lemaster.
All right. Permission to practice is granted.
Thank you, Your Honor. We're requesting adjournment in this matter to give us more time to discuss with our client.
Discovery. All right. Probable cause conference will be adjourned August 7th, 2025, 9
Thank you, Your
a.m.
Honor.
Or as your invite indicates, bond will continue. Thank you, Mr. Thank you, sir.
Thank you.
Court calls the case of the People versus Derek Martin.
That is for the people. Patrick Cannon on behalf of Mr. Martin. Mr. Martin, when you are at the lectern, please state your name.
Derek Martin. Thank you.
And we are simply requesting an adjournment, Your Honor. There's some outstanding discovery and I don't have one.
Get the form to us. I'll sign off on it. July 31st, 2025. Bond.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Harold Martin.
Echelon of the people.
Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin.
Harold Martin.
Yep. Yeah, no, I've been trying to make contact with my client. I was unable to do so. I'll be requesting an adjournment.
Your Honor, can I ask a question as to previous eventual issue?
As to what?
I think there's been previous warrants in this case, is that correct?
I do not know right off the top of my head, but one, yes, there was one April 24th.
Are you able to tell if he posted the bond?
I don't see it as posted, but
It was recalled.
it was a recall.
And I will also note for the record, there was another bench warrant that was issued on April 4th, 2024, that I think got recalled.
I don't know.
Okay.
We can assume for the sake of argument it was, so. Bench warrant in this case will issue. Bond will be set at 10,000 cash surety. That warrant will issue immediately. Court calls case People versus Robert Martin.
And Assistant Public Defender Nicholas Buckovich on behalf of Mr. Martin, who is now approaching the podium.
Your name, sir? Robert Martin. Thank you.
Today, Your Honor, will be waiving a preliminary exam, so Mr. Martin can pursue offer under 7411 in the circuit court.
Sir, is that correct? You're waiving your right to a preliminary examination?
That is correct, Your Honor.
You understand that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant's bound over to circuit court on the single count.
And I do have a waiver filled out for you, Your Honor.
It's your turn.
Yes, Your Honor. As it relates to the charges, we will waive a formal reading and my client be standing mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set
September 4th at 1:30 with Judge Slay.
September 4th, 2025, 1:30, Judge Slay. Bond will continue. Thank you.
Thank you, Your Honor.
Thank
Your
you.
Honor.
Court calls the case of the people versus Makisha Melchor.
Okay, Richard McDuffie for the people.
And Lori Yagi, Assistant Public Defender, hopefully with and on behalf of Ms. Melchor. I know she was having some issues logging in. Ms. Melchor, can you unmute yourself and say your name for the court?
Oh, there she is. All right, can you, there you go, you have it. State your name.
Keisha Melcher.
Okay.
Your Honor, we are respectfully asking that this case be set for exam,
All discovery is complete.
to my knowledge.
And Your Honor, I just want to confirm, apparently there was some discussion of a misdemeanor offer if was submitted that Ms. Melcher completed treatment. I'm confirming that that potential for an offer thing, and then there'll be no proof or coming, I can't stop. Sorry.
That, I guess I'm confused. There was no offer, and so we're setting it for exam. I'm not.
That's the correspondence that we had, but that's okay. Well, Your Honor, can we pass it for about 30 seconds, please?
Why? Is there an offer or not?
Council emailed me, requesting an update on a potential offer being discussed. I responded asking if she had the documentation that was requested for that offer, and here we are. So,
Your Honor, we're setting it for exam. There's no offer.
Preliminary examination in this matter will be set for July 29th, 2025.
Thank you.
9 a.m. before Judge Washington. Bond will continue.
Thank you.
Thank you.
Thank you, ma'am. Court does call the case, people versus Jordan Miller.
hey, Richard McDuffie for the people.
Ron Brown appearing on behalf of Jordan Miller. Green sheet.
You, man. Yes, Mr. Brown.
Please state your name.
Jordan Miller.
We'd ask for the adjournment to obtain additional discovery and review it.
Council approach. Conference in this matter will be 2025, 9 a.m. Bond continued.
I'll talk to my client.
Court calls case people versus Lanish. I got that right. Mitchell.
That is for the people. This is the public defender on behalf of Ms. Mitchell, who's approaching now. Your Honor, we are asking for an adjournment. I know that Ms. Douglas has been working tirelessly to try to get us the video discovery on this case, but it is still outstanding from several agencies. I also received a bond violation report, which I assume the court is looking at now.
Yes.
Ms. Mitchell did provide me with her medical marijuana card. I do have it if the court wishes to look at it. It is valid. I showed this to Ms. Douglas.
Yes.
There was some misunderstanding regarding that, but she does now have a valid medical card.
How much time were you looking for, Ms. Allen? I realize you guys are trying to work on this, but
yeah,
how much more time did you need?
Yes, Your Honor, I've had, for some reason, trouble getting video on it. I got some more this morning. If we could have a couple weeks, I do want to look at it because the video I had before was not of what I was expecting it to be of.
Okay.
So, I just want to make sure we're actually getting to the council.
Good, she said, okay. August 7th, 2025, 9 a.m.
August 7th.
Bond will continue. Thank you. Court calls case people versus Antoine Patterson.
Families even though we have people standing for whether we cannot.
Patterson, can you please state your name for the record?
Antoine Patterson Senior.
All right.
And
Go ahead.
I'm sorry, Your Honor. My understanding is that there is an agreement today and my client will be taking a no contest plea. I have, I believe in your file, there should be a previous advice of rights. However, if the court is not in receipt of that, I do have an updated copy and I did sign that with my client's permission.
I don't know. Why don't we just have the plea form before? Okay, the plea form indicates that the defendant will be pleading no contest to the charge of domestic violence. Upon a successful plea to that charge, count one would be no contact. But only through CPS recommendation or court order and incidental contact at a bus stop. The offer is contingent upon there being no violations, no assault or contact with anyone since the assault that underlies the current case. Also, there is a sentence agreement, which I can't bind the court to, but for 7694A with all treatments recommended by probation. That's the court's entire understanding of the agreement.
That is our understanding as well, Your Honor. That's our understanding.
Attendance one.
You solemnly swear or affirm the testimony you're about to give you the truth, the whole truth, and nothing but the truth so help you God.
Yes.
Go ahead and state and spell your name again.
Antoine Patterson Senior. That's ANTUAN
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of domestic violence. That is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. Do you understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
All right. Two things about it I have to make sure you understand. First thing you need to understand is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Basis for the no contest plea?
Fear of potential civil liability, Your Honor.
All right. So, sir, understanding all of that, you still do wish to plead no contest?
Yes, sir.
And to that,
No contest.
you understand that by pleading no contest, you'll not have a trial of any kind?
Yes, sir.
You signed an advice of rights form?
Yes, sir.
Any questions regarding those rights?
No, sir.
Look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of the trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been on the record to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 24-52383. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if I accept your plea, from the time of this plea to the time that you are sentenced, if there is indeed a violation or misconduct as defined by the Michigan court rules, and you're engaged in that two things. One, you would not be able to withdraw your plea. You understand that?
Yes, sir.
And you understand any sentence agreement and or recommend.
Yes, sir.
Counsel, are you aware of any other promises, threats, or other? Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll accept the defendant's plea of no contest to count 2. My paperwork. We have no contest to count two. Count one is dismissed. Pre-sentence investigation and report is ordered at 14A for probation, or I'm sorry, 14B probation. Sentencing in this matter will be
August 18th at 10 a.m. with Judge Washington.
August 18th, 10 a.m. Judge Washington. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Danielle Pressey.
National Monica people.
Defender Hayden School appearing on behalf of Ms. Pressey. We say your name for the record? Danielle Pressey? Thank you. Your Honor, I'm sitting in for Mr. Gaddy. We're asking for an adjournment. There's some mitigation information that's been being finalized and going to be presented to the prosecutor shortly.
Probable cause conference 7/2025, 9 a.m.
Thank you, Judge. Thank you.
Your Honor.
Bond will continue. Court does call the case People versus Jody Ann Russell.
And Lord Yaki, assist.
Jody and Russell, can you hear me?
Yes, we can hear you. Thank you.
Okay, no problem.
You're requesting an adjournment.
I am, Your Honor.
I will adjourn the probable cause conference August 7th, 2025.
Thank you, Your Honor.
Thank you.
And Lord Yagi, Assistant Public Defender, with on behalf of Mr. Schultz. Mr. Schultz, can you state your name for the court?
Motorola. Schultz? If that's you, wave your hand. Oh, there you go.
Yep.
You're on your. Okay, state your name.
Jeremy Schultz.
All right, very good.
Your Honor, I'm requesting an adjournment in these matters for some updated paperwork and continued conversation with APA.
All right. In both cases, probable cause will be adjourned to August 7th, 2025, 9 a.m. Bond continues.
Your I was gonna say I'm going back to work. Wondering if I could do it via Zoom for the 7th.
You talk to your attorney about that.
I'll file it for you, Mr. Schultz. We'll follow up.
Okay?
All right, thank you.
Thank you.
Or call the case People versus Joseph Smith. No.
Assistant Public Defender Nick Bukovich on behalf of Mr. Smith, who's appearing via Zoom. I did have a contact with Mr. Smith before the docket started, indicating that he was on the Zoom.
He was on it?
I'm here.
Yes.
I'm here.
Oh, that's you. Okay.
Mr. Smith, can you please state your name for the record?
Joseph Smith.
All right. Okay, what are we doing in this case?
At this time, Your Honor, be requesting an adjournment for some further negotiations and also determine if there's any outstanding video discovery in this matter.
All right.
I do have a green sheet for you.
I'll adjourn this matter to August 7th, 2025, 9 a.m. Bond continue. Thank you. Court does call the case People versus Myra South.
Mr. Douglas for the people.
Hello.
Hello, state your
My name is Alex Parks. I'm requesting permission to practice.
again. Who's your supervisor?
Miss Hannah Apple.
Did Miss Apple tell?
Mr. Daddy.
She's,
So are you normally with Miss Apple or Mr. Gaddy?
Mr. Gaddy.
Okay, now I get it. Okay. It's not Miss Apple's fault. Okay. All right, you're requesting an adjournment.
Yes, we are.
All right. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, ma'am. Court does call the case of the people versus Joe Stafford.
There he is. Public defender Hannah Apple, appearing on behalf of Mr. Stafford, who's from now. Mr. Stafford, will you state your name for the record?
Virgil Stafford.
Okay. In your honor, we have reached a resolution.
Yes, I do see. He's going to plead guilty to.
An attempt, count two, an attempt resisting obstructing.
Yeah, the problem is all right, I'll fix it. But it just states that to the primary charge. The PAC code is for the attempt, but got it. Okay.
Thank you.
He's going to be pleading guilty to the charge of attempted resisting and obstructing an officer, the 1-year offense. Upon a successful plea to that charge, that count two, count one would be dismissed. There is an agreement by the defendant that he will comply with all court orders for mental health treatment, comply with all medication plans. Defendant has a probate case, I'll just leave it there, that was transferred to Genesee County in June of this year. That's the court's full understanding.
Yes, Your Honor. That's correct, Judge. Thank you.
All right. May I have him sworn?
Someone swear or affirm the testimony about truth, whole truth, and nothing but truth. So, lower your hand, spell, and say your name again.
Virgil, Virgil Stafford, Stafford.
All right. Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor, punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Bravo in the 15th District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on the form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Yes.
Okay. Were you on probation at the time of this? Right. You understand that your entry of a plea in this case could be considered a violation of that probation. You understand that if it is considered a violation, that court could sentence you to the maximum allowable under that other charge.
Yes.
And understanding that, you still wish to plead guilty to this charge?
Yes.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
And of your own free will?
Yes.
And also because you believe that you are indeed guilty of this offense, sir?
Yes.
Police Department.
Yes.
What happened?
Sorry.
Go ahead. You may, dear.
Thank you, Judge. On that date and time, you came into officers that were with the Ann Arbor Police Department, correct?
Yes.
And you knew that they were officers with AAPD?
Yes.
Okay, and they ultimately asked you to step out of your vehicle, correct?
Yes.
Okay, and they you complied with that, but then they informed you that they were going to detain you, correct?
Yes.
And to place your hands behind your back?
Yes.
Okay, and you did not comply with that order,
No.
correct?
Yes.
Good. All right.
Defense is satisfied.
Okay. Very good. Sir, if I accept your plea, I do have to advise you that if between today's date and the time of your sentencing, if you commit misconduct as defined by the Michigan court rules, you first of all would not be entitled to withdraw your plea. Secondly, any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other plea promises, threats, or other inducements which have caused this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Defense is satisfied. Thank you.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
July 29th at 9 a.m. with Judge Bell.
July 29, 2025. What time, I'm sorry?
9 a.m.
9 a.m. with Judge Valwell. On.
Thank you, Judge.
Court does call the case of the people versus Darnell Taylor.
Alexander, we have Your Honor.
She is in the hallway charging his tether.
Doing what?
Charging his tether.
On our bill? Go ahead. I'm talking about. That's why our DT bill's so high. People come here to charge it.
Thank you for my appearance on me. On behalf of Mr. Taylor, will you state your name for the record?
Darnell Taylor.
Thank you. Your Honor, we are asking.
How long was he charging for?
Oh, maybe 15, 20 minutes?
35 minutes.
35, just kidding. On my time.
35? Figure out the DT rates. Give me a number. We'll make it pay. All right, go ahead.
Your Honor, Mr. Taylor is asking that this matter be set for a preliminary exam.
Media has not been sent over to defense counsel, nor has the 911 call. The media notice was made, I believe, 2 days ago, and the 911 call still has not come in yet, so they do not have media discovery nor the 911 call.
And Your Honor, that is correct. I informed Mr. Taylor of that. I informed him that the court would be asking if discovery was complete. We do not have there is still insisting and requesting that the court proceed with the preliminary exam. I fully advised him of the risks of that, considering one of the allegations is from the back of the patrol vehicle. We do not have video of that, but he is asking that the matter be set for an exam.
Sir, you understand that could be a problem for you? Because if the discovery comes in and people have it, your counsel hasn't had a chance to look at it, you're not going to get an adjournment of these proceedings.
Yeah, I understand.
You understand that?
Yes, Sean.
Do you think it might be better that your attorney would be able to look at what it is, particularly since some of it was involved in what I understand the back of a police vehicle, prior to making or being able to fully advise you as to how to proceed?
Yeah, Sean, I understand. I mean, at the end of the day, I honestly don't think it's gonna make a difference.
So you got your law degree where?
I don't.
Yeah. And I think she said it, so it's not really impinging on your privilege. She's advised you that you probably should wait till they can fully assess it.
Did I advise you of that?
Yeah, she did.
Okay.
Don't you think it might be advisable for you to follow your lawyer's advice?
I do, Your Honor. At the end of the day, I mean, I know what I did.
Well, no, whoa. I don't want you.
Okay. Well, I didn't do.
I do. No, hold on. Here's what we're going to do. Over your objection, I'm going to adjourn it. I'm going to make sure that it's fair to you and that you have what you need to make a proper call rather than rushing into it. Okay.
I understand. My main thing was I'm on this tether and
I know, but you don't want a circumstance where, and I'm not saying that it will, things can get much worse for you. Let your attorneys do the job for you. Okay.
All right.
You got good attorneys around you. Let them do their job. Okay.
All right, Your Honor.
All right. So we think we'll have that by when?
Probably sometime next week, Your Honor.
Okay. So if you get it next week, here's what I'll do. I won't put it out far. I'll put it out, instead of going to the 7th, I'll go to July 31st.
Thank you.
Okay. 2025, 9 a.m. And then at that point, after you've seen everything that's there, and your attorney, most importantly, has seen it, then you can make a decision.
Thank you, Judge.
Fair enough?
Yes, sir.
All right. And just because you actually listen to me, I'm not going to make you pay for the use of electricity.
I appreciate it.
All right. Take care.
Thank you.
Court calls case People versus Vershawn Vincent.
It's-
That's the line for the people.
Sorry. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Vinson. Your Honor, I don't believe with Mr. Vinson. I will take the blame for this one. Mr. Vinson typically appears on Zoom. That was my apologies in missing the deadline. I submitted it late. I've had communications with Mr. Vinson up and through today and just a few minutes ago. He lives in Detroit. He does not have transportation. But he was not able to make it here today. He tried everything he could over the last 24 hours to get a ride. But unfortunately, he could not appear in person. We do have a misdemeanor resolution on this case. We just need Mr. Vinson to get here.
She's so nice and eloquent. I hate being nice. People have any objection if I adjourn this out, given those circumstances? Who is it, Londi?
Yeah.
Oh, boy. This could get bad.
The only problem is Mr. Vincent has a very significant history of failing to appear.
He does, but I think since that,
Since he's been coming on Zoom, it's been better,
yes, exactly. And
but it's still not great.
If I could let the court know, just one additional thing. Mr. Vinson, we had a lengthy conversation yesterday. He's prepared to accept the offer. I informed him that we'd be asking for one more adjournment. And then my request is that he appear in person in 2 weeks at the adjourn date so that he can sign the waivers. We can make sure to have that conversation so that everything is signed and done. He informs me that he'd be able to get a ride, that's enough notice, and he would be here. So if the court is gracious enough not to issue the warrant, I will ensure that everything that I can do, that he is here in person and he has enough time.
noting the people's reluctance to agree, and I understand, and looking at the file that he's had some issues, I'm going to grant the request. I'm going to adjourn it out to July 31st, 2025, 9 a.m.
Thank you.
Continue. Thank you.
Thank you, Judge.
That it? Then what? I get a break? Court stands in recess.
All right.
Okay, this court is back in session. The honorable Nik Starow Snark presiding.
You may be seated. Court does call the case People versus Cheryl and Drasik.
Nick Manis, P41543, on behalf of Cheryl Anderson. State your name for the record.
My name is Cheryl May Anderson.
Anderson. Okay, sorry for mispronouncing your name. I have before me a plea form that indicates that the defendant will be pleading no contest. Do I have a report?
Ally's on behalf of the people, Your Honor, I believe we submitted the report on
Just the one.
May, but it was separate from the. I do have a copy here.
It wasn't even, was it one of the ones? Okay.
Yes, it was.
I didn't have a plea form with it though, right? Okay, that's why I probably don't recognize it. All right. It should be pleading no contest to counts 3 and 4. Counts 1 and 2 would be dismissed. And there is sentencing under, well, it says 4A, but presumably that's 769 4A. That's the court's full understanding of the agreement. Is that correct?
It is correct, Your Honor.
All right, very good. May I have her swear?
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
So
Go ahead and lower your hand, say it, and spell your name.
my name is Cheryl. Cheryl, Cheryl, as in 9th of May, Andrysek, Andrysek.
And it is this court's understanding that you're going to plead to 2 misdemeanor charges of domestic violence. Is that your understanding?
Yes,
All right.
sir.
Those are misdemeanors.
For my actions.
that may be the ultimate, but do you understand what it means?
That I did something wrong, and I'm pleading guilty to it.
You're not pleading guilty. They're allowing the judge to make a determination of guilt based on the police report.
Okay, yes.
Okay, so one thing, there are two things really I need really for you to understand about a no contest plea. The first thing is that it means that you're not further desirous or wanting to contest these two charges. You understand that?
Yes, sir.
You understand that? Also, I will be, as I think counsel was indicating, I would and have reviewed the report in this case and would use that as a factual basis to determine whether or not a crime has occurred. Do you understand that?
Yes, sir.
All right. The other thing you need to understand is that for purposes of sentencing, the court will treat you the same. You understand that?
Yes, sir.
All right. You have any other questions about a no contest plea?
No, sir.
All right. I also have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court. You understand that, ma'am?
Yes. Yes, sir.
All right. Any other questions regarding a no contest plea? Or anything so far?
No, sir.
All right. Basis for the no contest plea, counsel?
Basis, Your Honor, civil liability.
All right. So, ma'am, to the charge of domestic violence as contained in count 3, how do you plead?
No contest.
To that same charge as contained in count 4, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, I did.
All right. Do you have any questions regarding any of the rights on that form?
No, sir.
I'd ask you to look at paragraph 5, and underneath counsel, there's one. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights that are on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
All right. Are you on probation or parole?
Yes, sir.
He is on probation in Savannah, Ohio, Your Honor. She
All right.
understands the ramifications of this plea.
All right. And were you on probation at the time of this offense?
Yes, sir.
Okay. I do have to advise you that if you were on probation and this were considered, and your pleas in this case, if they are considered a violation of that probation, that the other court could sentence you to the maximum allowable under those other charges. You understand that?
Yes, sir.
All right. And understanding that, you still wish to plead no contest?
Yes, sir.
All right. Has anybody promised you anything other than what's been stated here today on the record, get you to plead no contest?
No.
And you were coerced to in it?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
All right. I need a copy of the report. Thank you, Mr. The court has been provided and has previously reviewed Ann Arbor Police Department report for their case number 25-14640. Any objection to the court having reviewed that report?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine defendant's guilt of these offenses. Ma'am?
Yes.
I do have to advise you that if I accept your plea, from the time of your plea to the date of your sentencing, if there is misconduct committed by you as defined by the Michigan court rules, you would not be entitled to withdraw your plea, and the court also would not be bound by any sentence agreement or recommendation. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements that?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's pleas of no contest to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
August 22nd at 10:30 with Judge Perry.
August 22nd, 2025, 10:30 before Judge Perry. Bond in this case will continue.
Thank you very much.
Thank you. Court does call the case People versus Zachary Brown.
That is for the people.
Afternoon, Your Honor. Dan Garrett on behalf of Zach Brown. He's stepping forward.
Good evening, Your Honor. I'm Zach Brown.
All right.
Not quite evening yet, is it?
No, that's okay.
We're getting close.
He's young, so it might be.
There should be a green sheet in Your Honor's file. We're asking for an adjournment to consider an offer that was made today.
All right. 31st or 7th?
Your preference.
7th.
7th, please, Your Honor.
7th. Probable cause conference will be adjourned August 7th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
I'm sorry. Court does call the case of the People versus Virgil Dunlap.
Good afternoon, Your Honor. Victoria Burke here, prosecutor here on behalf of the people.
Good afternoon, Your Honor. Edward Drukas on behalf of Virgil Dunlap.
All right.
And Your Honor, can you state your name?
Virgil Dunlap. All right.
Your Honor, today's time and date set for our PCC. I did fill out a green form. I'm asking for a adjournment to further negotiate. I'm also in possession of a bond violation report.
Yes. What does your client have to say about that?
Regarding that, when it was received, we have been looking for inpatient programs. He is here with his nephew today. There are 2 programs where he's on a waiting list, the Home and New Vision in Oakdale. He is a bed away. That's the direction that we're going.
What?
That's the direction that we're going, is getting into some assistance for substance use, as noted in the report. He has also been taking care of some other ailments. He was at Trinity Health this morning. He's got some referrals. He's had a bunch of different things that he has medical wise that he needs to take care of.
But he tests positive for fentanyl, heroin, opiates, and amphetamines.
Okay.
And cocaine. Well, sir, yes, I do see it on the new one.
I don't have the report from yesterday.
What?
I don't have the report from yesterday, but I do know that there's been 3 tests that have been received.
Right.
And also get 5 over 10.
Does he admit to these violations, Lee?
He would admit to them today.
I'll accept that admission. I mean, and his next test is pending that he took on the 16th. I don't have any hope that it's going to show up any better. Grant your adjournment of the probable cause conference. I'll set that for my earliest next date, really effectively is July 31st, 2025 at 9 a.m. At this point, given the violation testing, and it doesn't appear to be getting any better. In fact, he's just adding drugs to his system. At this point, the court's going to revoke the defendant's bond. Defendant's going to be remanded to the Washington County Criminal pending further hearings. Because I will sign an order if it insists that may allow him to be released or at least screened for inpatient treatment.
Okay.
All right.
Thank you, Your Honor.
Need to go with my. Court calls case People versus Benjamin Hoffman.
Alexander, on behalf of the people, Your Honor.
Hold on 1 second, guys. I don't know who's back there. I'll scare them and get them up here. They should know, but. Okay. Did they go back to the hall maybe?
Alfred Brand on behalf of the defendant, Your Honor.
All right. I have a plea form in front of me that indicates that the defendant would be pleading. Well, hold on. All right. It actually goes up here on the form, but that's okay. He's actually pleading no contest to count 3, the domestic violence,
Correct.
Correct, Your Honor.
and also an added count for attempted interfering with an electronic communication device.
That is correct, Your Honor.
All right. That latter one being a 1-year offense, the other being a 93-day offense, stated count 3. On his successful no contest pleas to those charges, doesn't, okay, counts 1 and 2 would be dismissed. Okay. All right. There is also an agreement, a sentence agreement of sentencing under 4A or no objection for the domestic sentencing under prosecutors deferred on count 4.
Correct, Your Honor.
That is correct, Your Honor.
All right. That's the court's full understanding. All right.
And we did not check off the sentencing judge waiver. I believe he'll be sentenced before your.
It's my case.
Correct.
All right. All right. Very good. Sir, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. State your name for the record, please.
Your Honor, my name is Benjamin Hoffman.
All right. Sir, it is this court's understanding that you are going to be pleading guilt or pleading no contest to 2 charges. Is that your understanding?
Yes, sir.
First being that the charge stated count 3 of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that? Also, that you'll be pleading no contest to the charge of attempted interference with an electronic communication device. That being a misdemeanor punishable by up to 1 year incarceration and $500 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
I do.
All right. 2 things about it. I have to make sure that you understand it. First of all, it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The other thing that you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Basis of the no contest plea, counsel.
Civil liability, Your Honor.
All right. Sir, to the charge of domestic violence, how do you plead?
Contest.
To the charge of attempted interference with an electronic communication device, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. There's a copy on the podium underneath the paperwork there. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
The court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25-11370. Any objection to the court having reviewed that report?
No, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. So I do have to advise you that if you commit misconduct as defined by the Michigan court rules from this date to the date of your sentencing, that 2 things. First of all, that you would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
And the court would not be bound by any sentence agreement and or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's pleas Of no contest, 2 counts 3 and 4, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 4th at 1 p.m. with you.
being me. August 4th, 2025, 9 a.m. Or is that 1 p.m.?
1 p.m.
1 p.m.
And you're.
That's before me. Yes.
People that respond.
Uh-oh. Yes.
Your Honor, it's my understanding that Ms. Hoffman, the victim in this case, is here today to request contact. The court would like to hear from her.
I'll always hear from her, but go ahead. All right. Yeah. You'll have to step over that way.
Find a spot, Your Honor. Have Mr. Simon.
Yeah, make him move. Hello.
Hello, I'm Anna Hoffman, and I'm the victim in this case. Your Honor, I am here today to request that you lift the no contact order with the defendant. The main reason being that we have 3 children, and it's been very difficult to parent without communication with the defendant. There's also numerous household issues and maintenance problems that have come up that I need to be able to communicate with the defendant in order to resolve. And I need to be able to contact and have communication with him about our best course of action as a family going forward. Whether that be through reconciliation or separation, which I intend to continue for this time, we need to be able to have those conversations, especially for the sake of our children. So I'm asking, Your Honor, that you please lift the no contact order. I have no reason to believe that I am under any sort of risk of this happening again due to the facts and the circumstances of his conditions that I've learned since the incident. So I feel completely safe and comfortable with this option, and I'm asking you please to lift the no contact order.
Right.
Okay.
Thank you.
Thank you.
Did the people have a position?
Your Honor, we'll leave it in the discretion.
Anything you want to say regarding the request to lift it up?
Just a couple things, Your Honor. So in talking to my client, he's not intending to move back to the house. However, he does need to have contact with his wife because they have 3 minor children. The AC unit went out the other day. My client's an engineer. Him being able to get over to the house and help is helpful. So we'd ask for the no contact to be lifted, but his intention, so we're very clear, is not to move back in at this point. Separate and
All right.
separate and
But just so that I'm clear, he would intend to go to that location, but he's not intending to move back in and reside there.
Correct. That is correct.
Okay.
Yeah, we have one other matter separate and distinct from that. My client oversees 200 engineers. He is required occasionally to leave the
engineers.
Yeah, they're just.
You know how lawyers feel about engineers, and there's like 200 of them, like a whole herd. Go ahead.
I thought it was a gaggle, but
it might be the proper term.
So he has to leave the state of Michigan occasionally and the United States, but at least for this point, we're asking for him to, if he needs to leave the state for employment purposes, job purposes, he'll be afforded that opportunity. If in fact he has to leave the United States, we would file a petition with the court, put the court on notice, give the court written documentation for that. We don't have that today because we're not anticipating it within the next couple of weeks, but he may have to.
People have a position on that.
Your Honor, as long as documentation for when he's traveling is provided, we would be willing to do a stipend order for that travel when it comes up.
For the overseas travel, because I was going to allow him to travel in the United States for work.
We can do that, Your Honor.
Okay.
Thank you very much.
So if you prepare an order to that effect, that's fine. What I will do regarding the contact is I will delete.
Kept breaking up in there. I had to come in here.
Really? Yep. Yeah. All right. I will delete the no contact and the no go to. I will add to the bond conditions, no non-consensual contact with Anna Hoffman. You understand, sir, what that means?
Yes, sir.
All right, so if for whatever reason she does not want you in her presence or around her, then it is your obligation to leave. You understand that?
Yes, Your Honor.
All right. Okay, so that we're clear, I've taken the prohibition against going to the address, the prohibited address off completely, have not replaced it with anything. I replaced the contact provision or the no contact provision with a no non-consensual contact. All right.
Thank you very
And
much.
I am permitting him to travel in the United States for his employment purposes.
Thank you, Your Honor.
All right. Bond will continue on the west. All right.
Thank you, Your Honor.
Thank you. Court does call the case of People versus Ahmed Al-Jabori.
Others than people.
Counsel, you're muted.
Good afternoon, Your Honor, to you and your staff. Brian Berry, appearing on behalf of Ahmed Al-Jabori.
Sir, can you please state your name?
Ahmed Mohammed Al-Jabori, Your Honor.
Thank you. All right, what are we doing on this?
Judge, respectfully ask for an adjournment, waive his right to have a preliminary examination within 21 days, just so that I can seek additional discovery and also have an opportunity to speak to the prosecutor in this case.
All right. That objection, I will adjourn this matter to August 7th, 2025. I set it at 9 a.m., but likely your case will be called in the afternoon block.
Judge, one more request, if I may.
Go ahead.
Thank you, Judge. Client, before all this, before the charges were brought in this case, the client and his family had booked travel to the state of Florida, to Orlando. Wife, the husband, and 2 kids. I've received verification of the same, and respectfully ask the court if he can travel between those dates and if we can maybe.
What were the dates?
August the 2nd through the 15th.
Oh, that's miserable down there. He really does want to go? No, I'm kidding. Do the people have a position on that?
Your Honor, I believe that it is documentation provided showing that he does have return tickets for the 15th. I'm not object to a family vacation.
All right. So I will permit travel. Why don't you contact the prosecutor, submit to the court a stipulated order regarding that, and I will sign that.
Thank you, Your Honor.
All right.
So the August 7th date, can we have a different date, Judge?
Pardon?
The August 7th would fall within that travel time.
You said one more thing, and now this is 2.
I
Okay,
thought
never
that-
mind. I can, so basically the first half of August, he's traveling for our purposes. I don't have the 20, I have what, the 19th is mine,
August 14th.
but he's gone to the 15th.
Oh, sorry.
No, it's okay, pay attention. So what's my next date? Thank you, that's what I said. Jeez. Thank you, Anna. August 19th.
Thank you, Your Honor.
All right, thank you. Anything else, counsel?
No more one more things.
All right. Thank you. Have a great day.
You as well.
Thank you, Your Honor.
Court does, you're welcome. Court does call the case, People versus Demetrius Caldwell.
Actually, Nik for the people.
And good afternoon, Your Honor. I know you were just waiting for me to get off Judge Slay's Zoom. Perfect timing. Sydney Rushing appearing on behalf of Mr. Caldwell. Mr. Caldwell, can you unmute your mic, start your camera, and state your name for the record?
Demetrius Caldwell.
Thank you.
Rushing, do you really think you're that important?
Your Honor, I definitely
No,
do.
never mind. Don't want an answer. Go.
Judge, I definitely do not. I just know that you are great at calling cases on the perfect time. That's all I was saying. Your
I
Honor,
appreciate that. Thank you.
yes. So, Your Honor, we are here today for a PCC. Mr. Caldwell has not been able to have his interview as of yet. He was scheduled for an interview back on May 29th. And when I did send the documents, I tried to send the documents to his guardian who is on Zoom with us today. The email, for whatever reason, did bounce back to me. I am asking Your Honor to refer him one more time for this interview to get completed. I don't think we should have another issue going forward.
And Your Honor, of course, we do want to get Mr. Caldwell evaluated so the case can continue. But based on the letter that, as I recall, from the Center for Forensic Psychiatry, I don't know if they're going to do it again without him being in custody at this point, because it's that I may be misremembering. So whatever we can do to accomplish that is fine. I just don't know if we're.
What letter are you referring to that indicated that?
Your Honor, if I may.
Yes.
Part of that letter, so I have a few other cases in another county that also had this same issue. They've added a part in all of their letters. It is being sent to anybody who missed a hearing, basically saying that due to the voluminous amount of people who have missed hearings before, they are not they are not rescheduling those unless they have a re-referral from the court. Is essentially what that came down to. But it wasn't just they didn't put that in there specifically just to Mr. Caldwell. It's something that they're putting into every paper or every letter that a person has missed that hearing.
Right. I get that part.
Oh, I misunderstood it, Your Honor. I thought it said something different than it did. It's my mistake.
Yeah, I don't think it was requiring me. It just needs a new referral. They're not gonna hold on to the other referral. So what I will do is we'll just start this over. I will then, you'll submit an order to the court for forensic evaluation. I'll sign off on that order. I'll set a competency hearing in this matter for October 16th, 2025, 9 a.m.
Got it. I'll get that right over, Your Honor. Thank you so much.
All right, bond will continue. Thank you. That's called the case People versus Adrian German.
Maybe there were two people.
And good afternoon, Your Honor. Hassan Bezi on behalf of Mr. German, who is present. Mr. Can you unmute your phone and state your name, please? You got to unmute it.
Can you hear me now, Your Honor?
Yes, state your name, please.
Yes, we can hear you. State your name.
Good afternoon. My name is Adrian German.
All right. All right, what are we doing on this case?
Judge, I had a chance to talk to Mr. yesterday, and we are asking for an adjournment in this case, and we also filed a motion this morning. I sent it to your clerk with regards to permission to travel.
Have you reviewed that, Ms. McDonough?
I have, Your Honor. No objection.
All right. You have an order in here, and I will sign off on the order permitting travel.
Thank you, Your Honor. And with regards to discovery, I did also submit it. I'm sorry, I forgot to submit it to the email address for discovery, but I did have a chance to go over with Ms. McGuffey yesterday. We need some time anyways, because there's a strong possibility of a resolution in this case.
August 7th, 2025, 9 a.m.
Would that be enough time, Ms. McDuffie, to get some information?
I believe so. We should be good.
All right, bond will continue.
You said August 7th, Your Honor?
Yes, sir.
Thank you.
Thank you.
Have a good day, your staff. Thank you.
And can you have Ann crack that order for my signature? Court does call the case of the People versus Torrance Oaks.
Ready, Your Honor. Your Honor, Joe Simon, on behalf of Ms. Oaks. She's making her way forward.
Just state your name.
Torrance Oaks.
Thank you. You're requesting an adjournment.
Yes, Your Honor. I reached out to Ms. Douglas. She's going to make some inquiries.
I'm going to defer to her to how much time she thinks she needs.
Your Honor, a couple weeks, but
All right, well, I'll go. I think I put the number of yours on the 7th, Mr. Chairman.
You're correct.
So I'll adjourn it out to August 7th, 2025, 9 a.m. Bond will continue.
Thank you.
Thank you.
Yeah. Thank you.
And it's not like I'm keeping up with your schedule. I just have to.
You just have a great
I have
memory.
big red flags on my calendar when you're going to be here.
Is there going to be an interpreter there?
You know what? That kept me up all night. Court calls the case People versus Lawrence Peck.
Good afternoon, Your Honor. Victoria Burton here, Chief Assistant Prosecutor appearing on behalf of the people.
And Your Honor, Joe Simon on behalf of Mr. Peck. Larry, state your name. Lawrence Peck.
All right. And you're again requesting an adjournment.
Yes, but this one, Your Honor, I spoke to Ms. Burton Harris. She'll confirm. There's another matter that is pending investigation that's reliant on a blood test being returned. So we're asking for a longer, before we talk about resolving all the matters, we're asking that the court give a longer period of time to adjourn this PCC.
All right.
Read your eyes and see that you're looking at me for confirmation. That
Yeah.
is correct.
Because I don't believe him. Yeah.
That is correct. I can confirm, Your Honor, we had that discussion, and in order to wait for that blood to return, which it'll take a number of weeks, we agreed that we would actually do a longer adjournment.
Would the 19th be enough time, or you need something at the beginning of September?
Probably the latter.
Probably early September, just to be safe.
What do you have?
September 18th.
18th? That's like way in September.
would you like it earlier in September?
I'll just pick my own date. September 11th.
Fair enough.
Why is that so hard over there? You guys,
There's only two of us, Your Honor.
two of us, one date. We can't figure that out. All right. Thank you. Bond will continue.
Thank you. We'll write you a confirm. Okay.
Court just called the case People versus Deshaun Tompkins.
That's a lot of good people.
And Your Honor, Joe Simon on behalf of Mr. Tompkins. And Mr. Tompkins, state your name right here.
Deshaun Tompkins. Thank you.
Your Honor, asking the matter be set for a preliminary examination.
Discovery complete.
Yes.
People have their witnesses available the 29th.
Could we go one?
No.
more, please?
That I'm
You
available.
can't.
I'm available on the 29th or August 12th, either one of those. The one in between, I'm not.
I never pick my date.
I know, but you're trying to.
I'm trying to not pick a date.
Same as me, I guess. That would be true.
If we could, Your Honor, if you don't mind, I would just like.
The August 12th day?
Yes, please. Thank you, Your Honor.
That objection, preliminary examination in person, August 12th, 2025, 9 a.m. That is before Judge Freshour.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
You are good to go. One thing real quick. Thank you, Your Honor.
Bond will continue. Court does call the case of the People versus Charles Boyce.
Christina Victory for the people.
And good afternoon, Your Honor. Gregory Sheen on behalf of Mr. Boyce, who's present via Zoom and consents to being on the Zoom call today.
Sir, can you state your name?
Yes, Your Honor. My name is Charles Boyce.
All right. And what are we doing?
Your Honor, at this current time, we're going to request an adjournment. Mr. Boyce has been offered a second OWI. He is going to take advantage of that. He has been assessed. He's just set up for a screening. If we can do that August 19th, that would be wonderful. I think everything will be completed by that date.
Did he pick a date? He did. People have any objection with the 19th?
No objection for the date. I just want to clarify for the record that the offer is it OWI second with treatment court?
That's correct. So
Okay,
I'm
and so
sorry.
the assessments you're looking at getting are for the purposes of getting into a treatment.
Exactly. I apologize.
That's
All right. Okay, probable cause conference will be adjourned August 19th, 2025, 9 a.m.
Thank you, Your Honor. Have a wonderful day.
All right, bond continued. Thank you. Court calls case People versus Ronald Lucky.
Okay, Rachel McDuffie for the people.
Good afternoon, Your Honor. Robert Ellman, with and on behalf of Mr. Lucky. Your Honor, Mr. Lucky, you approach.
Long time no see.
It's good to see you.
Good seeing you. All right.
Mr. Lucky, can you please state your name for the record?
I'm James Lucky.
And Your Honor, just because it's been so long since I've seen you, may we approach briefly?
With McDuffie?
Of course.
And you? No.
Pretty please.
Come
You should
on.
approach in chambers.
Oh, we could. Thank you for the bench conference, Your Honor.
All right. Guess there are two issues. I guess one is defendant is prohibited from going to the address that he has a no-go to, except with a civil standby.
Correct.
My understanding, he's been there a number of times, can be problematic.
Always with the
But
police.
sir,
Hold on.
sir,
Sorry.
Let him talk first, okay?
but my understanding, and correct me if I'm wrong, Mr. Ellman, that you pointed out to the court is that each time that he went there, he contacted the police, effectively instituting the civil standby.
Correct, Your Honor.
And that the number of times isn't because he's trying to go there to do anything, to do anything bad. It's just that he's trying to get his property and they can't get into the unit.
That's correct, Your Honor. He's
Okay. Well, they won't let him.
The homeowner won't let him in.
Homeowner is saying no.
Correct.
Okay. So he's in regard to what the defendant is doing, who's the subject of the bond, he's doing exactly what we would request that people do. He's calling the police, he's doing the civil standby. It's not working out because of it.
Can I say something?
If you want to.
Justin does not own the property.
Okay.
The
So
owner of the
sir,
property.
Sir, I don't know that and I can't resolve that today. And I couldn't resolve it in any event.
The owner of the property's been there.
Can you just listen to what I'm saying without interrupting?
Yes, sir.
Because that usually turns out bad for people. What I'm trying to point out and what your attorney was stressing to me and wanted to make sure that the court understood is that you had done exactly what the court would request that you do, so that if there was any request that you were going there trying to do something bad, that in fact, so you should thank your attorney for that. Okay? And sometimes if you're ahead, it's just better to just not say anything. All right. Next issue, Mr. Allen.
Well, and I guess, Your Honor, I apologize, maybe I'm asking for clarity. Are there, and I don't know, presuming that we'll call him the tenant of the home for sake of argument, refuses to further let Mr. Lucky into the property to reclaim his belongings. I'm assuming there, just for clarity, there is no order the court at this point could put on the tenant to force him to allow Mr. Lucky to retrieve his belongings.
I really can't do that. It may be fortunate if it's a tenancy type of situation instead of an ownership. It may be best to contact the owner to have them meet you there and have the owner give, if that's indeed the circumstance, because I don't know, have the owner give permission to go in and then see what the police would say to that.
Oh, thank you, Your Honor. I appreciate the clarity.
All right.
Been there 3 times with the police.
I understand.
All right.
Your Honor, and my second issue, Mr. Lucky and I have discussed this matter. Unfortunately, I do believe that we are at an impasse where there is a breakdown of the attorney relationship. Given our conversations and potential strategy plans, I'd be asking to withdraw at this point.
Mr. Lucky, What's your position on that?
I just asked him to let the courts know that the owner was there 3 or 4 times with the police giving consent.
You know what?
That's all I asked
The
for.
problem is we're not there. Okay? If there's an accusation that you've been at this, you don't seem to quite get this. There's an accusation that you were at the premises a number of times, maybe without a civil standby. Your attorney came.
Don't cut the judge off.
Your attorney came prepared to tell the court that you had done exactly what you were supposed to do. And he did that. All right? I can't solve all the problems regarding the civil standby. The next question was asked. I, again, don't know if the owner's there. So that's all that I can say to them. All right. And Mr. Elman, you think that the relationship between you and the defendant have broken down to the extent that you can no longer effectively represent him?
Unfortunately, Your Honor, I do.
Okay.
And I apologize. I don't take
You
this like.
and yes, I know that, sir. You don't do that, but what I will do is I won't grant your motion at this time. I think because you were appointed on the case, you're going to need to get to the MAC office for the preparation of at least some order. I will grant your request, but I need the order so that you can do that, so that this matter is not hasn't been delayed all that much in any event. But
And I guess, Your Honor,
yes,
forgive me if I understand this process wrong. I'm just trying to think of expediency for Mr. Lucky's sake. I know he wishes this case to move forward as quickly as possible,
which you've also expressed to the court, and I know that you're trying, Mr. Elman.
and so if I were to go to the MAC office and let them know, if they were to just send you an order for my withdrawal, would there be a need for me to file a motion?
They'd actually send the motion with the order with the new attorney.
And so you're indicating if we did it that way, there'd be no need for a motion hearing, or?
There'd be no need for that.
Okay, thank you.
Okay. But then I'd have to make sure that the attorney would have time to catch up. So what I'll do, you do that. I'll adjourn the probable cause to my next practical availability, which will be the 31st of July. You'll have a new attorney. Hopefully they'll be ready to go or to do something, and we'll have had contact with you. And that gives enough time. So July 31st, 2025, 9 a.m. or as it indicates, I'm sorry. And bond will continue. So if you get that order, if I get that motion in order to me, I'll sign off. And then there'll be a new attorney on the 31st.
I'll stop in their office right now, Your Honor.
All right.
Thank you for your understanding. Good luck to you, Mr. Lucky.
Court calls the case, People versus Lauren Michaels.
Hey, Pierre, Tamika, for the people.
I hate it, counsel, articulate enough to get the point across to me. Or I'm just dense and I can't understand.
Tried very hard there. I'm sorry.
It's okay. All right.
Mr. Elman said that I was nice to him. I just want to put that on the record.
That is correct.
All right. Sorry, Mr. Savage, if you could put your appearance
That's
on.
all right. I was gonna ask Joe Simon to give me a hand with this case, but he left. I'm kidding. That being said, may it please the court, my name is Matt Savage and I represent Lauren Michaels. Judge, may I represent her this afternoon with her being in absentia? She is still in a residential facility for her mental health treatment. She's now back in a facility called Rose Hill.
Yeah, I will. I'm very well aware of the circumstances. Counsel has kept my chambers apprised, and so unless there's an objection from the people, we'll proceed with the defendant in absentia.
Objection.
All right. All right. So what do we want to do on this case?
Your Honor, Miss Michaels was doing well. She was in St. Joe's Hospital for a while being treated. Then she went to Rose Hill, and then there was a setback there. And she was placed in a facility called Samaritan Behavioral Center. and now she is back in Rose Hill as of yesterday. At least that's what I was informed from her guardian. I'm hoping sooner than later we'll be able to get her here and resolve this case. At this point, what I'd like to do, and Ms. McDuffie, correct me if I'm wrong, I believe I've provided an independent evaluation. I'm hoping to get soon an opinion and evaluation from her treating psychiatrist. As soon as I have that, I want to share that with Ms. McDuffie and an actual written request for a deviation on this case. Hopefully, I'm hoping maybe mental health treatment court with whatever reductions are necessary to get us there, and maybe a Home Control Training Act assignment. But that all being said, that's my hopes. It's been a long 3 months, unfortunately, with Ms. Michaels. Sometimes she's very lucid, and sometimes she's not. But the medication that she was on last she was doing well, and then I'm not sure what happened. I tried to get information earlier today about that, and I was unable to. That's my hope. So I'm asking the court for hopefully one last adjournment on this case. Maybe I won't give you a date. But maybe late August, early September of 2029.
Very, that I could do.
Yeah.
Is it September 4th? September 4th.
Yes.
All right. Why don't I adjourn this out to September 4th,
Okay.
2025 at 9.
That sounds good, Judge. Just one minor potential issue with that. I'm supposed to start a jury trial on the 3rd in Macomb County. I'm hoping that case doesn't go. But if it's gonna go, I'll anticipate that earlier that week, and I'll reach out to staff and maybe we can move this court date.
Okay. And I mean, this case is plagued with certain difficulties.
Yes.
So I will, if that becomes a problem, if the date becomes a problem, I don't see any harm if we're moving it a little bit further out. So if the parties could send in a step to adjourn if that becomes an issue, Mr. Savage.
Perfect. Thank you, Your Honor.
All right.
Ms. McDuffie,
Bond
I'll be
will
in touch with
continue.
you soon. Thank you.
Sounds good.
All right. Thank you. Court does call the case of the people versus Michelle.
I'm coming, buddy.
Lovas.
I'm coming, buddy.
Is that a dog or a child?
Secretary of Administration, Your Honor. John Shea, Your Honor, with and on behalf of Ms. Lovas.
Lovas.
Your Honor, we are still awaiting. We're still awaiting discovery in the form of supplemental medical records, and so we're requesting a 4-week adjournment to continue our search for those.
All right. Would the 19th work for you of August?
Yes.
That's a Tuesday.
I think it will.
All right.
So that's 5 weeks then, right?
Yes. Well,
I'm sorry, did you say?
I said August 19th.
My calendar isn't. I see that as a Tuesday.
It is.
Very good.
Okay.
I was anticipating a Thursday.
Yes, and it's that week. I'm actually going to try to do a vacation, so it'll be a double up docket.
Wonderful.
So August 19th, and that's it. That's in the morning, so that's a 9 a.m. call, and bond will continue.
And Ms. Lovaz has appropriately corrected my misspelling or my mispronunciation of her name.
How is it pronounced now?
Are you? No, you can talk.
Go ahead.
Lovaz.
Lovaz.
Thank you.
Okay. I will remember that for exactly the next hour. And I probably will mess it up next time I call it. I'm just going to let you know. Okay. Thank you, ma'am.
Thank you.
Wait. Court does call the case of the people versus Francis McMullen.
John Shea, Your Honor, with and on behalf of Ms. McMullen.
Good afternoon, Your Honor. Victoria Burton Harris, Chief Assistant Prosecutor here on behalf of.
Your Honor, may Ms. Burton Harris and I approach?
Oh, boy. Yes, you may.
Thank you.
This could be an issue.
Thank you, Your Honor, for,
All right.
I understand you're passing this matter for the.
Yes, I'm passing. Yes. No, she took that. She took it. She did it. Oh. Court does call the case People versus Danielle Noonan.
Ashley Lonnie for the people.
David I. Goldstein appearing on behalf of the defendant. You're muted, Danielle. You have to unmute.
And then there.
Sorry about that, Danielle Noonan.
All right, there we go. Okay, what are we doing on this case?
Your Honor, Ms. Londi and I have been discussing the matter. We're asking an opportunity to have my client screened for the FTC. We think she would be a good candidate for that. So we're asking for an adjournment, maybe 2-3 weeks, 3 weeks.
All right, very good. I'll adjourn the probable cause conference to August 7th.
Your Honor, can we have the 14th? I'm not going to be here on the 7th.
August 14th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you, ma'am. Both case People versus Alexander Sanchez Garcia.
Chief Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Nicholas Monterez on behalf of Mr. Alexander Sanchez Garcia, present standing to my right. Mr. Sanchez Garcia, please state your full name for the record.
Alexander Sanchez Garcia.
Very good. You're requesting an adjournment?
I am, Your Honor.
I'll adjourn the matter to August 7th, 2025.
Your Honor, I know that you just picked a date, but prior to solidifying that date, would it be okay if Mr. Kennedy and I approach briefly? I know, I'm sorry.
I'll talk to you. It's Kennedy. Come on. Record to reflect, there's been a bench conference in this case. I will, instead of the 7th, I'll adjourn it out to the 19th of August.
Understood. Thank you, Your Honor.
All right. Thank you.
Have a nice day.
Bond continues.
Thank you, Your Honor.
Court does call the case People versus Cyrus Abadi.
Chief Kennedy for the people, Your Honor.
Good afternoon, Your Honor. Uwe Daus. I'm with and on behalf of Mr. Abadi. Cyrus taking in for the court, please.
Good afternoon, Your Honor. Cyrus Abadi here.
Thank you.
I'm looking to set this for preliminary examination, please.
All right. All discovery is complete.
Yes, it is.
People have their witnesses available on the 29th.
You are, Mr.
And we will as well.
Preliminary examination will be set for July 29th, 2025, 9 a.m. That is before Judge
Barr.
Judge Barr.
Very good.
All right. Thank you.
Thank you.
Good to,
Thank you, Your Honor.
thank you. Bond will continue. Okay. They're filling out a form. They're gonna do a police report. We don't have an answer yet. We're waiting on a return phone call. I'm gonna take a break, see if we can get it soon. If we can get it soon, then I'll take the play. All right?
All rise. Proceed to court back in session. The Honorable Judge Simpsons presiding.
You may be seated. Court does call the case of the People versus Francis McMullen.
Harris, Chief Assistant Prosecutor, and appearing on behalf of the people in this matter.
John Shea, Your Honor, appearing with and on behalf of Ms. McMullen.
Your name, ma'am?
Francis McMullen.
Thank you. And I have been handed a plea form that indicates that the defendant will be pleading no contest to the charge of public officer purchase goods for a private purpose, misdemeanor punishable by up to 90 days. Upon her successful no contest plea to that charge, counts 1 through 4 will be dismissed. I would also note on this, while the file is marked as a 14A2 file. And as a 14A judge, I could just keep it, but with respect to Judge Barr, counsel let me know that there might be an issue. For purposes of the record, my office did contact Judge Barr's chambers. Judge Barr indicated that had this case, or if this case came to him, he would have likely disqualified from hearing the sentencing, so it would have come back to me in any event. So with that, I will keep it for purposes.
Thank you, Your Honor. And I anticipated Judge Barr probably would have said that.
Pardon?
We anticipated Judge Barr probably would have said that, but I appreciate the court streamlining it.
Yes, and just in review of the report, Judge Barr's father, in his official capacity with the city of Ypsi, is prevalent.
Absolutely.
So I think it absolutely appropriate. All right. Having said all of that, may I have her sworn, please?
You raise your right hand. You solemnly swear or affirm the testimony you're about to give whole truth and nothing but the truth, so you got it.
I do.
Lower your hand and state and spell your name, okay?
Frances, Frances, McMullen, McMullan.
All right. Ma'am, it is this court's understanding that you are going to be pleading no contest to the charge of public officer purchase of goods for private purposes. That is a misdemeanor punishable by up to 90 days jail, $500 fine plus court costs. Do you understand that?
Yes. Yes.
Yes? All right. Do you understand what a no contest plea is?
Yes.
All right. Two things about it I have to make sure that you understand. It first of all means that you're not further desirous or wishing to contest this charge. You understand that?
Yes.
The other thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. Basis for the no contest plea, Mr. Shea.
Potential for civil liability.
All right. And ma'am, to that charge, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
All right. You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights that are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yes.
And because you believe that you are, well, I won't ask that part because that's not part of it. The court has been provided and has reviewed Michigan Department of State Police report for their case 548-23. Any objection to the court having reviewed that report?
No, Judge.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of this plea, if I accept your plea, and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, number one, you would not be permitted to withdraw your plea. And number two, any recommendation or evaluation regarding sentencing, the court would no longer be bound by. You understand that?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Judge, thank you.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Satisfied, Judge.
Yes, Judge.
All right. Court will accept the defendant's plea of no contest to count 5. Counts 1 through 4 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
August 13th at 9 a.m. with you.
all right. Will that work for you?
My calendar just screwed up, Judge, if I could, just a second. August 13th. It works for me. It's a Wednesday.
Yes, it is.
Is that okay?
August 13th, 2025.
9 a.m.
I said it at 9 a.m., but you'll get an assigned time block, and that will be before me.
Oh, this is another one of those floating time dockets.
Yes.
That is, okay, gotcha. All right,
All
so.
of mine are.
Yeah, are they all really though?
Yeah.
Okay.
Yep.
All right, very good. We will await the final notice about a week before from
Yes.
Ms. Ann.
Yes. All right, and bond will continue.
Thank you very much.
Thank you.
Thank you.
Thank you, Ms. Harris. Ms. Burton Harris.
Thank you.
Is Laura still here, Joe?
I'm not here today.
Okay. Should we contact probation?
Is Elon's not here?
I just believe it's Ryan.
Okay, we'll check. Thank you.
14A.
I'm a regular over at the Trial Watch Clips channel, where you go for clips of your favorite judges and your favorite attorneys and your favorite trials and your favorite cases.